for adjournments. Page number 8, seal number 27 to 30.
Madam, seal number 28 minutes. In that matter, I appear for respondent. Madam, in this matter, last occasion, your lordship has suggested me to get the feasibility, whether shifting of the tower is feasible or not. Then we are seeking the instructions from the corporate office itself, madam, with the technical experts report, whether it is feasible, because in order to shift the tower, they have to install a separate temporary tower, madam, in order to keep the electricity flowing to the north of Bangalore. Madam. Otherwise, it will take 2 months. If we shift the tower, entire north of Bangalore will lose the power.
Just give them the estimate first, so then they'll know.
No, madam, that estimation, that estimation will be providing, madam, because whether any additional towers to be installed. Total estimation will give, madam. 10 days time could use. 10 days could use.
Our estimate code the ಒಪ್ಕೋಬೇಕು ತಾನೆ. Our estimate ನನ್ನ ಪ್ರಕಾರ ಕೊಡೋದು ನೀವು ಒಪ್ಕೊಳ್ಳೋಕೆ ಆಗಲ್ಲ.
10 days, madam.
11th.
My lord, serial number 27, my lord. In connected matter, I am appearing for the petition. My lord, Spurti advocate today he has a doctor appointment, my lord. Doctor appointment to today. Kindly have it next week. Serial number 27.
Who wants Spurti?
Oh, Spurti.
Fifth.
Please.
Page number 9, seal number 31 to 34.
31, my lord. In that second petition, I'm told died. We'll take steps in that.
His report, the second petitioner is no more.
Second
Steps if any,
please.
in 2 weeks.
34, my lord.
I appear for the respondents in 34, your lordship.
Convenience. 11th July is what he is requesting. If your lordship supports.
His requested petition is dismissed as written.
32. Page number 10, seal number 35 and 36.
My lord, serial number 35, my lords. I'm for the petitioner, my lord. Your lordship may kindly have it next week, my lord.
You've been taking time repeatedly.
No, my lord, some instructions has to be sought in this next week. Okay.
Page number 11, seal number 37 to 42. Page number 12, seal number 43 to 48. Page number
56. Pertaining to the area state, attributed on 5th. Harish Kumar.
Page number 13, seal number 49 to 51. Page number 14, seal number 52 to 57.
53 minutes.
Well. Page number 15, seal number 58 to 61. Page number 16, seal number 62 to 66. Page number 17, seal number 67. Page number 18, seal number 68 to 70. Page number 19, seal number 71, 73. Page number 20, seal number 74 to 79. List number 2, non-compliance of office objection, first time matter, seal number 1. 2 weeks.
I appear on the petitioner. I'll comply with this by the end of this week. By the end of this day.
Granted you 2 weeks time.
2 weeks. Second time matter, seal number 2.
2 weeks, failing which is then dismissed.
Third time matter, seal number 3 to 5.
1 week, finally failing which.
Serial number 3. Fine for petition.
1 week.
2 weeks time because of have to find order.
Which one?
Serial number 3.
You've already taken 3 times.
My lord, we have to apply for certificate copy for audition.
Whatever you want to do it within a week or else it will be dismissed.
Fourth time matter, seal number 6 and 7.
Quite kind of 4 opportunities.
Sixth time matter, seal number 8, Sri Ranjit.
You spent kind of 16.
List number 1, fresh matters, seal number 1, Sri Mohammad Dastagir.
For the petitioners in this case. Simple matter of issue of permit for arbitration of matter. The applications are kept pending indefinitely for years to get.
This one. Madam,
Page number 49. Page number 49. Last paragraph. They say in first paragraph, illegal resolution bearing serial number 52.
పేజ్ నెంబర్ 49. నిరుద్యోగి మహిళా ఆటో రిక్షా రహదారి మంజూరాతి అదా?
Yes. It's not an illegal resolution, my lord.
They make a
You have to
submission.
give the clarification.
You can't find out whether they're unemployed or not?
They have to give the clarification, my lord.
Who has to give?
ಅರ್ಜಿ ಹಾಕೊಂಡಿರೋರು applicants.
No, you're saying that you don't know to find out whether they're unemployed or not? Madam, you can't find out that simple task?
Prayer B is accordance with law.
Prayer-
Prayer
Ah.
prayer B is accordance with law. Page number 24, annexure D1.
They are saying that they are unemployed females and they want a auto rickshaw permit. For that, what is your answer?
ಅದು illegal ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಏನ್ illegal ಅಂತ?
Prayer ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Illegal resolution ಬೇರೆ ನಂಬರ್ 52 ಅಂತ ಅದೇನ್ illegal ಅಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ.
ಅವ್ರದ್ದು ಪ್ರೇಯರ್ ಬಿಟ್ಬಿಟ್ಟು ನೀವು ಉತ್ತರ ಹೇಳಿದಕ್ಕೆ ಈ ರೆಸಲ್ಯೂಷನ್ ಅರ್ಥ ಏನು?
Accordance with law.
You'll pass the same order. According to you, you don't have the guidelines for finding out whether they're unemployed or not. Therefore, you will not consider the application.
It may be considered.
Consider, but I need a specific stand by you.
One statement.
Relist on so and so. The state shall make a categorical statement as to why it cannot ascertain as to whether the petitioners are unemployed or not. Relist on.
My lord, may I make one submission? In the very same resolution, 577 permits are already issued.
No, these ladies, they themselves want to drive the auto rickshaw, or is it to be?
They will not, my lord, because they have been exempted from obtaining driving license in the notification itself. Actually, the notification of annexure A says that they should be holding a driving license also. But in respect of unemployed women, that condition has been relaxed in 19 and other notification issued for annexure B, my lord. So they need not.
You will use the permit to hire somebody to drive.
Yes. Yes,
You will not be driving.
yes, my lord, that is permissible. In respect of only unemployed women.
5th July. Seal number 2,
July.
Shri M. Prakash, party in person.
Obliged.
You served a copy on BESCOM? You served. Take out notice on Padma Sutur. Sorry, madam.
Yes.
I'll have it on Monday.
Yes, ma'am.
We list ship Padma Sutur to take notice for respondents. BESCOM umbrella party.
Yes, sir.
Seal number 3, Shri Ramchandra Reddy.
Monday.
Much.
What is the next area?
Then an excess of jurisdiction by the excise commissioner. Partnership firm called Sandesh Enterprises. It's been running business since 2000. It has 2 licenses, CL2 and CL9. CL9 is for bar and restaurant and CL2 is for a wine store. Both of these establishments are run by the partnership firm as Sandesh Enterprises. Since 2000, licenses have been renewed every year. Or the license license is valid for a year, from July to June. It was renewed every year until 15. For the year 13-14, an application for renewal and the usual course was made. At that point in time, there was some disturbance amongst the partners. And one of the partners requested that the license be issued in her name separately. It is beyond the remit of the excise commission. It's a matter which a civil court would decide and dispute between partners. What the excise commissioner does, passes an order sitting as an arbitrator or a civil judge, dividing the licenses as CL9 license to one of the partners and CL2 license to another partner. And he refers to a pending civil
No,
dispute.
but you're challenging that order now after 10 years?
No, it was challenged before, when the alternate remedies were invoked, we challenged, my lord, the very right in posing the question to me. Before the appellate authority, the excise commissioner, that order came in very recently last month.
Where is that appellate authority's order? Because you're only challenging annexary in your prayer. There's no other prayer here. Without there being a challenge to the appellate authority's order. What is the point in just challenging the original order?
50 and 65.
53?
No, not 53, page 53 on.
Now kindly come to your prayer. What is the order that you're challenging?
The order is the original authority's order.
You don't have to challenge the appellate authority's order.
It was dismissed.
You don't have to challenge that order also.
No, we have come to court on the ground that the alternate remedies has taken 10 years to set aside what apparently, in our respectful submission, were not patently illegal order. And obviously, the adequate efficacious remedy staring at our face is completely inadequate. And the excise license is due for renewal by the end of the month.
Amend the prayer. I think you need to challenge the order of the appellate authority also. You can't.
And have it Monday.
Monday, CGP to take notice for respondents. Have you made the other partners as
No, that
parties?
doesn't arise. Because in a partnership, I can't sue my own partner.
No, but the original order benefited somebody. That order is confirmed. If you don't make them as a party, any order that I pass, if it affects their rights, don't you think they should be heard in the matter?
We're not looking at the firm as two separate entities. I quite see the point.
I think you should implicate them.
We will argue on that point on Monday, my lord. We'll see whatever view my lord takes.
Realist.
For preliminary hearing, seal number 4, Shri Nagendra Kumar K.
Number 3, Bescom.
The fourth respondent of builder, is the landlord who gave the property for construction of the apartment to the JDA. And as per the JDA, 45% I am entitled and 55% of the construction of the building he is entitled. Even before completion of the building, he sold his portion along with my portion also he sold to some other purchaser. Wherein, my lord, two properties, flats, I have gifted to my sister, including that property and other two properties, he sold to some other purchaser. Now, the possession of the building is not, occupancy right has not been given so far. And possession also not given to the purchaser. Now, before that, my lord, once the Bescom permanent power connection is granted, my lord, given, all other people, they will occupy the demand.
You're basically converting the writ petition into a civil dispute, isn't it? You're asking Bescom to get involved in the civil dispute.
We have given letter to the Bescom not to give because the.
Go to the civil court and adjudicate your rights regarding the JDA. How can you ask them to get in?
The two flats I have already taken in, but already two flats which he has told that it belongs to the petitioner.
Ask for a relief in the civil court. How can I entertain a writ petition? Can I decide this issue as to whether the JDA was breached or not?
Fraudulently sold before.
Agata, writ petition ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಂದ್ರೆ I'll entertain. I don't think I'll be able to entertain. Which is a suit that you have filed? Which is a suit that you have filed? Suit.
For permanent injunction. Restraining it to not to alienate the other two flats.
I'll permit you to seek for whatever relief you want against Bescom there. Bescom is a party there?
No, I'm not with it.
The prayer in this writ petition is for issuance of a mandamus. Direct the third respondent not to sanction permanent power connection to the property of the petitioner on which an apartment complex has been erected on the basis of a joint development agreement. It is the contention of the petitioner that the developer, that is the third respondent, fourth respondent, has committed a breach of the terms of the JDA and has sold the properties which do not fall within his share. It is therefore contended that the BESCOM should be restrained from sanctioning permanent power connection to the entire complex. In my view, such a player cannot be considered in a writ petition. If there's a dispute between the fourth respondent, the developer and the owner, that is a petitioner, regarding the terms of a JDA, the appropriate remedy for them would be to approach the civil court for an adjudication of the rights under the terms of the agreement. Not counsel, the petitioner also admits that the petitioner has indeed approached the civil court with a suit for injunction against the developer. So if that be so, it will be open for the petitioner to seek for appropriate interim relief, they said suit. Subject to the above, the writ petition is dismissed.
Seal number 5, Shemi Nagesh.
I am having a service from Malur to Hosur. The KSRTC is Malur.
Yes, madam.
The KSRTC, our permit, they are not adhering to the timings. Bandari is here. Consider my recommendations, whether they are adhering.
To responded to take notice for R4. HCG will take notice for R1 to R3. Notice the paper.
It's only consider, I have given recommendation to.
Now, note paper note then our give them the set of papers, I have it on Monday.
First time.
List.
Seal number 6.
It is like.
Yes. Yes, it is.
Lock ಹಾಕಿದ್ದಾರೆ, ಯಾಕ್ ಹಾಕಿದ್ದಾರೆ?
Not personally my notice. It was done in the month of January. Now I am, after that I am taking request against the tenant. All that my request is that now the tenant is least bothered about the premise. And this part will take further action, either for cancellation or for declaring a problem with you. The premises will remain state and in between I am separate. That is my
Lord,
request.
I am the tenant, my lord, they have not made me a party. I'll file necessary application to implead myself.
I will.
My lord, there is a dispute between the landowner and the tenant.
I will make them a party.
Not consider application 6 for permission to implead the tenant who is in occupation of the
Premises.
premises. Relist.
Fifth.
Seal number 7, Shri S.K. Acharya.
I'm appearing for the respondent. Lord, the original owner, my lords, may kindly see the annexure B, my lord. He has surrendered the RR numbers, my lord. 11 RR numbers he has surrendered.
Annexure?
Annexure B, my lord. The property belonging to the one Narayan T. Amin, my lord, he has surrendered 11 RR number, my lord. Based on that, we have disconnected the power.
Our ಹೆಸರು ಮಾಡ್ಕೊಡಿ ಅಷ್ಟೇ.
Yes,
It's in possession, isn't it?
he is in a position, my lord. It is, he has filed the suit before the concerned court, my lord.
For what?
Until the disposal of the suit, subject to result of the suit, power may be restored and
For what has he filed the suit?
not to vacate and
Injunction.
injunction. TI, my lord.
ದಾವ ಹಾಕಿದೆ.
47, my lord.
Also displayed. 46. As per my lord, the forcible erection, he.
There is a dispute between the owner and tenant, my lord.
Paragraph 47. Issue and adding limit, temporary limit. Given power supply. Provided. Now, after obtaining, suffering this order, he immediately submits this letter stating, I don't want any power supply. Just to see that the office gets closed.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಾರೆ ಅಲ್ಲಿ?
No. Mescom. Owner, no. Mescom.
If you are going to make a statement that you will give a connection in his name, I'm dismissed with notice to the third respondent. Because third respondent is made a party only because he was a tenant on REM.
Yes, ma'am.
If he says he does not want electricity connection,
Yes, ma'am.
and if you make a statement that you will make him the agreement holder, enter
Yes.
into an agreement with him,
Yes, my
and
lord.
dispense with notice to him.
Yes, my lord. We will restore the power connection subject to payment of installation charges and consumption charges. ma'am.
But ಅವ್ರ ಹತ್ರ ಹೋದ್ರೆ mostly ಎಲ್ಲ ಬಿಲ್ಡಿಂಗ್ ಪೂರ್ತಿ ಕೇಳ್ತಾರೆ ನಿಮ್ಮ ಹತ್ರ.
ಎಲ್ಲ building,
ಅಲ್ಲ ಅವ್ರ ಕಸ್ಟಮರ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದಾಗ ಪೂರ್ತಿ ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲ ನಿಮ್ ತಲೆ ಮೇಲೆ ಹಾಕ್ತಾರೆ. But then I'll issue notice to issue notice to the third respondent as an interim measure. The respondents 1 and 2 are directed to restore power supply to the office premises run by the petitioner at room number 209. You will ಬರ್ದಿಲ್ಲ ಅದಕ್ಕೆ ಹುಡುಕ್ತಾ ಇದ್ದೆ ನಾನು. It's not mentioned in your there.
Sorry, with permission, I will add that.
Where is the RR number?
Entry model act. Bracket ಅಲ್ಲಿ RR number ಅಂತ with permission.
ಅಲ್ಲ ಎಲ್ಲಿದೆ RR number ಹೇಳಿ ಹಂಗೆ.
RR number ಇದ್ರಲ್ಲ first ಇದೆ.
entry model ಅಲ್ಲಿ ಇಲ್ಲ. RR. There is no RR number mentioned.
ಇದ್ರಲ್ಲ ಹಾಕಿದೆ. Paragraph number 13 ಅಲ್ಲಿ.
To which an installation had been serviced in RR number UDP 68260. Notwithstanding the fact that the landlord has sought for surrender of the said RR number. It is made clear that the restoration of power supply would be subject to the petitioner paying the consumption charges. That's all it-
Consumption and installation charges. ma'am.
ಏನ್ installation?
Already they have restored ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ರಿಸ್ಟೋರ್ ಅಲ್ಲ ಅವರು RR number ಸರೆಂಡರ್ ಮಾಡ್ಬಿಟ್ಟು there is no meter.
That's why I've said, notwithstanding the surrender, you will restore the power supply subject to consumption.
Yes, ma'am.
New installation ಅಂದ್ರೆ you will ask for the entire building and
No, my lord, in a particular RR number only installations. Because there are 11 RR numbers, my lord.
no, it will be a fresh connection, then you will start claiming everything from the beginning. We'll have returned the deposits to that landlord.
We do not,
Ask him all that money back. Alva?
my lord, the thing is
He
that
is collecting rent now.
4.9 supply conditions ಅಲ್ಲಿ
Some
ನಮ್ಗೆ
charges and, payment of the deposits that are required to be paid by the consumer.
For orders, seal number 8, Shri Shagat S. Gowda.
In this matter, your worship suggested that to settle the matter. We are ready, we are open for settlement.
My lord.
Whatever they say, but settle it.
ಏನು open,
My lords,
what is the settlement offer?
settlement offer is this, my lords. There 43% is the their share in the constructed area. So out of 43%, there are 4 landlords. Only 1 person has come before this honorable court. Out of this 46%, let him work out his shares, whatever flats, 14 flats, 10 flats, 12 flats. We are ready to refurbish and hand it over to him. And he should make sure, my lord, the other 3 landlords tomorrow should not make claim, you know, that you have chosen this flat and that flat. It is for them to work out among these 43 flats.
ಆಮೇಲೆ
This is all, my lord. This is.
the amounts that are to be paid,
The amount, my lord, there is, it is refundable and non-refundable. There is a dispute whether it is refundable or non-refundable also. In one JDA, my lord, which is registered instrument.
then I dismiss the petition. There should be a comprehensive settlement.
Should come, my
There
lord.
can't
What
be,
should- So far as amount, they have to come out with the correct amount, what they want.
whatever is the amount to be paid under the agreement, if you are,
4%, you know, under the agreement, it is 2 crores. We have already on record paid nearly 1 crore 60 lakhs. That is, there are statements for that. Remaining is 40 lakhs. For that also, we have paid betterment charges, conversion and all those things. And that also, so as per the.
what is
JDA
your demand?
My
Azim?
lords, the problem here arises is that they have entered into a sharing agreement with 4 landlords. Now they have entered into a sharing agreement with the 9th floor, which is not there. With a for a 9th floor, which is not even there, firstly, my lords. Then secondly, they have sold 20,000 extra square feet that is coming to their share. So I don't know even if the flats are there or not. Thirdly, now they are saying that I have to get my share, but now there are 4 landlords. So they have to enter into a sharing agreement, fresh sharing agreement with all the landlords, say what all flats are going
Can
to
you
come.
get the other 3 landlords to agree?
No, my lords, that will be hard to get this in this petition, my lord. My instructions are like they will want to go ahead without the compromise is what is my instruction.
You're interested in litigating rather than settling the matter?
My lords, because I am forced to, because there are no flats, as per the EC, as per my objections, all 100 flats that are coming to their shares have gone. Now, if the 9th floor is not there, they have to give me extra 4 floors, 4 flats, which are not even there. That is my problem, my lords. Otherwise, if there were any other possibilities, I would have tried to settle. but there are no possibilities now because of the fact that there are no flats there, everything is occupied. And secondly, I'm not able to quantify how much damage I have lost, because all these years I have lost, my lords. The investment amount, they have not given me interest, all these things. And whether the four,
Collect the value of the flats, the 4 flats that they have not given to you. Whatever is the value that you
no,
want.
because then I do not know which share, because each flat has a different square feet area and all those things, my lord. So
You know your entitlement, right?
please, my lords, I'm entitled to around 17 flats or something like that, as per my
That square feet also will be mentioned.
mentioned, yes.
There is 4 shortfall.
4 shortfall, but it's among the 4 landlords, my lords, all.
Right. The value of those 4 flats
Yes,
at
my
the rate determined by you.
please,
Suppose they are prepared to pay that money to you.
please, my lords.
Would it solve your problem or would you still want to litigate?
My lords, but then what has happened is they forged other documents also, that will come into.
You want to litigate, I'll not come in your way.
Yes, my lord, that
you
is
want
what, that is what they want to do, is what my instructions are. I tried for the settlements. My lords, there's Tuesday, again, today it was.
So their whole purpose of filing this criminal law in motion is.
No, but if you have cheated them and if they cannot, you were supposed to give them 4 flats.
No, my
You're
lord,
taking advantage, 4 flats is a shortfall now. You're taking advantage of the situation.
Plus 4 flats is the shortfall because of this reason. 9th floor was supposed to be considered subject to getting the TDR right. We did not get the TDR right. Whatever is now available among these 8 floors.
If you did not get, if you did not get TDR, you should have modified the sharing agreement.
We are ready to modify.
Not after selling your share.
Plus,
ನೀವು ತಪ್ಪು ಮಾಡ್ಬಿಟ್ಟು ಇವಾಗ ಹಿಂಗಿದೆ ಸಿಚುವೇಶನ್ ಹಿಂಗಿದ್ರೆ ಒಪ್ಕೊಳ್ಳಿ ನೀವು ಅಂತಂದ್ರೆ
ಹೇಳೋದಕ್ಕೆ ರೆಡಿ ಅವ್ರು ಹೇಳ್ಬೇಕು ನಮ್ಗೆ ಇಷ್ಟು ಅಮೌಂಟ್ ಕೊಡಿ ಇಷ್ಟು
ಇವಾಗ ಇದೊಂದು ಕಂಡೀಷನ್ ಆಗ್ತಿಲ್ಲ ಅವ್ರು 3 ಜನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಆಮೇಲೆ ಅದ್ ನಿಮ್ ಜವಾಬ್ದಾರಿ ತಾನೇ ಅದು.
ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಈಗ ಅವ್ರು
ಇಫ್ ಯು ಆರ್ ಏಬಲ್ ಟು ಗೆಟ್ ದೋಸ್ 3 and all of them,
as of now that I will solve the problem which is in front of this person is in front of.
that won't be a complete solution.
You are watching my guidance.
Then he'll be right saying that you are trying to get away with whatever cheating that you committed, the forgery that you committed. You have an option to escape provided you settle to their terms.
Plus we are in ಏನಿದೆ ಆ ಫ್ಲಾಟ್ಸ್ ಅಲ್ಲಿ 43% ಶೇರ್ ಏನ್ ಹೋಗ್ಬೇಕು ಅಷ್ಟು ಫ್ಲಾಟ್ಸ್ ಅವ್ರಿಗೆ ಕೊಡ್ತೀವಿ. ಫ್ಲಾಟ್ ನಂಬರ್ ಸೋನ್ಸ್ ಅಂತ ಇವ್ರು ಚೂಸ್ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಮಿಕ್ಕಿದಂತ
ನೀವು ಅವ್ರು ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅವ್ರು 3 ಜನ ಬರ್ತಾರೆ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಅಂತ ಅವಾಗ ಅವ್ರು ಜಗಳ ಆಡ್ಬೇಕು ಅವ್ರ ಜೊತೆ.
that also will try to explore. That we will try to explore.
that is a
Tuesday
Tuesday's
ಮೆರಿಟ್ಸ್
second.
ಮಾಡಿದ್ರೆ ಟ್ಯೂಸ್ಡೇ ಅಷ್ಟೊಂದು ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರ ಕರ್ಸಿಯನ್ನು ಮಾಡಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ
Plus so far as we are ready to go ahead with marriage collapse. It is in there and also faculty. Plus this intention to deceive did not exist at the inception. This all 2010 agreement was complaint is filed in.
ಮಾಡಂಗಿನ ಮಾಡಿ ಈಗಲೇ ತಗೊಳ್ತೀನಿ. ಮೆರಿಟ್ಸ್
They are ready,
argue.
Because
I didn't want the 2 of you to fight, therefore I suggested. ಬೇಡ ಅಂದ್ರೆ ಇದೆ.
I am being before my lord. I am interested in settling this.
We should be settlement which is mutually acceptable, not a settlement on your terms.
Whatever they say, we are ready to agree. They have to come up with some
my
proposal.
lords, now I'll be.
ಅಲ್ಲ ನಿಮ್ ಪ್ರಪೋಸಲ್ ಅವ್ರ 3 ಜನ ನಿಮ್ ತಲೆನೋವು ನಾವ್ ತಲೆನೋವಲ್ಲ ಅಂತಂದ್ರೆ
I will take back that. Let them say now.
Lords, that
ನೀವ್ ಹೇಳಿ ಅವ್ರ 3 ಜನ ಹೆಂಗ್ ಸೆಟಲ್ ಮಾಡ್ತೀರಾ 4 ಜನ ಸೆಟಲ್ ಮಾಡ್ತೀರಾ ನೀವು.
Total ಆಗಿ ಇವಾಗ total 56 lakhs per. Their share is about 17 lakhs. 17 into 15 into, now it was 17. Now there is 4 flats shortfall. Around 15 flats for each person. 15 flats which has come to each share. We will identify and say these are the flats which will be given to you. And others 15% we will also identify their share and make an offer for them. Totally 60.
ಏನ್ ಮಾಡ್ತೀರಾ ಮಂಗಳವಾರ ಅಷ್ಟೊತ್ತು ಮಾಡಿ.
Not on that, any rate of apart from that.
5th. On that day, no further time. You have to argue on merits or reports.
I came within.
No, my lord, I was this one, but my problem has to be seen because the other 3 brothers.
Come up, give me a proposal, I'm ready.
But
I get an impression that you are trying to escape the problem by saying you solve that problem, then
Not our intention.
you got into the agreement with 4 of them. It's your responsibility to solve it.
It's actually my brother, it's not even appeal, petitioner was before this honorable. It is actually one Praveen Kumar, he is not even here. Accused number 1. Anyways,
5th ವರೆಗೂ ಇದೆ ನೀವೇನ್ ಮಾಡ್ತಾರೆ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ go on with the merits.
Seal number 9.
May I seek for extension of the interim order.
Seal number 9, Shri Gautam.
Last week I had taken time
Because wanted to try for a settlement. Perhaps I have given the list to the current senior. This is a matrimonial dispute, perhaps which ended in a criminal case and divorce proceedings are pending.
You're for the,
I'm for wife, respond number 2. The in-laws, husband and sister-in-law are before your lordships.
the husband and the sister-in-law.
Sister-in-law and in-laws.
There is a.
4 ಜನ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ except for husband the proceedings are stayed. When I moved the matter last week it was listed. So since there are no issues out of the marriage and divorce is pending, both they don't want to reside together. Gracefully we can put an end. That was the request. And I pointed out that certain jewelries which are given during the time of marriage has to be returned. You may not claim anything extra. So I was directed to share a list with the respondent, petitioner, sorry. So that perhaps there could be any via media settlement. I have given the list to them. So whatever is, at least let them have a counter offer that Uttu serial antu kalasiralla, palace ground al marriage agide. Looking at the community background, we would have given something. Let them be fair.
What he says that both sides put in 15 and 15. 30 lakhs, they had their marriage. With respect to her things, I'm told that she took everything and that's already come in the evidence, which for the cross-examination with photographs, all of that has already been done, Your Worship. So if the return is there, then their share of the wedding expenses probably could be returned.
You have to buy peace if you want.
I understand.
You want to argue on merits?
Not fair. Your Lordship, this other issue.
You're in a situation where it's better that you buy peace and get rid of this problem. Instead of arguing like this, saying that it was given back, we shared the wedding expenses. There must be some penalty that you should pay for the marriage going wrong.
The difficulty for them right now is this, Your Lordship. Sister-in-law has also been made a partner. She got married very recently. She went abroad. These people are informed. They have sent this girl back saying, until and unless you quash your criminal case, you cannot.
Therefore, all the more reason for you to buy peace.
To Your Lordship, but that is being held as against us to push us to.
Madam, you're a lawyer, I was a lawyer, he is a lawyer. This is what happens. That's why I'm saying, you want to buy peace, buy peace. Why do you want unnecessarily litigate this? The marriage is gone, isn't it? It's dead.
Right now, in fact, there was nothing wrong there. She's brought it to this situation.
It's marriage is dead. What is the point in you going on with this?
Your Lordship, but they are saying that what is rightfully to be returned, we will. But beyond that, they are also not.
And this is not mathematics. You want to buy peace, be a bit generous, get rid of the problem. Or else you will unnecessarily keep on litigating. And this won't end here. With your experience, you should know this won't end here. This is only the beginning.
Again, try to push them to come forth and we will give the counter offer.
Your choice. You know what my limitations are. I can't go beyond. So if you.
In fact, her returning to her parents' home, even her brothers and sister-in-law have split up. So in fact, now as a result of one complaint.
That is their problem. That is their problem. That's it. At least you get your family right. Why do you want to?
Now the husband is so upset that his sister's marriage is in shambles because of this.
That's why I'm telling you, there's an opportunity to buy peace and get rid of this. You're unnecessarily arguing on.
Your Lordship, if they're more fair with their offer, we could.
So let them give counter offer. I can persuade my client.
We just received it.
Flatly refusing, saying some allegations and all. That should not be. I want, at least I should, I wanted to put an end to this because both are young and they can have a good life.
He's given it to us a minute before the matter came up. So we've not even had to.
Any date, whatever. Now she will take the lead for settlement.
Your choice.
Number 10. Shri Venkateshwari.
ಯಾವಾಗ ತಿರೋದ್ರು?
1 ವರ್ಷ ಆಗಿದೆ.
Stated that Commissioner 2 and 3.
ಒಬ್ಬರು ಸತ್ 1 ವರ್ಷ ಆಗಿದೆ, ಇನ್ನೊಬ್ರು ಸತ್ 3 ತಿಂಗಳಾಗಿದೆ.
Since steps have not been taken, the petition as against P2 and P3 shall stand awaited. Make an application whenever you want. ಇಲ್ಲ ಅಬೇಟ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ಆಮೇಲೆ ಅಲೋ ಮಾಡಿದ್ದೀನಿ. ಇಲ್ಲ ವೆದರ್ ಐ ಸೇ ಇಟ್ ಆರ್ ನಾಟ್, ಇಟ್ ಇಸ್ ಅಬೇಟೆಡ್, ಇಸ್ಂಟ್ ಇಟ್?
ಇಟ್ಸ್ ಆಪರೇಷನ್
ಆಲ್ರೆಡಿ ಅಬೇಟೆಡ್. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಲೋ ಮಾಡ್ತೀನಿ ನಾನು. ಸೆಟೆಸೆಡ್ ಅಬೇಟ್ಮೆಂಟ್ ಹಾಕೊಳ್ಳಿ, ಆಟೋಮೆಟಿಕ್ ಅಲೋ ಮಾಡ್ತೀನಿ.
Seal number 11. Shri Dominic Avinash Pokish. 14, petitioner.
Not engage the council.
They said that they need, unfortunately, one NOC, what to need is second NOC. They need about 2 weeks left when council appear for the.
No, this is 2018 matter. I can't grant you time like this. The last ticket itself, I said you would be granted only 1 week's time.
Okay, why don't you get a lawyer? Yeah, supposed to get a second NOC, not really second NOC.
What do you mean second NOC?
One is with High Court, and this is what they need, one is with the lower court.
We are only concerned with the High Court. If you can't engage a council, I'll ask somebody else to appear on your behalf. The petitioner appears in person 6 for 1 more week's time to engage another council. Finally, a week's time is granted for him to engage the council. Relist on 8. If you don't engage anybody by then, I'll dismiss it.
Seal number 12. Ramani, yes.
School though.
They have to file the sketch, my lord.
Sketch or matter. This portion. Hello. This portion I'll save that, sir.
No, actually there is ample amenities. They have the compound, they have the playground, and they have an open theater.
Whatever is shown by the Tahsildar as 11 guntas, that we have no issues, madam.
No matter the parts of the.
With regard to that 11 kunta, we have no issues. It is not the allegation that I am disposing them or I am in a illegal occupation.
Sir.
Please.
Seal number 13, CPN Manmohan.
Section 11, made not moved upon the.
Relist.
File it in the registry.
5th.
Seal number 14, GR Mon.
Kindly take up the file amended petition with connected.
What happened, madam? Instructions.
I have instructions. Minutes, what is challenging is annexure K minutes. Amended petition may kindly be taken. His grievance is minutes. I'll read out annexure K. His grievance is
Sir.
minutes. Sorry, minutes.
Next, sir, A.
Annexure K
K.
of the amended petition minutes. I will just read out. It's, minutes got it.
Can you give me the page number?
Minutes,
Amended petition.
ಅದು amended petition ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ he has given that document, annexure K at page 4 of the amended application minutes. Let's go.
Where is the Yav annexion?
Amended annexure G page 28. Annexure G.
Next, the case page.
K man, ಇದನ್ನ, sir.
Page number.
Sir, it's dated the 12th February 24 minutes.
Yes.
I'll read out minutes. Your film May 18 was screened on 14/12/23. The cuts notice was sent on 29/12/23. You have resubmitted carrying 8 out of 9 cuts, but you have not carried out the 9th cut, that is lip sync to Kannada language. Repeated notices were sent on 30/12, 31/12 and 22/1 to resubmit 9th cut. You are hereby directed once more to sync lip movement to Kannada dialogues. You may resubmit with video clips, 4 clips of 5 minutes each from each quarter of the film having conversations, proving beyond reasonable doubt, or reapply in dubbed category. Therefore, in the present dubbed Form May 18 shall not be certified as fresh and original. Furthermore, approach revising committee for redressal before approaching this honorable court.
What is
So
the
this
application that he had given for?
Please, my lords, on the last occasion, my lords had asked me what is this dubbed category and original category? And where from we draw support in the rules.
So
my
what did
lords.
he apply for? Where is his
He
application?
applied for original category.
Where is
because
his
it's a
application?
Tamil movie.
Where is his application?
Application, he has to submit it. my lords.
Application is Annexure A, page 11.
Under which category do you
One.
submit?
Kannada language is original language is Kannada. Annexure A. Then your lordship may kindly see. Annexure C, page 15.
My lords,
They
I
say
will
they are
just take-
certified as A film.
Whether original language or dubbed, you have said original language.
my lords, I am placing on record
You
the,
had applied under the original language category. But it is actually a dubbed film.
Kannada. Because it is a original Kannada film. Annexure D, I have clarified also. As per Annexure C, your lordship, I given a reply. Kindly see page number in that. Page number 18, your lordship, Annexure D. Whatever the page number 18. And kindly see at page number. They are agreed only about the seal number 9, page 21, you are lucky. Page 21 only. Story happening in the lordship, page 21.
So this 9
Annexure
objections
D.
that you raised at page number 16.
please, my lords, I have produced it in my objection statement as R1.
That is dated 29/12/2023.
Huh.
Please read the contents of the letter.
2912, please, my lords. With reference to your application to the Central Board of Film Certification dated so and so for certification under Cinematograph Act 1952 to exhibit the film titled May 18 Kannada. That is what he's written, given the title. I am directed by the board to inform you that the film has been viewed by the examining committee and the board has come to the conclusion that the film is not suitable for unrestricted public exhibition, but may be suitable for public exhibition restricted to adults, provided you carry out the excisions modification in the film listed in the annexure, and that you should accordingly be requested to carry out the excisions modification so that the film may be sanctioned for public
Seal
restricted.
number 1 to 8 are relatable to the adult content.
Please, my lords.
Seal number 9, lip sync movement. How is it relatable to public viewing or by adult viewing?
My lords, that is a different thing, but I have produced one form, my lords, where under which he has to apply. That form, if my lords see.
No, if
that
suppose
is-
he had applied for the dubbed category, do you mean to say that there are different yardsticks?
He
The
has.
purpose of certification of viewing by the public, the contents of the film are the same, whether it's dubbed or original.
But my lords, he has to follow the procedure under which he has to apply. He has applied under original category. We have no issue in giving him for the
There is
dubbed category.
substantive difference in certification, whether it's original or dubbed.
Yes.
Suppose in
because-
the original category it is shown as adult.
Huh.
And in the dubbed category, would you give a different certification?
My lords, we will give him the A certificate only. But our issue is let him carry out the lips sync.
Is that relatable to certification for viewing?
My lords,
For your concern-
I will point
Or
out.
concerned with the content?
My lords, I understand, my lords, what my lords are asking is, but there are rules where they have said that as per the format, if applied, they will get certification. And as per the format,
And you're looking at the form rather than the substance of the film.
my lords,
the
it
application
can't
that
be
he-
exhibited like that, my lords. If the characters are speaking in Tamil and he is giving in Kannada subtitles, it doesn't suit, my lords. So
You're
all
not
that
the
we're
aud-
asking is,
You're not the audience. The audience will take care of it. Your job is to see whether the content is to be viewed by X category or Y category. Once you say it's adult category and he has done all the 8 cuts, the 9th cut is unnecessary for the purpose of certification as to who should view it, whether the lip sync or not. How does it matter?
my lords, but that is the procedure followed by the board.
The wrong procedure.
My lords, then he has to challenge that procedure.
I'll hold that it is an improper procedure.
My lords, unless he
Have to challenge
challenge,
it.
my lords,
You
my
can't-
humble
you
submission
can't-
is.
You can't use these tactics to stall the exhibition of a
My
movie.
lords, we have no intention to harm any producer or director who wants to make movies for this purpose. But I have two submission, my lords. One is that unless he specifically seeks for that prayer, this honorable court may keep
What
it
is it
in
that you
mind.
want to do?
Secondly, my lords, secondly, there is a statutory, under the statutory scheme, there is an appellate authority available. alternate remedy. So there's a revising committee and there's a FCAT, that is Film Certification Appellate
It is
Tribunal.
not an absolute bar for 226.
Please, my lords,
What is the statutory rule that you want to rely upon?
that is, my lords, I will pass the Cinematograph Act, I think, my lords.
What is that you
This is
gave?
the act. He'll add the format for applying for the certification. The next is the rules, my lords. Read with the act, I will pass on this act, my lords.
Just tell me the rule. What's the rule that.
Rule, yes. Let's kindly see page 29 of the rules what I have produced, 25, my lords. Rule 25. 1. On
25.
receipt of, my lords, got it. 25-1, on receipt of the record
Rule
referred.
25 one. Rule 25.
Rule 25, please. On receipt of the record referred to. Page 29. On receipt of the record referred to in Rule 23, the chairperson may, on his own motion or on the request of the applicant upon a representation made under subsection 2 of section 4, refer it to a revising committee constituted for the purpose. My lords, this is the first stage of appeal, if we can say. And then he also has an appeal under cinematograph, what I just, it's under 5C of
There
this.
is an examining committee which may refer it to the revising committee.
Please, my lords. Revising committee constitution next is given. Who
Yes.
constitute the revising? So my submission is let them re-examine the movie.
For what? You had raised 9 objections. 8 of them are complaint. The 9th one only relates to lip sync.
My lords, because they are the experts to know whether, how it affects the public viewing. my lords.
The theater also, only for the film.
That's all.
Even the earlier direction is also very specific, you know. That's a
The
very.
petitioner sought for certification. Film. While seeking for a certification, the petitioner did state that the film was in the original language of Kannada.
My lords, yeah, please interrupt me. There is one more submission I have to make. My lords, what has happened here is, this movie was made long time back in Tamil, in 2015. Porukalathil Orupu is something, is the title, my lords. That movie, my lords, is based on, it is the same, characters are same, storyline is same, nothing has changed except the film title. That movie is made on the protagonist is a lady who belongs to the LTT gang, and she was misbehaved by the Sri Lankan army. On that ground, that original Tamil movie was refused certification because it affects the friendly relationship with Sri Lanka. My lords, that movie was refused. Again, he made that as 18/5/2009 Tamil alle. Instead of made in 18/5 he. That was again refused. He made again in Telugu Samara Bhumilu Sanna Jaji. This was, my lords, allowed, certification was allowed, but again, the regional office were not aware of the history of the movie. Then again, the information and broadcasting, that lady's mother and sister sent a legal notice saying that this is what is happening and we will take action. So, my lords, when originally the Tamil movie was refused, it went to Chennai High Court. High Court held that, should I bring my lord's notice to the High Court judge?
Madam,
The High Court
you
held
could
that.
have refused certification on that ground, saying that your earlier
My lords, we
request.
were not aware of that at the point of
Then
time.
why
when
did you
we-
issue this endorsement?
Why I'm saying is, my
Withdraw
lords.
this endorsement and then
Alex,
make
I
it fresh.
understand, my lords, but what I'm trying to say is, my lords, if at all it is referred to revising committee, they may consider all these facts.
Why should you? Madam, I don't seem to understand. They come to you for certificate. You raise 9 objections. 8 objections are relatable to the content of the movie. You are justified. It was open for you at that point of time to say that, no, we will not allow this because the original Tamil movie was not allowed.
We were not aware of it at that
So
point.
therefore, withdraw this and say that you will pass a fresh order. So long as this order stands, granting him certification subject to compliance of 9 conditions.
My
It
lords,
does
I
not
will
lie
go
in
with
your
it.
mouth to say that I will not allow this film to go.
Please, my lords, I will go with it, my lords. I will withdraw it and my lords may record it.
In fact, my director was referring to the suit. That suit is also dismissed. I filed a yet
Lala,
additional document already.
you can't prevent them to withdraw this letter.
The suit is also dismissed and the revising committee also approved it.
No, she has a point in the sense if this film was not certified in Tamil Nadu twice.
What is that certification?
Illa, my lords.
Yeah, we
All
should-
annexures I have done.
submitted the list, already they have issued a certificate. And film is also released in theaters.
They're not counsel
That's
for
what
the
it's also released in theaters.
respondent. Submits that the respondents are withdrawing.
Annexure K, my lords.
Next year K. Which is impugned in the writ petition. And they propose to pass a fresh order. In view of the above, it is obvious that the writ petition has become infructuous. Respondents are permitted to pass a fresh order on the request of the petitioner for certification. If any such order is passed adverse to the interest of the petitioner, we open for him to challenge the same.
Grateful.
In fact, page 117 of the statement of objection, they sought for legal opinion for Tamil movie. They said once the certificate is granted, it cannot be withdrawn. So here also, yes, certificate is given. So I'm
No,
not-
but if they want to withdraw this, what does it do?
Seal number 15, Srimati Sudhadi.
You know? Where? Now, ಅವ್ರೇನೋ prayer ಅಲ್ಲಿ 31-1 ಅಂತ ಕೇಳ್ತಾರೆ. ನಾವು ಈ ಪಿಟಿಷನ್ ಯಾವ್ದು ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ 31-1-2023 ಅಂತಾರೆ.
ಸನ್ನದುದಾರರಿಗೆ ವಾಟ್ಸ್ಆಪ್ ಮೂಲಕ ನಿಂಬರವನ್ನು ಕಳುಹಿಸಿದ್ದಾರೆ ಆಗಿರುತ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. And get the instructions for us because we have not a contract ಅಂತ. It is an lease agreement between the citizen and the fixed responsibility.
What is this 21-2-2023 that you had given? Which is stated in the impugned endorsement.
Well, that is the original petition. As per annexure E, page number 23.
Next year,
Annexure E, page number 23.
dated 21-2 ಅಲ್ಲಿ.
It is filed.
Then I'll permit you to challenge this, challenge it separately. The prayer will not survive, isn't it? The prayer in this petition is for issuance of amendments to direct the second respondent to pass appropriate orders on the representation dated 31-1-2023, which is produced as annexure E to the writ petition. Then HCGP submits that the representation of the petitioner has been considered and an endorsement has also been issued on 28-6-2023. She also places a copy of the said endorsement on record and furnishes a copy of the same to the petitioner. In the light of the endorsement that is stated to have been issued on 28-6-2023, it is obvious that the prayer in the petition does not survive for consideration. Liberties are reserved to the petitioner to challenge the endorsement dated 28-6-2023 in a manner known to law.
Seal number 16, D. Vijay Kumar.
My lord, I am for the petitioner, my lord. This petition is filed by the Reliance General Insurance Company. My lord, in the office objection, my lord, I have mentioned it is a registered under the Companies Act. But officers, I have made a submission.
Nature of the petition stated in constitution.
Yes. Reliance General Insurance Company Limited, TP Clients, 5th floor, Centenary Building, East Spring, Bangalore.
What is the petition about?
My lord, petition, my lord, we have filed an application before the tribunal for impleading application to implead the respondent number 5, 6 and 7. My lord, that application has been dismissed in spite of no objection, and also, my lord, In the FIR, my lord, the proposed respondent numbers
Who are the?
3 and 5 are there. Even in the charge sheet also, the charge sheet is filed against them.
Yeah, who are the proposed respondents?
Proposed respondents, my lord, one is the National Highway Authority of India. Peenya flyover, my lord, Peenya flyover. My lord, they have not maintained the road. It was closed. And they have allowed the rider of the motorcycle and also the vehicle to move on the road during night time without light. During rainy season, the entire rainwater is collected in the flyover. Actually, it was banned. During that time, the accident has taken place. Therefore, my lord, even the police have also filed FIR and charge sheet against the National Highway Authority of India, the concerned officer, and also the contractor. They have not repaired. And my lord, you ask me kindly see the annexures, my lord, from the police have made repeated request demands and many reminders. This is from annexure G2. Kindly see annexure G. The my lord, all there are about 25 correspondence between the National Highway Authority of India and also the Peenya Police and also the Commissioner of Police. In spite of it, they have neglected to maintain the road. Thereby, the accident has taken place. And police have filed a charge sheet against the National Highway Authority.
What is the reason given the trial court?
Well, the tribunal has not given a proper reason because they are not entitled for compensation from National Highway Authority of India. My application is only to implead them. After impleading the party, let the court decide on merit.
It is a motor vehicle accident. The charge sheet has been laid against the
Both.
driver of the offending vehicle. Now you want
Driver of the offending vehicle and
highway
also
authority
National Highway Authority of India, contractor and also the supervisor, team leader.
government party ಮಾಡಿದ್ರೆ government ಅವರು
ಮಾಡಿದೆ.
In motor vehicle case ಅಲ್ಲಿ can you go into all this?
My lord, there is one
necessary parties. Whether
they are the proper, my lord, because of the bad maintenance, my lord, because of the Appaji case is there, my lord, the division bench of the Istanbul court, it has fastened the liability on BBMP also.
ಕೊಡಿ ಅದು ಯಾವ್ದು judgment ಎಲ್ಲ
Right now, I don't have, my lord, I'll give it, my lord.
Produce it. Relist.
Office objection may be overruled. My submission may be accepted.
It is deferred for the present.
Okay. Next week, my lord.
5th, yes.
How much of list?
Number 17, Srimati Sudhadi.
Who's Zarwan and Art?
Correspondent number 1, Your Honor.
My lord, the petitioner is the manufacturer of liquor.
Manufacturer of?
Liquor, Indian made liquor, having its distillery at Goa. My lord, as indented by the respondent number 1, number 2, which is a government company which is a first seller of liquor in the state, certain quantity of liquor was transported and it reaches the destination. During the election time, there were certain difficulties faced in transportation and the excise inspector registers a criminal case at annexure D that the permitted time the goods has not been delivered to the consignee. That case has been compounded also by applying section 45 of the Karnataka Excise Act. My lord will kindly see page number 22, the compounding order. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವಿಧ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಕರ್ನಾಟಕ ಅಬಕಾರಿ ಕಾಯ್ದೆ 1965 ಕಲಂ 45 ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಅಬಕಾರಿ ಉಪನಿರೀಕ್ಷಕರ ವಲಯ 31 BUD5 ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಇವರು ದಾಖಲಿಸಿದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋಣಿಸುವ ದಿನಾಂಕ 13/4/24 30,000 ರೂಪಾಯಿ ಮಾತ್ರ ದಂಡ ವಿಧಿಸಿ ಇಲಾಖಾ ಮುಖಾಂತರ ಇತ್ಯರ್ಥಪಡಿಸಿದೆ. ಸನ್ನದುದಾರರು ದಂಡದ ಹಣದ ಪಾವತಿಸುವುದನ್ನು ಖಚಿತಪಡಿಸಿಕೊಂಡು ಪ್ರಕರಣ ಜಪ್ತುಪಡಿಸಿದ ಮದ್ಯ ಮತ್ತು ವಾಹನವನ್ನು ಪರವಾನಗಿ ಅವಧಿ ವಿಸ್ತರಿಸುವ ಬಗ್ಗೆ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಬಿಡುಗಡೆ ಮಾಡಲು ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ವೈಟ್ಫೀಲ್ಡ್ ವಲಯವರಿಗೆ ಆದೇಶಿಸಿದೆ. So, having case has been compounded, there is no difficulty of delivering the goods to the consignee because it is a seized property. The inspector has to take steps to see that it is delivered to the consignee. Now, in this case, what is the difficulty is, it has reached their campus. The truck owner is the person and the driver. In order to extract money for entire period of seizure, he is not opening the lock. My humble submission will be a
lock of what?
Lock of the truck. It is there in the truck in the campus of the respondent consignee. They have also no difficulty in taking it. My humble submission is that, my lords, let the respondent state excise department break open the lock. The compounding is done at my,
You want them to break open the lock of some truck owned by somebody else without them being made a party here?
no, the excise department, I am only requesting the authorities to exercise the powers vested in them under section 32. Now
You want somebody else's truck to
it
be.
is, let the authority take, I am not asking that.
Make him a party.
The difficulty will be, my lord, he is, the parties, both of us have requested him like anything. He says, you pay me every day.
If you make him a party, then probably I can pass some order on the judicial side. Without him being a party, you want me to direct them to break open somebody else's?
It is, authority have got the power under section, they can, the compounding is my case.
Suppose he sues them, as how did you touch my truck? Then who's to
We
take?
cannot, because loaded goods is excisable article. Without permit, it cannot be kept even a minute. More than 2.5 liters, one cannot possess even a minute.
Party madi nodana, let us see if we can do something.
Please, maybe called on Monday, I will, tomorrow itself, because almost 2 months, and I understand that I do not know whether beer is there, that's a perishable goods. Though liquor is not.
Make him a party, let us see if I can pass.
Tomorrow I will file application and.
I'll permit you to take out hand summons on him. Take out, let us see what can be done.
Please. What is the RC address? I have taken the.
You have hired him, so you would know who he is.
Yes, I have got his particulars. I will advise my client to see that.
Implead him, I'll permit you to take out hand summons.
Please.
And thereafter.
Please. Tomorrow I will file that.
Address ಕೊಟ್ರೆ ನಾನು ಈಗಲೇ implead ಮಾಡ್ತೀನಿ ನಿಮಗೆ permitting you to.
I will. Phone number is there. Please.
If you know his name.
By 2:30 it will be done.
My lord, it will be there in the FIR, my lord. Page number 17.
17.
Yes, my lord.
34.
Annexure D. Page number 17. Accused number 1, Jagdish B.
Kolur.
He is the driver or the owner?
He is a Bangalore number. It's a driver. I can implement the driver right now.
No, I need the owner. What will the driver do?
Registered owner.
He's the owner from my given understanding. He's the owner.
Driver come owner.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಹೇಳಿದ್ದಾರೆ, instructions are like that. I will implement him, my lord. I will take the chance.
Monday.
My lord, may.
Right give me your details. I'll implement him right now. You're not very sure.
It is there in the affair. I will show you.
ನೀವು ಮಧ್ಯಾಹ್ನ ಕರಿತೀನಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. ನಾನು ಡ್ರೈವರ್ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ತೀರಿ ಅವ್ನು ನನ್ಗೆ ಬರ್ದಿರ ಹೋದ್ರೆ.
ಇಲ್ಲಿದೆ FIR accused number 1.
There's nothing to indicate that he's the owner of the vehicle, isn't it?
My instructions are there. Even the other side says he says owner come driver is the same person.
ಹೆಸರೇನು ಅವ್ರದ್ದು?
Jagdish. Jagdish son of Basuraju. Number 34 Kolur, Antarahalli, Dodballapura, Bangalore. Rural district. Seventeen is the particulars of the accused.
The case of the petitioner that the Indian-made foreign liquor, which was consigned to the first respondent, was seized by the excise department, and a crime was also registered. But subsequently, the proceedings were compounded, subject to payment of a fine of rupees 30,000, which has also been paid.
Yes.
It is this further case that the consignment has actually reached the premises of the first respondent in the vehicle belonging to one Jagdish B. Basuraj. But they said Jagdish, son of Basuraj, is refusing to hand over the liquor and has locked the container, thereby preventing access to the first respondent to remove the liquor. So in that view of the matter, Jagdish B, son of Basuraju, residing at number 34 Kollur B. Antarahalli, so page 17, is ordered to be pleaded as the fifth respondent petitioner is also permitted to take out and summons on the said Jagdish released on, I said Tuesday.
Please.
My lord, if
My
my
lord,
name
say-
may be reflected, I'll undertake to file wakalat at the end
So
of
the
it.
standing counsel
No, my lord.
or the
She's-
counsel in the panel, because every time
They don't have the
I've
panel.
There's no panel advocate, my lord. It's on
She's
case
the
to case
advocate for the
basis.
board.
you appear for all the matters.
No, only for this particular matter. It's on case to case basis that we are allotted, my lord. So there's no panel advocate.
Ask them to furnish a copy of the email address so that I'll ask the notices to be sent to them. Normally, there should be somebody to receive notice. You're a statutory corporate, you're a state
Board,
corporation.
government company.
So why should we wait for you? Can't you make arrangements to see that somebody is represented the moment or petitions are filed?
I will instruct, my lord. I will instruct them to take necessary actions.
The office to register the name of Srimati so-and-so is appearing for the first respondent. The first respondent is also directed to furnish the list of advocates in their panel so as to facilitate the service of writ petition and its annexures to them in the event petitions are filed against them.
The consignment is meant for the depot, the second respondent.
First respondent andre
First respondent is the incorporated office. Depot is the second respondent. Same board authority, but local distribution center.
the premises of the second respondent.
To avoid the pilferage, the government corporation has been created.
Bill number 18.
Please.
Andhra.
May-
I appear for the request. That, now that power supply has been restored. And where not that initiated proceedings, subsequently after filing of his objections, that order has been recalled on yesterday and power supply has been restored.
Award recall agida.
That order has not been challenged. The notice has been challenged 1/2/2024. Subsequently, he has not appeared before him and filed, furnished the documents. Then 27/5/2026, that order has been passed. And
This 1/2/24 is withdrawn.
27/5/2024 withdraw. That is 1/2/2024 is a notice calling upon him to file objections.
The Council Sri H. V. Devraju submits that pursuant to the impugned notice dated 1/2/2024, an order directing disconnection of electricity was made on
27/5/2024 order was passed.
He submits that this order has since been recalled and the power supply has also been restored. In that view of the matter, the prayers sought for in the writ petition would not survive for consideration. Writ petition accordingly disposed of the consequences.
For hearing on Bill number 19. Shanti.
Please. I appear for the petition in this case, madam.
Please, time may be granted.
But
Meanwhile, I complete the office objection and connected matter is for a
ನೀವ್ ಹಾಕಿರೋದು ಅವ್ರು ಹಾಕಿರೋದು.
ನಾನ್ ಹಾಕಿರೋದು.
ಅವ್ರು ಹಾಕಿರೋದು. I don't know why, what's his claim in the my property, my lord. But my lord, if your lordship may kindly see, my lord, the act is repealed. This matter pertains to
What
the.
is his right? What is he claiming? What is his interest in the matter?
Well, the site has been allotted to the impeding applicant from the housing society. The land has been given to the government as per the information to the society. And as per the Urban Land Ceiling Act, according to the Urban Land Ceiling Act.
This land was given to a society anta.
Please, my lord.
And you're an allotee of
The entire land vested to the government. Government has given to the housing society. Housing society has allotted to the impeding applicants, my lord.
Then
And
I
all
thought the-
procedure has been complied by the government. Land vested to the government.
Impleading allow ಮಾಡ್ತೀನಿ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ ಅವ್ರು.
Please, my lord, please.
The application for impleading is allowed since this content by the proposed ಒಬ್ರ ಎಷ್ಟ್ ಜನ?
Ibrides.
Proposed respondents that they're the beneficiaries of no. The land which is subject matter of this writ petition. Cost rate will be amended. ಯಾವತ್ತ ಹಾಕೊಳ್ಳಿ?
Next week, my lord.
Next week. Connected matter dictating order ಸಿಗಿದೆ ಸ್ವಾಮಿ 18 ಅಲ್ಲಿ.
My lord, in that we are not the parties in that.
Notification is common.
Notification
In
will
which
be.
same notification, two survey number has been challenging. This
Want me to send this there?
Please.
Want me to send?
No, my lord. This is entirely different matter than what my learned friend is
next
saying.
week.
My lord, this is straight away covered by your lordship's judgment. My lord, I have filed it, my lord, on
Next week ಮಾಡ್ತೀನಿ ಅವ್ರು ರೆಡಿ ಇಲ್ಲ.
Please, may pass on this judgment, my lord, to be in the file, my lord. The, ಇದು ಇನ್ನೊಂದು. Grateful.
Number 20.
I pay for the petitioner, but I pay for 2 weeks time to file my objections.
Who has filed the application in pleading?
I have filed the application, but I pay for some time to file my objections. R1 to R3, not have to file their objections to the main petition also.
What is this in pleading?
Alas. Lord, respondent number 2 and 3, who is a legal enforcement cell joint director, he had issued a notice to the petitioner to pay the market fee to the APMC Bangalore. Now, my lord, the second and third respondent enforcement cell has been withdrawn and it is closed as now. And the entire matters of their matters has to be taken care by the concerned APMC. So concerned APMC is Bangalore APMC. That is why Bangalore APMC has filed this application to implead themselves as a.
What is the order impugned here?
It is a notice that is impugned, my lord.
By whom?
Notice issued by respondent 2 and 3.
So you are saying response 2 and 3 don't exist?
Now it has been withdrawn. There are.
Implead them. Since it is contended that the proposed respondent is the authority who has succeeded to the powers and responsibilities of R2 and R3. In my view, they would be necessary parties. The application for impleading is accordingly allowed. Petitioner to amend the cost rate. Amend the cost rate.
Much of.
Seal number 21, Shri A.V. Amarnath.
I'm appearing for the respondent in this case.
They are charged for misuse of electricity, my lord. That was not a correct. Alla.
What is the application for modification?
Modification earlier.
Modification of the interim order. It is considered, my lord, and earlier. And they have.
Now it's only for, can be disposed finally, my lord. My lord, they are charged the petitioner with the misuse of electricity. My lord. That was not correct, my lord. What has happened is, my lord, the petitioner obtained the electricity connection 2009 as per the 2008 tariff order. My lord, under the Electricity Act, KERC passes tariff order every year. November they publish it, January public hearing, February they pass orders. Under the 2009 order, my lord, this guest house was LT2A only. It was not 3. Then, my lord, my lordship will kindly see the respondents have filed objections, my lord. In that, my lordship.
His service was.
2009 in the 2A there was no fault. And
LT2A.
LT2A.
LT2A is residential purpose. LT3 is commercial.
Commercial.
Well, I not used for commercial anything like it was guest house of the company. Company had more than 500 employees. They had branches in Bombay and they used to come and they used to stay there. Well, there is no misuse of like that. Well, let's turn to page number 42 of the respondent's counter filed by the respondent.
You have the tariff with you, madam? Tariff.
My lord.
May
kindly see the page number 56 and 59.
2016 tariff order, they say the guest house is converted into LT3 into 3 anta. LT3 anta.
My statement of objections, my lords, may kindly see the page number.
I'm making submission, please.
Page number 56, my lord, Panchanama, my lord.
Next R5.
Yes, my lord, R5, my lord.
No, where is the tariff regulations?
Tariff is at 42, page 42, page 42.
Or counter line,
over there, over the counter ಅಲ್ಲಿ electric tariff order 2015-16 ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ page number 43 ನಲ್ಲಿ last page number 43 ನಲ್ಲಿ last sentence chowki rearing paying guests also. Paying guests LT2 ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಅವರೇ. LT2 ನಲ್ಲಿ 43 ನಲ್ಲಿ tariff schedule and LT2A. And paying guests also LT2A ನಲ್ಲಿ ಇದೆ. LT3 ಬಂದಿಲ್ಲ. Well, they are using regulation 42 telling that I misuse the power tariff and there's a penalty of 12 months alla ಹಾಕಿದ್ದಾರೆ. Section 126 of Electricity Act. There is a procedure laid down.
My lord, for LT3 tariff, my lords will get a page number 50 annexure R4, my lord.
Tariff order it is mentioned as the LT2A only. As per the documents produced by the respondent only. 2015, 16, the tariff order passed on 2/3, 2015, where this,
But in LT2, page number 44,
Yes,
they
my
talk about guest houses / travelers
Yes.
bungalows run in government buildings or by state, central government, religious, charitable institutions.
Yes,
So only these kind of guest houses, which are run by the state, will attract LT2.
yes, yes, Mel.
Others automatically.
Correct.
Lords may kindly see the page number
Mel-
50, my lord.
If it is converted LT3, they should notice say that your tariff is shifted from 2A to 3A. They should notice and proper inquiry has to be held on that one, not misuse of electricity. I not misuse. The tariff is shifted from 2A to 3 from 2015 and 16. There should notice on that one. My last two ten is section 126 Electricity Act. What the steps they have to take on that aspect? Electricity Act 126.
LT3 ಎಲ್ಲಿ ಬರುತ್ತೆ ಮೇಡಮ್?
My lords may kindly see the page
Next page ಅಲ್ಲಿ ಇದೆ sir.
Annexure R4, page number 49, operative page number 50, my lord. Item number 8, my lord, in that, page number 50, item number 8.
That does not
Private
amount
guest
to
house,
misuse, Mala. That is only tariff because of the KESC passed an order tariff from 2015
Item
that is
number
changed.
8 is the private guest
They
house,
should
my
issue
lord.
notice, Millard, stating that your tariff is from
What
2A
is the
to 3.
notice, what is the notice that is issued to you now?
Now they say they have misused the electricity and back billing for 12 months.
Where is the notice?
It is there, Millard. In my petition, Millard.
Demand notice is annexure,
Demand notice only, you have misused.
annexure
the-
A, my lord, in writ petition.
A1 to A14.
29-4, annexure A, my lord, in writ petition.
There also, they not follow the procedure laid down under section 126, Millard. That is also not proper, Millard. May I read section 126 of Electricity Act? Millard?
What is, you had filed an appeal also?
Yes, Millard.
File the appeal before the superintendent, second respondent, my lord. My lords may kindly see the
There also
finding
we had mentioned that
which will
not
be
properly-
available in
inspection report is not furnished, inspection report is shown.
131 of statement of objections, my lord, page number 131. my lord.
This premises is owned by whom?
The company, Millard, there are 14 flats, Millard. It's a flat building owned by the petitioner.
This Mukram
Mukram Millard. He is the owner of the company and also the 14 flats in the building. 14 flats in the building, 6 flats there you are using for a guest house. That is guests coming from Bombay, Mysore, Bangalore, everything, they were having the guest house. That guest house is kind of, as per 2009 tariff, Millard, it is coming to
When you
LT2
made
EMV.
you made the application for electricity connection.
LT2 2009.
What did you indicate?
Same 2 years. 2 years applicable to.
Domestic,
What did you indicate as a
I
house?
said
or as
guest house only. Guest house was,
no, my lord.
application?
Millard, guest house and application also ಇದೆ.
Application ಅಲ್ಲಿ ಮನೆಗೆ ಅಂತ ಹಾಕಿದ್ರೆ ಗೆಸ್ಟ್ ಹೌಸ್ಗೆ ಅಂತ ಹಾಕಿದ್ರ?
ಗೆಸ್ಟ್ ಹೌಸ್ ಅಂತ ಹಾಕಿ. ಗೆಸ್ಟ್ ಹೌಸ್ LT2 ಏನು ಬರುತ್ತೆ ಅವಾಗ?
No, my lord. They applied under
2009
LT2
ಗೆಸ್ಟ್ ಹೌಸ್ ಬರುತ್ತೆ.
My lord,
Do you have a copy of the application?
ಇದೆ ಅವರಲ್ಲಿ ಹಾಕಿದೆ ಸರ್.
my lords may kindly see the page number 61, my lord. It will clearly come to
This
know
is the
that
application.
whether it is a private guest
ಕೌಂಟ್ರಲ್
house.
ಹಾಕಿದ್ರು. ಅವ್ರ ಕೌಂಟ್ರಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನಕ್ಷ ಎ.
Our counter.
14 applications are there. Over the country. Countrally at page number.
Which number?
Page number 11 in the some annexion R1 ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ. This is my application. They considered and sanctioned it for LT2A. 14
lord-
meters.
My lords may
14 meters.
14 meters or something. The power sanctioned under LT2 will be reflecting in page number 39, annexure R2, my lord.
ಅವಾಗ LT2A ಏನೇ ಇತ್ತು 2009 ಅಲ್ಲಿ 16 ಅಲ್ಲಿ ತಾರೀಫ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ ಚೇಂಜ್ ಇಂಟು LT3. ಅದು ಅವರ ಫ್ರೆಶ್ ನೋಟಿಸ್ ಕೊಡಬೇಕಿತ್ತು ಈ ತಾರೀಫ್ ಇಸ್ ಚೇಂಜ್ ಫ್ರಮ್ 2A to 3 ಅಂತ.
ಯಾವ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಅವರು ಟಾರಿಫ್?
LT ಇದು 2009 ತಾರೀಫ್ ಆರ್ಡರ್.
ಅಲ್ಲ 2009 ಅಲ್ಲಿ ನೀವು ನಿಮ್ ಪ್ರಕಾರ ಒಪ್ಕೊಳ್ತೀನಿ ಅದು ಗೆಸ್ಟ್ ಹೌಸ್
LT2 ಏನಿತ್ತು
ಟ್ಯಾರಿಫ್ ಚೇಂಜ್ ಮಾಡಿದಾಗ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ? ಯಾವ ರೆಗ್ಯುಲೇಷನ್ ಇರುತ್ತೆ?
Some LT or they changed it by 2000 as per 42 page number 42 Miller. They changed it in 2015.
Does not indicate in this application as to why he was seeking for power supply. Does he state as to why?
ಅವಾಗ ಇದಂತಾನೆ ಕೊಟ್ಟರು ಸರ್, ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅಂತಾನೆ ಕೊಟ್ಟರು.
So company
ಫ್ಲಾಟ್ಸ್ ಮೇಲೆ ಫ್ಲಾಟ್ಸ್
ಕಂಪನಿ ಗೆಸ್ಟ್ ಹೌಸ್ ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ ಅದರಲ್ಲಿ.
6 ಫ್ಲಾಟ್ಸ್ ಗೆಸ್ಟ್ ಹೌಸ್ ಮಿಕ್ಕಿದೆಲ್ಲ ಓನ್ ಯೂಸ್ ಇಟ್ಕೊಂಡಿದೆ ಸರ್. Residency, that there's an agreement as tenants, there are tenants.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರ ನೀವು ಗೆಸ್ಟ್ ಹೌಸ್ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಂತ?
My lord,
ಅವಾಗ it was taken as residential 2009 ಅಲ್ಲಿ.
There was no option for them to then check and use or apply the tariff for guest houses.
Well, guest house is changed in 2015 only. Guest house in 2015 ali they are changing.
No, but this tariff that you just now showed first.
Yes,
that
madam.
makes it clear that it is guest houses run by the government alone or coming under LT2.
That
So all other guest houses.
15-16 tariff order guest house government ಬರಲ್ಲ, guest house comes under commercial ಅಂತ ಬಂದಿದ್ದು ಅದೇ next 43 ನಲ್ಲಿ ಇರ್ತದಲ್ಲ.
The implication of this particular tariff of the year 2009, which you referred to.
Yes, madam.
ಯಾವ page number?
2000 tariff order ಇಲ್ಲ sir.
one simple aspect, my lords, may kindly see the page number 60 of my statement of objections. Every answer will come on that document, my lord. This is the public service guest house, my lord, service apartment. The tariff is also written on the down, my lord, in page number 60, my lord. Single bedroom, 3,000. One bedroom with apartment, 6,000. This is they are running the guest house even till today, my lord. All the traveling websites, it's available, my lord. Even till today, my lord.
But whenever you did a meter reading, your people would know.
Yes, my lord. We came to know, my lord. I'll make a submission, my lord.
Isn't there a maximum period that you can claim? Can you go for 10
12
years?
months, 12 months, my lord.
And how much have you now asked for?
12 months only, my lord. As per
Section
42.2,
110 says
my lord.
6 months only.
My lord, we came to know on 9/4/2015, there is a misuse of tariff, my lord. Our vigilance has visited to their place and conducted the Panchanama. We came to know that this is using for the service apartment, my lord, and very much available in all the websites of the online, my lord, and booking is available, my lord. Based on that, we have done the Panchanama and we have issued the demand notice on 29/4/2015.
For 12 months.
For 12 months, back billing, as per the regulation 42.2, my lord, which will be available in my statement of objections. I produced that also. One.
Where is the regulation?
Annexure R8, page number 121, my lord. Misuse of tariff, my lord.
That is there 2 times a tariff applicable.
Yes, my lord. 12 months from the back billing immediately on the down bill, bottom to second line.
Basically, it's like for 2 years. We're going to charge at 2 times. For
Yes,
12
my
months. It's
with
basically
with penalty.
penalty like that.
This is the regulation framed by
And my
the.
lord, they have filed the appeal before the concerned authority. There also they clearly admits that they are using as the private guest house, which will come under the LT3, my lord. My lords, may kindly see the finding, page number 131 of my statement, 134 of my statement of objections, finding number 5.
This is the regulations framed by the KRC.
They themselves
it comes
admits, my
out
lord.
from the Electricity Act, my lord, section 126 of Electricity Act.
Yes.
126. If on an inspection of any place or premises or after inspection of the equipment, gadget, machines, device found and connected or used for after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment an electricity charge payable by such person or by any other person benefited by such person. The order of provisional assessment shall be provisional assessment has to be done. Provisional assessment, a person in occupation or possession of a charge on the place of premises in such manner as may be prescribed. The person on whom a notice has been served under subsection 2 shall be entitled to file objections, if any, against the provisional assessment before the assessing officer, who may, after affording a reasonable opportunity of hearing the such person, pass a final order of assessment of the electricity charges payable by such person. Any person served with the order provisional assessment may accept such assessment and deposit the assessed amount with a license within 7 days of service of such provisional assessment order upon him, provided that in case of provision of the person deposit of the assessment amount, he shall not be subject to any further liability or any action by any authority or whatever. If 5 is important, madam. If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, it shall be presumed that such unauthorized use of electricity was continued for a period of 3 months, immediately preceding the due date of inspection in case of domestic and agriculture services, and for a period of 6 months immediately preceded the date of inspection for all other categories of services unless the onus is repeated by the person occupied or person subject. Here they mentioned, so this is an act, my lord. What is their abilities and regulations framed by them? Regulation, they say 12 months.
These are in conformity with the.
It should be, they should be.
They are, isn't it? They did issue a provisional assessment order. They gave you a show cause notice.
Yes.
You filed objections.
Yes.
And thereafter final order is passed.
Alla provisional assessment ಅದು ಕೊಟ್ಟೇ ಇಲ್ಲ ನಮಗೆ. Inspection notice ಕೊಟ್ಟಿಲ್ಲ.
What is annexure A1? What is annexure A1?
29 for provisional assessment only, my lord. For
That
that,
is
they
Xerox
filed
copy, we got it from them afterwards. That was not served on us. Xerox copy we obtained after they sent a notice, we went to the office and got it.
My lords, may kindly see the page number 123 of my statement of objection. They filed the objections for provisional assessment also, which will be produced by before this.
Objections also ನಾವು ಹೇಳಿದೀವಿ. ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಟೈಮ್.
Objections ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ? Objections ಹಾಕಿದ್ರಾ?
ಅಲ್ಲ ಆಮೇಲೆ ಇದು ನೋಟಿಸ್ ಕಾಪಿ ತಗೊಂಡ್ಮೇಲೆ ಆಫೀಸ್ ಹೋಗಿ ನೋಟಿಸ್ Xerox copy ತಗೊಂಡ್ಮೇಲೆ we filed objection stating that we are not misused the authority.
There was a provisional assessment made. You responded to that. There's a final assessment order.
ಅಲ್ಲ
You filed an appeal is dismissed.
ಅಲ್ಲ ಪ್ರೊವಿಷನಲ್ ಅಸೆಸ್ಮೆಂಟ್ ಅಷ್ಟೇ ಕೊಟ್ಟೇ ಇಲ್ಲ ನಮ್ಗೆ. ಈ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಷ್ಟೇ ಅವ್ರಿಗೆ. ನಾವು ನೋಟಿಸ್ ಕೊಟ್ಟ ತಕ್ಷಣ ನಾವು ತಗೊಂಡು ಅದಕ್ಕೆ objection.
The notice indicated that wrong tariff is being applied to you. You are misusing the energy, the electricity for a purpose other than for which it was authorized. Therefore, we propose to change the tariff. For which you filed objections.
This is not a misuse of electricity, Mala. The tariff is changed by 2016. Tariff change of
The tariff that was applied to you was on the basis of the representation that you made, that you used for a house. It was used for a guest house.
It was used and as per 2009 order, 2009 permission.
That was a misuse.
No, 2009 it was not misuse, Mala. 2009 it was 2016 only they changed it.
Where is his objections page?
My lord, page number 127 below. Annexure R10 below.
Yes, 123, Mala.
Sorry, my lord.
123.
123 below.
The objections filed, Mala.
Annexure R9.
We have mentioned, Mala. May I read, Mala?
Yes.
Para 1, Mala. First of all, above referred notices along with other 14 insured or even though it is dated.
You did receive the notice dated 29/4/2015.
Yes, my lord.
Notice
only this.
You have received this notice on dated 29/4/2015.
We collected it afterwards, Mala, from there.
Did you collect it or not?
Yes,
You don't say that you have received it. 29/4/2015 is annexure A1.
For
which you have filed objections.
Para 2 of my objection, Mala. Para 2 of my objections. MK International is a group of companies with the manufacturing and trading businesses which has employed about 500 employees across all the companies situated at Mysore, Bangalore and other places with a registered office situated at Mysore. Our employees and executives will be visiting the registered office and to accommodate them for overnight stays. We have the apartment building situated at number so and so next to there Mysore and named at the MK Pharma. This apartment is our own building constructed for the purpose of using that all our own guest house or our company completes and guests, and it is not being used for any commercial purpose. This building is having kV power supply connected with 14 different meters with LT2A sanction and connection tariff. Against all the 14 orders, you have sent the Xerox copy of the demand notice bearing number so and so. All of them dated 29/4/2005 by conveying our conditions from LT2 to LT3 and also back billing to previous 12 months from 18/3/2015 to 12/4/2014, which with the double penal rates based on the alleged inspection made by 9/4/2015 by the assistant executive engineer LT range of Mysore. the details of the demand of back billing or RR number so and so, so and so. From all the above demand notice, it is found that the inspection report number and the dates are mentioned as nil, and we are at loss to know and understand on what basis the whole report you have made the back billing for 12 months on the basis of LT3. It is clear from the demands and notice that there is no inspection or report submitted by anybody, and without any proper application of mind, asserting the real facts, and without any basis, you have issued the above demand notices, which are illegal, arbitrary, and unjust, which required to be withdrawn. The demand notices ought to have contain the proper information and provided the opportunity for filing our objections, if any, and also the personal hearing is denied. Hence, the demand notice cannot be implemented and need to be withdrawn immediately. Insofar as LC so and so, in all other demand notices for the remaining RR numbers, the demand amount is arrived based on a logical formula and basis. Therefore, all the 14 demand notices are illegal, arbitrary in the same. Para 6 also. It is submitted that none of your officers have visited our premises on 19/4/2015 for inspection as alleged by you, and there is no report as such, and you have issued the said demand notices based on no materials or report. If there was any such report by any of your officers, a copy of such report should have been given to us. We have not received any copy of such a alleged report, and in the absence of such an alleged report, the demand notices raised by you is arbitrary, illegal, unjust, and just to harass us, since demand notices have been issued. Hence, it is required to be withdrawn immediately. This is what I mentioned in the objection. My lord, when the tariff change, it is duty of the respondent to inform us that your tariff is changed from 2A to 3A. That is not done. They say that you are misusing. There is no question of misuse. The same use only I'm making it. If they have changed the tariff manner, they should be fresh notice stating that is not issue. If they had issued that one, I would have followed that to 3 only. That they are not done. They go on telling that I misused. They go for inspection, say that it has been misused and using for 3 and all. That was not correct, man. In that connection, Mela, there are 2 citations, Mela, which I could not get it right now, Mela. Tomorrow I'll produce it and Monday, Mela. Citation because in the section 126 ಬೇರೆ ಫೈಲ್ ಇತ್ತು 126 ಅಲ್ಲಿ there's a judgment that the proper procedure has to be followed ಅಂತಿದೆ
230 ಕೊಡು 232
ಇದೆಲ್ಲ ಆಫೀಸ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಫೈಲ್ ಆಗಿ ಮಾಡಿದ್ರಲ್ಲಿ ಇದೆ ಮಂಡೇ ಮೇಲೆ ಶಿಪ್ಮೆಂಟ್
ರಿಸರ್ವ್
ಮಂಡೇ ಮೇಲೆ ಶಿಪ್ಮೆಂಟ್
ನೀವು ಕೊಡಿ 3 ದಿನದಲ್ಲಿ ಕೊಡಿ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ತೀನಿ give it within 3 days
ಮಂಡೇ
give it to the court officer good enough.
My lord, as on today, there is a balance of 64 lakhs, my lord, they are misusing.
For admission, seal number 22, Sri Rahul S. Reddy.
On the last date, respondent wanted to produce some appearing for the respondent, my lord. The document which I am going to rely, the same documents have been produced by the police along with the charge sheet. If my lord's permits, I will rely upon the document where the petitioner has purchased the property under the GPA, my lord. I'm requesting Ross to kindly see why this.
Let us see your complaint first. What is your complaint?
Please, my lord. Please, my lord. Please, my lord. The complaint and the typed copy is at page number. They have not served the proper page number sets, but I have a paper, my lord. I will go through the, if not. ನಾನು ಈ ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ತಾಯಿ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತೇನೆ ಹಾಗೂ ಸ್ವಂತ ಬಿಸ್ನೆಸ್ ಮಾಡಿ ಜೀವನ ನಡೆಸುತ್ತಿರುತ್ತೇನೆ. ಚಳಿಕರಿಗಮನದ ಸರ್ವೆ ನಂಬರ್ 86/2 ಮತ್ತು 87/2 ರಲ್ಲಿ ಕ್ರಮವಾಗಿ 16 ಗುಂಟೆ ಮತ್ತು 17 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಾಗವನ್ನು ನನ್ನ ತಂದೆಯವರಾದ ಶ್ರೀ ಗೋಪಾಲಕೃಷ್ಣ ರೆಡ್ಡಿಯವರು, ನಾನು ದೊಡ್ಡಪ್ಪರವರಾದ ಶ್ರೀ CP ರಾಮಯ್ಯ ರೆಡ್ಡಿ, ನಾನು ಚಿಕ್ಕಪ್ಪ P ಶಂಕರ್ ರೆಡ್ಡಿಯವರು 1980ರಲ್ಲಿ ಪಂಚಾಯಿತಿ ಪಾಲುಪಟ್ಟಿಯಂತೆ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದು, ಸದರಿ ಪಾಲುಪಟ್ಟಿಯನ್ನು 1994ರಲ್ಲಿ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ಮುಖೇನ ಒಪ್ಪಿಕೊಂಡು ಪ್ರಕರಣ ಮುಕ್ತಾಯಗೊಳಿಸಿರುತ್ತಾರೆ. ತದನಂತರ ನನ್ನ ಚಿಕ್ಕಪ್ಪ ಶ್ರೀ ಶಂಕರ್ ರೆಡ್ಡಿ ಹಾಗೂ ದೊಡ್ಡಪ್ಪ ರಾಮಯ್ಯ ರೆಡ್ಡಿ ಅವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 87/2 ಜಂಟಿಯಾಗಿ 11 ಗುಂಟೆ ಬಂದಿದ್ದು, ನನ್ನ ತಂದೆ ಗೋಪಾಲಕೃಷ್ಣ ರೆಡ್ಡಿ ಅವರಿಗೆ 5 ಗುಂಟೆ ಹಾಗೂ 1 ಗುಂಟೆ ಖರಾಬ್ ಜಾಗ ಬಂದಿರುತ್ತದೆ.
5 guntahs and 1 guntah.
Please, my lord.
That is in which survey number?
Survey number 87/2.
Listen. Your father got 5 guntahs plus 1 guntah of Karab.
Please, my lord.
After the partition amongst his brothers.
Please, my lord.
Yes.
ನನ್ನ ಚಿಕ್ಕಪ್ಪ ಮತ್ತು ದೊಡ್ಡಪ್ಪನವರಿಗೆ ಯಾವುದೇ ಉದ್ಯೋಗವಿಲ್ಲದೆ ಕಾರಣ ಅವರ ಪಾಲಿಗೆ ಬಂದಿರುವ ಸ್ವತ್ತುಗಳನ್ನು ನಿವೇಶಗಳನ್ನಾಗಿ ವಿಂಗಡಿಸಿ ನನ್ನ ತಂದೆಯವರ ಮುಖೇನ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಇವರು ಯಾರ್ಯಾರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ ಎಂಬುದು ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಆಗ ನನಗೆ 22 ವರ್ಷದವನಾಗಿದ್ದು ತಿಳುವಳಿಕೆ ಉಳ್ಳವನಾಗಿರುತ್ತಾನೆ. ನನ್ನ ತಂದೆ ಶ್ರೀ ಗೋಪಾಲ್ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಅವರು 13/2/2007. This is important, my lord. This date of death.
So the property which fell to your uncle's share was sold through your father.
Please, my lord.
That
The
is-
3 brothers have entered into a GPA.
That is 12 guntas that they had got.
Please, my lord, whatever the shares they have got under the partition.
The complaint indicates
Please,
12 guntas was given to your uncles
please, my lord.
and 5 guntas plus 1 gunta crop was given to you.
Please, my lord. Please,
Now 12 guntas they formed sites and sold.
Told
You
me.
also admit.
Please, my lord.
So 5
Nothing
guntas was
remains
all
in-
that remained with your father.
Nothing remains in survey number 87/2 and 86/2. Please, my lord. The date of death is 13/2/2007. That's the complaint's father. ಹಾಗೂ ನನ್ನ ಚಿಕ್ಕಪ್ಪ ಶಂಕರ್ ರೆಡ್ಡಿ, that is the father of the petitioner who died on 27/7/2010. These 2 dates are important by filing the present case, my lord. ನನ್ನ ತಂದೆಯವರ ನಿಧನ ನಂತರ ನನ್ನ ತಂದೆಯವರ ಪಾಲಿಗೆ ಬಂದಿದ್ದ ಸ್ವತ್ತನ್ನು ನನ್ನ ತಾಯಿ ಶ್ರೀಮತಿ ಚಿನ್ನಮ್ಮರವರ ಹೆಸರಿಗೆ ಪಾವತಿ ಖಾತೆ ಮಾಡಿಸಿರಲಾಗಿರುತ್ತದೆ. ಈಗಿರುವಾಗ ಈ ಮಧ್ಯೆ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಕೋ ನಾರಾಯಣ ರೆಡ್ಡಿ 46 ವರ್ಷ ಇವರಿಗೆ 23/8/1989 ನನ್ನ ತಂದೆ ಗೋಪಾಲ್ ಕೃಷ್ಣ ರೆಡ್ಡಿ, ನನ್ನ ದೊಡ್ಡಪ್ಪ ಶ್ರೀ ರಾಮಯ್ಯ ರೆಡ್ಡಿ, ಚಿಕ್ಕಪ್ಪ ಶಂಕರ್ ರೆಡ್ಡಿ ಸೇರಿ ಚಳಕೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 86/2, 87/2 1ರಿಂದ 7ನೇ ನಿವೇಶಗಳನ್ನು GPA ನೀಡಿರುವಂತೆ ದಾಖಲೆ ಸೃಷ್ಟಿಸಿ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ.
So
ಆದರೆ
site number 1 to 7
1 to 7 ಮೊಲ
had been alienated by way of a GPA to Ratnam.
by Ratnamma, so called GPA holder of all these 3 brothers, my lord.
So you admit the GPA executed by your father.
No, my lord, it has been disputed.
ಅಲ್ಲ ನೀವು ಬರೆದಿರೋದು ಈಗಿರುವಾಗ
ಅದು ಹೀಗಿರುವಾಗ ಸೃಷ್ಟಿಸಿ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ.
ಅಲ್ಲಿ ನನ್ನ ತಂದೆ
ಆದರೆ ನನ್ನ ತಂದೆ, ನನ್ನ ದೊಡ್ಡಪ್ಪ ಮತ್ತು ಚಿಕ್ಕಪ್ಪರವರ ಸಹಿಗಳನ್ನು ನಕಲು ಮಾಡಿ ಮಾರಾಟ ಮಾಡಿರುವುದು ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ
you say is forged.
forced, and it is handwriting expert is at page number 129. It is says different. ಮಾರಾಟ ಮಾಡಿರುವುದು ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ನನ್ನ ತಂದೆ ದೊಡ್ಡಪ್ಪ ಮತ್ತು ಚಿಕ್ಕಪ್ಪರು ತಮ್ಮಲ್ಲಿ ಒಪ್ಪಂದ ಪತ್ರವನ್ನು 12/2/1995 ಮಾಡಿಕೊಂಡಿದ್ದು, ಸದರಿ ಪತ್ರದಲ್ಲಿರುವ ರುಜುಗಳು ಮತ್ತು ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಎಂಬುವರಿಗೆ ಮಾಡಿಕೊಟ್ಟಿರುವ GPA ಪತ್ರದಲ್ಲಿನ ರುಜುಗಳು ವ್ಯತ್ಯಾಸ ಇರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತದೆ. ಈ ಮಧ್ಯೆ ದಿನಾಂಕ 26/9/2012 ಶ್ರೀಮತಿ ರತ್ನಮ್ಮನವರು ನನ್ನ ಚಿಕ್ಕಪ್ಪನಾದ ಲೇಟ್ ಶಂಕರ್ ರೆಡ್ಡಿಯವರ ಮಗ ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್, ದಟ್ ಈಸ್ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಎಂಬುವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 86/2 ಮತ್ತು 87/2 ರಲ್ಲಿನ ನಿವೇಶನ ಸಂಖ್ಯೆ 4 ಮತ್ತು 5 ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 1.5 ಅಡಿಗಳನ್ನು
Site number 4 and 5.
4 and 5.
In which survey number?
Survey number 86/2 and 87/2.
Sold to petitioner.
No, it has been purchased by the petitioner through a GPA holder.
Is sold to petitioner.
Please, please.
Ratnam on the basis of the GPA.
Please, my lord. ನೋಂದಣಿ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ನನ್ನ ಅತ್ತೆಯವರಾದ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀದೇವರು ಕುಟುಂಬದ ಆಸ್ತಿ ವಿಚಾರದಲ್ಲಿ ಭಾಗಂಶಕ್ಕಾಗಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS ನಂಬರ್ ಸೋ ಅನ್ನು ನಮ್ಮೆಲ್ಲರ ವಿರುದ್ಧ ದಾವೆ ಹೂಡಿದ್ದು ಪ್ರಕರಣವು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿರುತ್ತದೆ. Now I am requesting my lord to kindly
there is a compromise decree, my lord.
Now we'll come to that, my lord. My lord, kindly see the sale deed.
Complete the reading of.
Yes, my lord. Please, my lord. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 86/2, 87/2 ರಲ್ಲಿನ ನಿವೇಶನ ಸಂಖ್ಯೆ 4 ಮತ್ತು 5 ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ, ಸೋ ಅಂಡ್ ಸೋ ಮೆಜರ್ಮೆಂಟ್ 2691 ಅಡಿಗಳ ನಿವೇಶಗಳನ್ನು ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀದೇವಿ ಎಂಬುವರು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಾಡಿದಂತೆ ದಿನಾಂಕ 27/12/2013 ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್ ಎಂಬುವರಿಗೆ ನೋಂದಣಿ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ರಂತೆ ಮಾಡಿ ಕೊಟ್ಟಿರುವಂತೆ ದಾಖಲೆ ಸೃಷ್ಟಿಸುತ್ತಾರೆ.
So your auntie also executed confirmation in this.
The same auntie has filed a suit for partition regarding the very same property.
But she has executed a confirmation deed.
That is also
What is the date?
created document, my lord. The same person has filed a
What is the
suit.
date? 27/12/2013.
Please, my lord. 27/12/2013.
Lakshmi Devi.
Lakshmi Devi. She has filed suit OS number 4/4/2005 regarding the very same scheduled property, seeking partition.
Site number 4 and 5.
Please, my lord.
Yes.
ಆದರೆ ಸದರಿ ನೋಂದಣಿ ಮಾಡಿಕೊಟ್ಟಿರುವ ಪತ್ರದಲ್ಲಿರುವ ಭಾವಚಿತ್ರದಲ್ಲಿರುವ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀದೇವಿಗೂ ಹಾಗೂ ಅಸಲಿ ನನ್ನ ಅತ್ತೆ ಲಕ್ಷ್ಮೀದೇವಿಗೂ ತಾಳೆ ಇರುವುದಿಲ್ಲ. There are two altogether different persons claimed by the petitioner as she is unearned, and another two persons which have executed the sale deed on through the GPA. They
So
both
you are
are
saying
different persons.
You are saying that the confirmation deed that is obtained by him is also fraudulent.
Fraudulent, my lord. The handwriting experts give their report saying that all signature and names have been different.
And Lakshmi Devi has not filed any complaint.
She has not filed a complaint. She has filed a suit for partition and separate position.
She has not raised any grievance
No, my
about
lord.
the confirmation deed.
No.
You are only raising the grievance about the
The
confirmation.
the reason I will come to later stage, my lord. I will complete with permission of the court, I will complete the complaint.
Yes.
ಈ ಮಧ್ಯೆ ಸದರಿ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಎಂಬುವರು ಮಾರಾಟ ಮಾಡಿರುವ ದಾಖಲೆ ಪತ್ರಗಳಿನ ಭಾವಚಿತ್ರಗಳು, ದಾಖಲೆ ಸಂಖ್ಯೆ, ನೋಂದಣಿಯಾಗಿರುವ ಸೋ ಅಂಡ್ ಸೋ, ರತ್ನಮ್ಮ ಭಾವಚಿತ್ರಗಳು ಬೇರೆ ಬೇರೆಯಾಗಿದ್ದು, ಸದರಿ ಪತ್ರಗಳಲ್ಲಿರುವ ರತ್ನಮ್ಮ ಅವರ ವಯಸ್ಸು ಅಜಗಜಾಂತರದಿಂದ ಕೂಡಿರುತ್ತದೆ. 1989ರಲ್ಲಿ ಮಾಡಿರುವ GPA ಪತ್ರದಲ್ಲಿರುವ ರತ್ನಮ್ಮ ಅವರ ವಯಸ್ಸು 46 ಎಂದಿದ್ದು, ನೋಂದಣಿ ಪತ್ರದಲ್ಲಿರುವ ವಯಸ್ಸು 50 ಮಾಲಾಡು. ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, 30 ವರ್ಷ ಆದ್ಮೇಲೆ ಅವರಿಗೆ ಜಸ್ಟ್ 3 years ಅಂತ ತೋರಿಸ್ತಾರೆ. ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ she completed 30 years of her age is 50 years. ಇನ್ನೊಂದು ಪತ್ರದಲ್ಲಿ 69 ವರ್ಷಗಳೆಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ. In one GPA she is 40, another one GPA she is 50, another third GPA she is 69 my lord. ಈ ನಡುವೆ ನಿವೇಶಗಳನ್ನು ಕಬಳಿಸಿರುವ ವಿಚಾರ ತಿಳಿದು ನಾನು 4/12/2015 ಬೆಳಗ್ಗೆ ಸುಮಾರು 10 ಗಂಟೆಗೆ ಸರ್ವೆ ನಂಬರ್ 86/2, 87/2 ರಲ್ಲಿ ನಮ್ಮ ನಿವೇಶಕನ ಬಳಿ ಹೋದಾಗ ಅಲ್ಲಿದ್ದ ರಂಜಿತ್ ಕುಮಾರ್ ಎಂಬುವರು ಹಾಜರಿದ್ದು ಇವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ನಮಗೆ ಸೇರಿದ ಮೇಲ್ಕಂಡ 6 ಗುಂಟೆ ಜಮೀನನ್ನು 5+1 as per the partition deed ಜಮೀನನ್ನು ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಮಾರಾಟ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿ ನಮಗೆ ಸ್ವತ್ತಿನಲ್ಲಿ ಪ್ರವೇಶ ಮಾಡದಂತೆ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ಇದರಲ್ಲದೆ ಶ್ರೀ ಯಲ್ಲಪ್ಪ ಎಂಬುವರು ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಅವರ ಕಡೆಯಿಂದ ನಿವೇಶನ ಸಂಖ್ಯೆ 1, 2, 3 ಖರೀದಿ ಮಾಡಿರುವುದು ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಶ್ರೀ ಯಲ್ಲಪ್ಪ ಅವರು ಸಹ ಅನಿಲ್ ಕುಮಾರ್ ಅವರೊಂದಿಗೆ ಬಂದು ನಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ಬೆದರಿಕೆ ಹಾಕಿದ್ದಲ್ಲದೆ ನಮ್ಮಗಳ ಉಳಿದೆಲ್ಲ ಸ್ವತ್ತುಗಳನ್ನು ಇದೇ ರೀತಿ ಕಬಳಿಸುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. Therefore, the action may be
According to the arguments in the complaint,
please no.
site number 4 and 5 were sold by Ratnamma on the basis of the GPA to the petitioner.
Please madam.
This was confirmed by Lakshmi Devi in the confirmation deed.
No my lord, there are two different sale deeds. One is Ratnamma to
ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಹೇಳೋದು ಅದೇ. Site number
complaint
4 and 5, Ratnamma sold on the basis of GPA.
ಇಲ್ಲ, Ratnamma has sold two sites. Two sites.
Site number 4 and 5.
One sale is from Ratnamma to another person, that is Yellappa. One site is Ratnamma to the petitioner.
There. Petitioner is 4 and 5.
4 and 5. Site number 4 and 5.
Complaint ಪ್ರಕಾರ Ratnamma sold site number 4 and 5 on the basis of a forged GPA. Correct?
Please my lord.
Alva? Lakshmi Devi had filed a suit against you.
Please my lord.
Devi went
Against
and
the
executed a confirmation deed in his favor.
Please.
That also you say is a bogus confirmation.
Please my lord.
Correct.
Please.
So your claim is of site number 4 and 5.
Please.
Which according to you belongs to you, your
Please my
father,
lord. Please my lord.
isn't it?
Please. Now my lord, I am requesting my lords to kindly see the sale deed by the petitioner at page number 54 in the charge sheet. This is the reason why the complaint has been lodged. This is the reason why the charge sheet has been registered by the police. Page number 54. ನೋಡಿ, ಇದು ನೋಡಿ.
Now you first have to tell me as to what is the rate over site number 4 and 5.
4 and 5 sites have been allotted.
What is there to show that it belonged to your father?
Please my lord. They only have produced before this honorable court as the decree of the civil court. I will.
That is the decree passed in OS.
US number 1844 my lord. My lord, only before going to the decree of the civil court, I am requesting my lords to kindly see the sale deed dated.
First ನಂಗೆ site number 4 and 5 ನಿಮ್ದು ಅಂತ ತೋರಿಸಿ, then I will examine all the other things.
Please my lord.
This is the OS 1844/1995.
Please my lord. Yes, the petitioner has filed a memo.
Your father's name is Gopal Krishna Reddy.
Please my lord.
And your uncles are Ramay Reddy and Shankar Reddy.
Shankar Reddy my lord.
Alva?
Please my lord, please.
Page number 6, they have allotted. Page number 6, para 2, my lord.
That is not right. Requesting lords to kindly see the page number 4 of the memo filed by the petitioner.
Read from para 3 itself. Page 3.
Page 3 my lord.
It is ordered.
Interim compromise petition. It is ordered and decreed that the first defendant number 1, Sri Gopal Krishna Reddy, is hereby allotted a portion of the suit schedule property in item number 1 and 2, which is more fully described here in under towards its share. It is further ordered and decreed that A scheduled properties were allotted to the share of the plaintiff, B scheduled properties were allotted to the share of first defendant, and C scheduled properties were allotted to the share of the second defendant. In the said partition deed dated 24/3/1989, and they were in possession and enjoyment of the properties allotted to their respective share as absolute owners. Now, my lords, next para is the important. It is further ordered and decreed that as per the partition deed dated 24/3/1989, the properties bearing number survey number 1/1, 86/2, 87/2. These are the properties now before my lord, issues before my lords. 87/2 of the Chalkere village measuring 1 acre 29 guntas and 15 guntas and 16 guntas in extent respectively was in joint possession and enjoyment of the plaintiff and defendant number 1 and 2. After the partition deed, the plaintiff and defendant number 1 and 2 have made layouts of site in the said survey numbers. It means, my lords, the petitioner father and the elder brother have made a layout and they have sold the entire sites to the different persons. And they have sold the sites to the different persons, and the first defendant, that is
Have
the
sold the sites to different persons. And the first defendant has sold the sites as a GPA holder
Yes.
on behalf of plaintiffs.
and the defendant number 2. So my father has
So you
sold the
have
property.
Sold all the sites that were formed in 1/1, 86/2 and 87/2 on the base of a
GPA. Please, madam. Next line, madam. Next line. Plaintiff and defendant number 2. And the plaintiff and defendant number 1 and 2 have no manner of right, title, interest, or position of any kind over the site sold in survey number 1/1, 86/2, 87/2 of Chalkere, Kerpura Hobli, Bangalore.
So there is a clear admission by our father
Please,
that
madam.
certain sites were sold.
Please,
And none of the brothers
Please.
had any right over the properties are already sold.
Please, madam.
Correct?
Please.
Now next paragraph.
Next, my lord. It is page number 6, page number 5, first
Please
paragraph.
read para 4
Please.
again.
It is further ordered and decreed that the plaintiff and defendant number 1 and 2 have also jointly retained site number 1 and 2 formed in survey number 1/1, measuring east to west 33 feet, north to south 60 feet, and bounded on east.
Then ಅದು apply ಆಗಲ್ಲ.
But
1/1 apply ಆಗಲ್ಲ.
survey number 1/1 is not under the my lord. Page number 5, first para is important, my lord. It is further ordered and decreed that it is open for the parties to enjoy the properties allotted to their respective shares as shown in the partition deed dated 24/3/1989, and as per the schedule, except survey number 1/1, 86/2, 87/2 of Chalkere village, Kerpura Hobli, Bangalore East Taluk. Except
The properties other than 1/1, 86/2 and 87/2
please, madam.
will not be disturbed. It will go by the earlier partition.
Please, madam.
So 1/1, 86/2, 87/2 will go by this compromise.
Please, madam. Now, I am requesting Maharaj to kindly see page number 6. The properties allotted to the share of the first dependent, that is the complaint's father. Second para, my lord. 2 sites bearing number 14 and 15, measuring east to west, northern side 60 feet, southern side 80 feet, northern to south eastern side 42 feet, western side 30 feet, have also been retained in survey number 86/2 and commonly bounded on east and so. Except the above 3 sites, the first defendant has no right, interest, or position of the kind.
Your father had one site in 1/1.
Please, my lord.
Site number 14 and 15 in 86/2. Apart from this, your father had no other property
my lord.
in 87/2.
86/2 and 87/2, the complaints father has
Not
3
87
sites.
Not 87/2. 1/1 is one site.
One site.
Correct?
Please, my
Then
lord.
2 sites bearing 14 and
sites.
15, measuring so and so, and also so retained in survey number 86/2. Ashte, not in 87/2.
Written in 86.
So you don't have any right over the site number 4 and 5.
Only 3 sites, the
Your
father
father had only
complaint.
site number 14, 15, and that was in 86/2.
Please, my lord.
87/2, you have no right now.
Please, my lord.
Now your complaint is completely different.
No, my lord.
Your complaint is in respect of site which your father did not even own.
No, my lord. The partition deed says the complaints father has 3 sites as per the compromise petition as well as the decree of the civil code. The same partition deed, the same decree of the trial code does not say not a single site is owned by the father of the
That is not
petitioner.
your concern. Your father owned site number 14 and 15 in survey number 86/2.
No,
The complaint that you have given
Please.
is in respect of survey site number 4 and 5.
4 and 5, my lord.
Over which your father had absolutely no right.
No,
If your father had no right over 4 and 5, How can you even maintain the complaint?
No, my
If
lord,
that site belongs to somebody else.
that's the reason, my lord. The same sites have been changed khata numbers. Now earlier it is,
Complaint
please, my lord,
madre ಏನ್ ಮಾಡಕ್ಕೆ?
my lord, the same site have been referred as site number 4 and 5. Now the khata number is different and site numbers have been also changed. The petitioner has filed a suit for the very same properties for partition separate portion. Total 11 suits have been filed by the petitioner.
Last date also the
Your
same thing
complaint
is.
will have to go. Your complaint can't be maintained in the light of this compromise which you do not dispute.
My lord, the issue is for the survey numbers and issue is for the extent of the land. It is a civil dispute. One thing, my lord, I am admitted it. I am admitting the fact. But I am requesting my lords to kindly see how the property has come to the share of the plaintiff, how he has made fraudulent on the papers,
ಅದು
how he has created the documents.
ಅದು ನಿಮ್ ಸೈಟ್ ಅಲ್ಲ ಅಂದ್ರೆ ನೀವು ತಲೆ
ಅಲ್ಲ, ನನ್ನ ಸೈಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರದ್ದು ಸೈಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು ಸೇಲ್ ಡೇಟ್ ನೋಡ್ಕೊಳ್ಳಿ ಒಂದು.
ನಿಮ್ ಸೈಟ್ ಅಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಯಾರಿದೆಯೋ ಓನರ್ ಅವ್ರು ಬರ್ತಾರೆ, ಅವ್ರ ಮೇಲೆ ಹೋಗ್ತಾರೆ.
No, my lord, no,
ನಾಟ್ ಎಕ್ಸ್ಪೋಸಿಂಗ್
there is no sites available, only 3 sites available as per the partition deed.
Your complaint gives a distinct impression that your father retained site number 4 and 5.
3 sites. That's it.
Your complaint categorically states site number 4 and 5 are that of your father.
Please, my lord.
The compromise petition that is produced, which is not in dispute, nullifies that for a particular assertion.
Please, my lord, I do agree, my
Your
lord. I do
complaint is
agree, my lord.
false.
I do agree, my lord. The survey site numbers have been changed, but the site only 3 sites remains in that survey number 86 but 2 and 87 but 2.
I will
There are 3
permit you
sites
to-
belongs to.
I'll permit you to urge all this contention a civil suit that you may institute. Sitting cell posh.
My lord, kindly see the sale deed, my lord. That's the only last request before this honorable court, my lord. Then thereafter I'll leave it to the court.
Say Ratnama ಬರ್ಕೊಟ್ಟಿದ್ದು.
No, no, no. The property which has been purchased by the petitioner.
Ratnama ಬರ್ಕೊಟ್ಟಿದ್ದಾನೆ.
Ratnama, through Ratnama, ಅದನ್ನ ಒಂದು ಸಲ ತಾವು ನೋಡಿದೆ. ಅದಾದ್ಮೇಲೆ ನಾನು I don't have any arguments, my lord.
Yes.
The only sale deed dated 26/9/2012.
ಇಲ್ಲಿದೆ.
ನಾನು ಕೊಟ್ಟಿದ್ದ ಪೇಜ್ ಅಲ್ಲಿ 54 ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 54 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
When did you produce it? Where is it produced?
ನೋಡಿ.
The sale date dated
26/9/2012 purchased by Mr. Petitioner.
ಎಲ್ಲಿ produce ಮಾಡಿದ್ರೆ?
Even I don't have a copy, madam.
ಇದನ್ನೇ ತೋರಿಸ್ಬಿಟ್ಟು.
Then who gave it to you?
Please, madam.
ಯಾವ್ದು ಯಾವ
ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ.
First part of charge sheet.
Part and parcel of the charge sheet.
Photos.
ಕೊಡಿ ಸರಿ. My lord, this is the sale deed dated 26/9/2012. The names Ramaya Reddy, Gopal Krishna Reddy, Shankar Reddy. Shankar Reddy is the father of the petitioner and Gopal Krishna Reddy is the father of the complainant. My lord, the sale deed dated 26/9/12. My lord, the petitioner here is the practicing advocate who knows his father died on 27/7/2010. And the complaint's father who died on 13/2/2007. The property has come to his share through a GPA executed by his father and his uncles.
ತಂದೆ ಹೆಸರೇನು?
Shankar Reddy, who died on 27/7/2010.
Was the second defendant.
Shankar defendant, my lord. The GPA, the property has been come to the plaintiff's position through a registered sale deed executed by a GP holder. Executants are no more. His father was died on.
So he was basically buying his father's own property.
Father's own property and his uncle's through a GPA person, my lord. His father died on.
We will assume that this GPA is null and void.
Please, my lord.
Even then, he was basically purchasing the property that belonged to his father and his uncles. Correct?
Through his uncles.
The property that he purchased was a property which belonged to his father.
No, my lord. It is not his father, my lord. The partition deed as well as the decree of the court says.
The sale deed is by 3 persons through a GPA holder.
Please, my lord.
So the purchaser admits that the property was owned by Ramaya Reddy, Gopal Krishna Reddy and Shankar Reddy.
Please, my lord.
So he was essentially buying the property of 3 people, one of whom happened to be his father.
Please, my lord.
Now his father is dead and so is his uncle Gopal Krishna Reddy.
Also died.
So the GPA is of no consequence.
Please, my lord.
Correct?
Please.
He is purchasing the property of 3 people, 2 of whom are dead.
Please, my lord.
Therefore, according to the GPA, did not exist.
Please, my lord.
Correct?
Please.
There's a compromise petition amongst these 3 people in which it is admitted that your father did not own any of the sites that he was purchasing. So if your father does not own any property which he was purchasing, you cannot even maintain a complaint.
This is true, my lord, in the state Panchayat Parikat as well as the partition.
You are
DA.
forcing me to give a finding unnecessarily.
No, my lord.
I
There
will
are
give you
only three
liberty.
sites available in that decree as well as the
ಮೂರೇ
partition.
ಮೂರು ಉಳಿದಿರೋದು ಅದಕ್ಕೆ ಜಗಳ ಆಡ್ತಿರೋದು. ಅವ್ನು ಹೋಗಿ ವಾಪಸ್ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾನೆ, ಅದಕ್ಕೆ ಗಲಾಟೆ ಆಗ್ತಿರೋದು.
ಕೊಂಡ್ಕೊಂಡ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಂಡ್ಕೊಳ್ಳಿ. ಸತ್ತವ್ರ
Well, there is a dispute.
ಕೊಂಡ್ಕೊಂಡಿದ್ದಾನೆ ಇಷ್ಟೇ. ಅದು ಪೊಸಿಷನ್ ನನ್ನ ಹತ್ರನೇ ಇದೆ ಇವತ್ತಿಗೂ.
You are forcing me to give a finding that you have no right. When a complaint was lodged by the second respondent on 10/12/2015, contending that his uncle C.P. Ramaya Reddy, P. Shankar Reddy, and his father Gopal Krishna Reddy, alva, owned properties bearing serial number 86/2 and 87/2. And they had also entered into a partition in the year 1989. And they had acknowledged this partition in a civil suit in 1994. He stated that his uncles were allotted 11 guntas in 87/2, while his father was allotted 5 guntas plus 1 gunta of Karab in 87/2. He also admitted that his uncles had farmed sites and had sold the same through his father. And he was also aware as to whom his father had sold the sites. He stated that his father, Gopal Krishna Reddy, had passed away on 13/2/2007, while his younger uncle, Shankar Reddy, had passed away on 27/10/2010. And on the death of his father, the property that had fallen to his father's share had been succeeded to by him and his family members, and the Kata was mutated in the name of his mother, Chinnam. He stated that one Ratnama claimed that she had obtained a GPA dated 23/8/89 from her father and his uncles in respect of site numbers 1 to 7 formed in serial number 86/2 and 87/2. And this GPA was a forged GPA. It was stated that his father and his uncles had entered into a settlement letter on 12/2/1995. And in the said letter, if the signatures contained therein of his father and uncles were compared to the signatures found on the GPA obtained by Ratnamma, it was clear that the signatures did not tally. He also stated that on 26/9/2012, the said Ratnamma had sold site number 4 and 5, carved out to serial number 86/2 and 87/2 in favor of Anil Kumar, the son of his uncle Shankar Reddy, who incidentally is the petitioner herein. He submitted that the sale deed was sold the properties. He submitted that his aunt, Sri Lakshmi Devi, had instituted a suit in OS 404/2005, seeking for partition. And notwithstanding the said suit, she had executed a confirmation deed in favor of the petitioner. He contended that in the confirmation deed also, the photograph of Srimati Lakshmi Devi was not tallying with the actual photograph of Lakshmi Devi, and neither did the signatures tally. The complaint, he also contended that the signatures found in the salience exhibit by Ratnamma also contained photographs which did not reflect the actual image of Ratnamma. He therefore contended that the entire transaction culminating the sale in favor of the petitioner was fraudulent. He ultimately stated that when he came near his property bearing number 86/2 and 87/2, one Ranjit Kumar was present there and stated that 6 guntas of the said land had been purchased by the petitioner herein and warned him not to enter upon the said land. He therefore requested the authorities to initiate proceedings for offence under section 504, 465, 468, 471, 419, 420 of the IPC. Thanks, Parag. On investigation, the police proceeded to lay a charge sheet against the petitioner. Please, madam.
Ranjit Kumar and Namama.
Against the relation either Obrena
Illi Obreman.
against the petitioner and 3 others for offense under section 465, 467, 468, 471, 474, 419, 420. Being aggrieved by the registration of a crime and the laying of a charge sheet, the petitioner is before this court. Then counsel for the petitioner basically contended that the site number 4 and 5, which the second respondent contended was the sites belonging to his father, Gopal Krishna Reddy, did not belong to him at all. And therefore, the entire basis of the complaint was illegal. There was no basis for the said complaint. He placed reliance on a decree of compromise that had been entered into between C.P. Ramaya Reddy, P. Gopal Krishna Reddy, bracket, father of the respondent complainant, and his father, P. Shankar Reddy, and contended that under this compromise, it was clearly admitted by all the 3 brothers that they had retained clearly admitted that there was a partition of the year 24/3/89, and the said partition would govern the properties allotted therein, except for land bearing serial number 1/1, 86/2, and 87/2 of Chelkere. He also stated that according to this compromise, the father of the petitioner had been allotted one site in serial number 1/1 and 2 sites bearing number 14 and 15 in serial number 86/2. And the compromise and the schedule of the property which was allotted to the father of the complainant specifically had a statement that apart from the 3 sites His father did not have any right, title or interest of any kind over serve number 1/1, 86/2 and 87/2. He therefore submitted that when the father of the petitioner himself admitted that he had been allotted only site bearings number, two sites bearing number 14 and 15, and that too in serve number 86/2, the entire premise of the complaint that the complainant's father owned site number 4 and 5, which had been carved out of serve number 86/2 and 87/2, was incorrect. And there was therefore no basis for initiating a criminal proceeding. Suit and Mibrale,
11 suits are pending, which has been filed.
ಇದ್ರ ಬಗ್ಗೆ
ಇದ್ರ ಬಗ್ಗೆನೂ ಇದೆ.
ನೀವ್ ಹಾಕಿರೋದು ಅವ್ರು ಹಾಕಿರೋದು.
My lord, he's telling suits are pending, but ಇದು ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ suit pending ಇದೆ. I don't know about their suit, my lord.
11
Last time he told
11
he
suits have been filed by the petitioner
will
himself,
produce it,
my
my lord. Till now he is not produced.
They are not counsel for
Produce
the
if required.
complainant, however submitted that the police after investigation have come to the conclusion that the sale deeds obtained by the petitioner were fraudulent and were on the basis of a GPA which had stood determined by virtue of the death of the principals. And therefore it was a clear case of cheating, and the police were therefore justified in filing a charge sheet. Next. He however did not dispute the fact that there was a compromise decree passed in OS 1844/1995 in a suit between his father P. Gopal Krishna Reddy and his two uncles C.P. Ramaya Reddy and P. Shankar Reddy. In the light of the above, it is clear that it is the admitted position of both the parties that there was a compromise decree entered into in OS 1844/1995, in which the three brothers, Ragdalli, including the father of the petitioner and the father of the complainant, clearly admitted that the three brothers would enjoy their properties as per the partition of the 89. But in respect of the properties bearing serial number 1/1, 86/2 and 87/2, their rights would be gone by the compromise. The compromise petition also indicates in clear terms that the three brothers had sold sites to different persons, and these sales were made by the father of the complainant as the GPA holder on behalf of his two brothers. It has also been stated in the compromise that none of the three brothers have any right, title, interest, or possession of any kind over the sites which have been sold in serial number 1/1, 86/2 and 87/2. It is therefore clear that all the three brothers acknowledged unconditionally that they had sold several sites in serial number 1/1, 86/2 and 87/2. And they ultimately admitted that they had retained site number 1 and 2 in serial number 1/1. And that site bearing number 1/1 was allotted to the father of the complainant. And apart from the said site, two sites bearing number 14 and 15, which had been retained in 86/2, had been allotted to the father of the complainant. This compromise therefore indicates that apart from two sites which had been retained in 86/2, there were no other sites that had been retained by the family, and all these sites had been sold as had been clearly acknowledged in the compromise petition. If this compromise is not in dispute and the father of the complainant had retained only site number 14 and 15, the question of the petitioner, his son, claiming that his father owned property number 4 and 5 and the conveyance of this property by one Ratnamma was illegal, cannot be accepted at all. It is clear from the above narration facts that the criminal proceedings have been initiated only as a ruse to avoid a civil litigation. I'm therefore of the view that the entire proceedings initiated by the petitioner when his father had no right over site number 4 and 5, carved out of sub number 86/2 and 87/2, cannot be sustained, and the proceedings are therefore quashed.
Number 23.
A private complaint has been filed under section 200 of the CRPC without following the Priyanka Srivatsa case. Investigation was done, then charge sheet has been filed.
Where's the complaint?
At page 55, annexure C. And after filing the complaint, I will take a look at annexure A, page 9, reference order under 156/3.
They made an averment that they had approached the police, but the police did not
No.
take any action.
Then after filing affidavit, sending to the SP, no affidavit, nothing. Straight away on the same day, page 9, my lord.
Page?
Page 9. This is impugned order, 10 for reference order. PCR file, referred the matter, and by a judge, he is having no jurisdiction. Because this is order passed by third additional senior civil judge and CJM Mysore, order of preference. Next page may be kindly seen, my lord. 3 AVJ filed memo to transfer this case to first additional senior civil judge court as accused are within the jurisdiction of Vivipuram police. Hence, office is directed to send this case to first additional senior civil judge to Mysore.
In complaint, no?
Complete exit C. Page 55.
You are the developer, huh?
Yes, my lord. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಮೌಂಟ್ ಕೊಡೋದಿತ್ತು ಡೆವಲಪರ್ ಅವರು ಲ್ಯಾಂಡ್ ಓನರ್ ಅಮೌಂಟ್ ಪೇಮೆಂಟ್ ಆಗಿ ಎಲ್ಲ ಆಗಿದೆ ಕಾಂಪ್ರಮೈಸ್ ಟಿಕ್ರಿನೂ ಆಗಿದೆ ನನ್ನ ಮಗನ ಚೆಕ್ ಇಟ್ಕೊಂಡಿದ್ದನ್ನ ಮಿಸ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ನಾನು ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಎಲ್ಲ ಇದು ಮಾಡಿದ್ದಾರೆ ನಮ್ಮ ಮಗನ್ ಚೆಕ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಹೇಳ್ತಾರಲ್ಲ ಸಿ ಹರಿ ಪಾಠಕನ್ ಚೆಕ್ ನನ್ನ ಮೇಲೆ ಕೇಸ್ ನಾನು ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ
Who's accused number 2?
Managing director. Accused number 1 is a company. Accused number 2 is a managing director.
ನಿಮ್ ಸಂಧಾನಲ್ಲ ನಿಮ್ ಸಂಧಿ ಯಾವ್ದು ಚೆಕ್?
ಸಂಧಿ ಮಾಡೇ ಇಲ್ಲ. ಹರಿಪಾಠಕ್ ಅವ್ರ ಚೆಕ್ ಅದು.
ಎಷ್ಟು ಅಮೌಂಟ್ ಅದು?
ಅದು ಒಟ್ಟು 1,78,00,000 ಏನೋ. ಎಲ್ಲ ಚೆಕ್ ಅವ್ರದ್ದೇ.
25 lakhs.
ಮತ್ತೆಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾರೆ. ಹೌದಾ ಹರಿಪಾಠಕ್ ಚೆಕ್ ಮೊದಲೇ ಅಕೌಂಟ್ ಕ್ಲೋಸ್ ಆಗಿದೆ ಎಲ್ಲ ಬ್ಯಾಂಕ್ ಇಂದ ತಗೊಂತಾರೆ ಲೆಟರ್ ಗಿಟರ್ ಎಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡೋದು ಕಂಪನಿ ಮೇಲೆ ಇವ್ರ ಮೇಲೆ. ನಾನ್ ಕೊಟ್ಟಿದ್ದ ಚೆಕ್ ಬಗ್ಗೆ ಕೋರ್ಟ್ ನಲ್ಲೇ ಮೆನ್ಷನ್ ಇದೆ ಕಾಂಪ್ರಮೈಸ್ ಟಿಕ್ರಿದಲ್ಲಿ ಯಾವ್ದು ಚೆಕ್ ಕೊಟ್ಟಿದೆ ಅವೆಲ್ಲ ಇನ್ ಕ್ಯಾಶ್ ಆಗಿದೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಇಸ್ ಪೇಡ್ ಅಂಡರ್ ದ ಕಾಂಪ್ರಮೈಸ್ ಟಿಕ್ರಿ.
Essentially civil dispute alva.
My lord, thing is that when the matter has been compromised, out of the terms of the compromise, 6 checks have been issued by this accused number 2.
ಎಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿತ್ತು?
Annexure F, my lord. Relevant page is at page 72.
Page?
Page 72, annexure H, annexure F, page 72.
Is it referred to in the complaint?
Yes, my lord.
Is it referred to in the complaint that there was a settlement?
Yes, in complaint it is referred.
Yes, my lord. OS 877 is referred. But those checks are what they are issued. These are not the checks. As per this compromise, entire amount is paid. I have produced all the documents.
4, 5, 6. of the complaint.
Under the compromise,
Yes,
some rupees 2.15 crores was to be paid, huh?
Yes.
my lord. You're basically enforcing a compromise petition.
Yes. It
By
has
way
been,
of a PCR.
no. After obtaining the decree, my lord, these checks which have been referred in the para
These checks were given pursuant to compromise, isn't it?
Yes.
No, my lord. No checks are given.
And case is that
Let us see the compromise petition.
accused number 2
Let us
stating
see the
that
compromise petition.
Yes. Compromise decree at page 65, my lord. No mention of any checks. It starts from 67. It's only agreed 25 lakhs to be paid, my lord, 67, para 2, my lord. It is further ordered and decreed that balance amount of
ಕೊಟ್ಟಿದ್ದಾರೆ,
25
the amount ಕೊಟ್ಟಿದ್ದಾರಾ?
ಎಂಟೈರ್ ಅಮೌಂಟ್ ಇದು ಬ್ಯಾಲೆನ್ಸ್ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ, ಎಂಟೈರ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಈ ಚೆಕ್ ಇಟ್ಕೊಂಡು ಆಟ ಆಡಿಸ್ತಾ ಇದೆ.
This was paid within 6 months?
Yes, madam.
This 1.8 crores was paid within 6 months?
That is, I'm not sure, but entire amount is paid. I have produced all the payments.
Was it paid before they lodged the complaint?
Yes, my lord. Before that only paid, my lord.
On 10/4/2015.
Yes, madam. Before that only paid, my lord.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
ಇಲ್ಲಿ ನಾನು ಇದರ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಬ್ಯಾಂಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ.
ಡೇಟ್ಸ್ ಕೊಡು.
Yes, madam.
ಒಂದೇ ಸಲ ಕೊಟ್ರೆ ಇಲ್ಲ ಪಾರ್ಟ್
ಪಾರ್ಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೆ. 8 ಮಂತ್ಸ್ಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದೆ. 8 ಮಂತ್ಸ್ ಇತ್ತು ಅದರಲ್ಲಿ, ಅದ್ರ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದೆ. DEF ನಲ್ಲಿ ಅದರಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿದೆಲ್ಲ ತೋರಿಸಿದ್ದೀನಿ. ಅಲ್ಲ ನಿಮ್ಗೆ ಇಮೇಲ್ ಬರ್ತಾ ಇರ್ಬೇಕಲ್ಲ ರೆಗ್ಯುಲರ್.
ಬೇರೆ ಯಾರು? You received the entire 2 crore 5 lakhs before you lodged the complaint.
well, my case is that towards the payment, these checks have been issued by the accused number 2, stating that it is his checks. But factually, those checks are belonging to the account of his son, which was long back it is
You are a compromise. The no checks were given under the compromise petition.
No.
Under the compromise petition, all that they said will give you 1.8 crores within 6 months, balance 25 lakhs within 8 months. That amount has been paid. And there are
That
records to indicate.
because
Then on what basis are you claiming
since
this?
these checks have not been honored.
So you want 4.10 crores
No more.
as against 2.05 crores?
So my complaint itself is to 2 crore
Which you had
15
already
lakhs.
received.
According to my party instruction, we not received, my lord.
I'll
That is-
impose cost 25 lakhs.
No, I have to get the instructions.
But I'll impose cost.
ಅಲ್ಲ. Because ಈ ಇದ್ರಲ್ಲಿ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಮೋಸ ಮಾಡ್ದಂಗ ಆಗಲ್ವಾ? 2 ಕೋಟಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ ಮುಂಚೆ ಇಸ್ಕೊಂಡು
ಮೈ ಸಫಿಷಿಯಂಟ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ ಚೆಕ್ಸ್ ಇದೆ ನನ್ನ ಹತ್ರ 2 ಕೋಟಿ ಬಾಕಿ
ಅಲ್ಲ,
ಬರುತ್ತೆ.
if it is so,
You agree about the compromise in the suit. You agree that the total entitlement is 2 crore 5 lakhs. If you already got 2 crore 5 lakhs, how can you file one more private complaint?
My lord, may I make a submission? I have to get the instruction and secure his bank account, to which account they have alleged to have been transferred.
2018 criminal petition.
ಹೌದು.
ಮತ್ತೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ I'll impose.
ಅಲ್ಲ, ಈ ಕೇಸ್ ನನಗೆ ಇಲ್ಲ. I will get the instructions. If it is so, my lord, if it is credited to my account.
Yes, produce a
Really?
bank statement.
ಅಲ್ಲ, ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ನನಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಅವ್ರನ್ನ ಕರೆಸಿಬಿಟ್ಟು ಅವ್ರ ಬ್ಯಾಂಕ್
ನೋಡಿ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರ ಹೆಸರಿದೆ?
ಅವರದ್ದು.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೆಸರೇನು? ಷಡಾಕ್ಷರಿ.
ಪಾಟಕ್ ಡೆವಲಪರ್ಸ್.
ಷಡಾಕ್ಷರಿ.
ಷಡಾಕ್ಷರಿ is your client. ಇದೆಯಲ್ಲ ಎಂಟ್ರೀಸ್ ಇದೆಯಲ್ಲ.
ನಮ್ದು ಪಾಠಕ್ ಡೆವಲಪರ್ಸ್ ಇದೆ. ಇದ್ರ ಷಡಾಕ್ಷರಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡಿದ ಬಗ್ಗೆ ಎಲ್ಲ ರೆಫರೆನ್ಸ್ ಇದೆ.
ಯಾವ್ದು ಡಿನೈ ಮಾಡಿಲ್ಲ ಅವರು. 10% ಹಾಕ್ತೀನಿ ಕಾಸ್ಟ್.
My lord, I will get the instruction. No, without assisting the court, I can't make submission.
Tuesday.
Tuesday. Tuesday, madam.
Tuesday.
ಅಲ್ಲ, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತರಿಸ್ಬೇಕು.
You have time till Tuesday, do whatever you want to do.
No.
If you don't, if you're not ready by Tuesday, I'll proceed.
ಅಲ್ಲ,
to
ನೆಕ್ಸ್ಟ್
fast.
ಫ್ರೈಡೆ. ನೋ,
Tuesday.
ಐ ರಿಕ್ವೆಸ್ಟ್. ಯಾಕಂದ್ರೆ ಮೈಸೂರಿಂದ ತರಿಸ್ಕೊಳ್ಬೇಕು ನಾನು.
ಇದು ನಿಮ್ಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ನಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ, ಅವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ ನಾನು ಈಗ
ಅಲ್ಲಿ
ಐ ಹ್ಯಾವ್ ಟು ಕ್ರಾಸ್ ಚೆಕ್ ಮೇಲೆ.
ಅಲ್ಲಿ ಚೆಕ್ ನಂಬರ್ ಇದೆ, ನಿಮ್ಮ ಅಕೌಂಟ್ 1 ನಿಮಿಷ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾರೆ, ಎಲ್ಲ ಇಂಟರ್ನೆಟ್ ಬ್ಯಾಂಕಿಂಗ್.
ಅಲ್ಲ, ಅದನ್ನೇ
ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ತೀನಿ, ನೀವು ರೆಡಿ ಆದ್ರೆ ರೆಡಿ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಯು ನೋ ವಾಟ್ ಲ್ಯಾಪ್.
ಟ್ಯೂಸ್ಡೇ ಬೇಡ, ಫ್ರೈಡೆ.
Tuesday.
1 week.
For further
Kindly,
consideration,
Stay may be kindly extended.
seal number 20.
Friday. I request.
Tuesday.
Chain Basuraj.
ಇಲ್ಲಿ ನಿಮ್ ಕೊಲೀಗ್ ಮಾಡೋದು 2 days ಮಾಡ್ತೀವಿ. ಹೋದ್ಸಲ ಇದೇ ಹೇಳಿದ್ರೆ ಅಕೌಂಟ್ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಕ್ಲಿಯರೆನ್ಸ್.
ಅವ್ರು ತಮ್ದೊಂದು ಡೈರೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು. they have not deposited the arrears of salary.
Who is to complain?
ಅವ್ರು
University has to
ಯೂನಿವರ್ಸಿಟಿ
deposit. ಯಾರು? ಯೂನಿವರ್ಸಿಟಿ
ಅವರೇ ಯೂನಿವರ್ಸಿಟಿ.
ಅಲ್ಲ, ಯೂನಿವರ್ಸಿಟಿ ಯಾರು ಆಫೀಸರ್? Let him come and appear.
2 days ಮಾಡಿ ನಾನು
The
ಬೆಳಗ್ಗೆ
bill was paid and dismissed, isn't it?
ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಅದರಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್ ದಿ ಫೈನಲ್.
Correct.
So what is the effect of that?
ಪ್ಲೀಸ್ ಮಾಡಿ.
When was the dismissal?
It is last week.
Last 20 days.
19th ಮಾಡೋದು. ಕಾಪಿ ಕಳ್ಸ್ಕೊಟ್ಟಿದ್ದೀನಿ. 2 days ಅಲ್ಲಿ
ಮಂಗಳವಾರ ಕರಿತೀನಿ, ಅವ್ರು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ I'll ask the registrar to be present, please.
Number 25.
25, I am appearing for respondent number 3.
Yes.
My lord, the connected matters have not been listed, my lord.
Petitioner.
Connected matters have not been listed. Only one matter has been listed. In all these matters,
I have find.
all these matters have to be listed together. Your lordship directed the government to make submission.
All right, release along with connected matters.
Fifth guess. For further hearing, seal number 26, Shri Prithvi Odia.
230. Idru senior. Yes, sir.
For preliminary hearing B group, seal number 27 and 28 adjourned, seal number 29. M. Subramania Bhatt.
I'm appearing for R1, Your Honor. Kindly adjourn the matter. My senior counsel is held up in other court hall.
2017, madam.
She is held up in other court hall.
Adjourn the last occasion also. What is the prayer?
Lordship, kindly adjourn the matter, please.
There is no appearance on behalf of the petitioners. And due to the fact that the matters of the year 2017, there's no justification for continuing matter petitioners dismissal non-prosecution.
Seal number 30, Shri Mohan Bhatt.
For petitioner, kindly pass on. Pass on.
Seal number 31 and 32 adjourned. Seal number 33, Shri Srimati Shubha.
I appeal for the petitioner, my lord. The few modifications, my lord, this petition can be disposed of. My lord, may kindly come to page number 19, my lord. 19, running page number 19, my lord.
The compensation.
Compensation matter.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Idralli Swami, paragraph number 31, my lord, page number 19, paragraph number 31 alli. Therefore, yield of the coconut per tree is considered as 180 and price of the coconut is considered as rupees 10 and hence annual income from the coconut per tree comes to rupees 1,800 and hakidare Swami. Instead of 180, my lord, it should be assessed at 103 as per Dodaka's judgment, my lord. 180 is little exorbitant.
ಇಲ್ಲ.
Coconut nuts na
ಬಿಡಿ ಆಮೇಲೆ
ಅದಾಯ್ತು. ಆಮೇಲೆ my lord, paragraph number 36, my lord. Further keeping in view estimated valuation details ella hakbiಟ್ಟು the valuation of neem tree is fixed at rupees 15,000 anta hakidare Swami. In all other cases, we have taken as we have only admitted and uniformly neem trees is fixed at rupees 13,000, my lord. In
13.
other cases,
13,000.
13,000. So
ಎರಡ್ ಸಾವಿರ ರೂಪಾಯಿ.
but 44 trees are there, my lord. So substantially it will be reduced. ಅದೊಂದು 2,000 ಮಾಡಿ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಇದು
ಯಾವ ಆಧಾರದ ಮೇಲೆ 13,000 ರೂಪಾಯಿ ಹೇಳ್ತಿದ್ರೆ ನೀವು?
ಅವರು ಇದ್ರಲ್ಲಿ 15,000. My lord may kindly come
ನೀವು 13,000 ಮಾಡ್ಬೇಕು ಅಂತ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಹೇಳ್ತಿದ್ರೆ?
consider the valuation as per that year, my lord. ಬೇರೆ cases allow produce ಮಾಡಿ. I have a judgment, my lord, where we have only agreed and uniformly we are paying 13,000 ಸ್ವಾಮಿ.
You are paying ಅಲ್ಲ.
ಅಲ್ಲ, ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು 13,000 ಮಾಡ್ಬೋದು ಅಂತ.
ಪೇಮೆಂಟ್ 13,000 ರೂಪಾಯಿ ಸರಿ ಇದೆ ಅಂತ ಯಾರಾದ್ರು ಕೋರ್ಟ್ ಹೇಳಿದಾರ?
ಹೌದು ಸ್ವಾಮಿ, ಬೇರೆ ಕೇಸಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಕ್ಕೆ ಈ ಕೇಸಲ್ಲಿ ಫಾಲೋ ಮಾಡಿ ನಾವು.
ಅದೇನಾದ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ?
ಚಾಲೆಂಜ್ ಏನಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ದೇ ಆರ್ಡರ್.
So it can't be accepted.
ಅಲ್ಲ,
ಕೋರ್ಟ್ ಅವರು ಅದನ್ನ ಒಪ್ಕೊಂಡಿದ್ರೆ ಯಾರು ಒಂದು ಕೋರ್ಟು ಎಲ್ಲಿದೆ 13,000 ರೂಪಾಯಿ ಅಂತ?
I don't have a copy. ಅದ್ರಲ್ಲಿ 13,000 ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. The other side also had agreed and only.
This is again without any reasons. There are two name trees. The trial court has taken rupees 15,000.
My lord,
the same request was modified as rupees 13,000.
Yes, uniformly we have decided. And
ಫೈಂಡಿಂಗ್ ಎಲ್ಲಿದೆ ಇದು? 15,000 ರೂಪಾಯಿ ತಪ್ಪಾಗುತ್ತೆ, 13,000 ಕೊಡಬೇಕು ಅಂತ.
15,000 ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ತಪ್ಪು ಸ್ವಾಮಿ. Kindly come to page number 18 of my writ. 18. ಅದರಲ್ಲಿ the learned judge has reduced ಈ ಕೆಳಕಂಡ ಸದೃಢವಾಗಿ ಬೆಳೆದ ಮರದ ಅಂದಾಜು ಫಸಲಿ ಮತ್ತು ಅಂದಾಜು.
ಎಲ್ಲಿ ಓದ್ತಿದ್ರ?
Page number 18, my lord, of the writ petition.
It's page number 9 of that order. CMS.
Yes. At the end, my lord, end of the page. ಬೇವು ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಬೇವು 125 ರೂಪಾಯಿ kg 3,000. at the end ಮಾರ್ಕೆಟ್ ದರ 6,052 ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಅವರು ಇದನ್ನ ನೋಡ್ಕೊಂಡು 15,000 ಕೊಟ್ಟಿದ್ದಾರೆ. So even according to them also 6,052 andre at the most they could have taken as 7,000, but she has given, the lower court has given 15,000. Apart from that, there is no other finding. So my only submission is, since we have only admitted and we are taking it, instead of 15,000, it can be taken as 13,000 and there is some calculation mistake also, Swami. It will coming back again to paragraph number 36.
I will simply confirm the order. If there's anything to be calculated, it will be calculated in accordance with the valuation that is made.
There is a mistake also in the valuation, Swami. Double calculation. Again, coming back to page number, paragraph number 36, Swami. Paragraph number 36, last 2 lines. Value of the neem tree fixed as rupees 15,000. 15,000 into 44, she has calculated as 13,20,000. But 15,000 into 44 is 6,60,000.
ಸರಿ ಮಾಡ್ತೀನಿ 6,60,000 ಮಾಡ್ತೀನಿ.
Another connected matter is also there. Big petition filed by.
My lord, my only submission
ಅವ್ರು
is
ಹಾಕಿದಾರ, ನೀವು ಹಾಕಿದಾರ.
Now Akila, sir. Similarly placed to the land, another petition. Petition number 6756 of 2022.
ಆಯ್ತು, ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ರೆ ಅದೇ
ಅಲ್ಲ sir, ಇದೇ 6756.
1717, sorry, 1717 of 2020.
ಎರಡೆಲ್ಲ ಮೇಡಮ್ ನಿಮ್ದು ಕೋಕೋನಟ್ ಟ್ರೀಸ್
Coconut trees ಒಂದು ಮತ್ತೆ ಇದು.
ನೇಮ್ ಟ್ರೀಸ್.
That's all.
The petition is filed challenging the award of compensation, which was enhanced to rupees 19,22,984 by the district judge. Learned counsel appearing for the petitioner contends that there are two errors in the order. She submits that the district judge has committed an error in taking the yield of coconut per tree as 180 and it ought to be as 130 or 115.
150 ಮಾಡಿದ್ರು ಪರವಾಗಿಲ್ಲ.
150. She further states that the value of the neem trace has been taken at rupees 15,000 and it ought to be taken at rupees 13,000. For this, she places reliance on an order passed by this court in WP 12477/2021, where this court reduced the value of the neem tree from rupees 15,000 to 13,000. She also submits as a calculation error in para 36 of the judgment insofar as it relates to calculating the value of the 44 neem trees. She submits that if the value of the neem trees is to be accepted as 15,000, for 44 trees, the sum awarded should have been 6,60,000 and not 13,20,000. In my view, the first two arguments that there were errors in respect of the yield of coconut per tree and regarding value of the neem trees cannot be accepted. In my view, the district judge has exercised discretion in coming to the conclusion that the average yield of the coconut tree was 180. This is obviously having regard to the fact that the coconut trees that are grown in Chiknayakanalli Taluk do yield a higher amount of coconuts as compared to other talukas. The second argument that the value of the neem trees ought to be rupees 13,000 as has been accepted with this court cannot also be accepted. This court in the aforementioned petition, in the factual context of that case, modified the value of the neem trees at rupees 13,000. This court has not determined that the value of the neem tree should be 13,000 in all cases. In my view, the trial court, after taking into consideration that the estimated valuation made by the range forest officer, which was for the year 2001-2002, and taking into consideration that the trees were felled in 2014-15, the determination at rupees 15,000 cannot be found fault with. Consequently, the valuation made by the trial court insofar as it relates to the yield of the coconut tree and the value of the neem tree is accepted. However, it is noticed that the district court has in fact committed an error in arriving at the total value of the 44 neem trees. If the value of the neem trees is to be accepted as rupees 15,000, for the 44 neem trees, the amount payable would only be rupees 6,60,000.
Yes, my lord.
And not 13,20,000. Hence, to that extent, the amount of rupees 13,20,000 found in para 36 is substituted with the figure 6,60,000. In all other respects, the award of the district judge is confirmed. The amounts shall be recalculated.
Paragraph 37 also, the mistake continues, my lord.
The amount payable shall be recalculated by taking into consideration that the value of the named trees would be rupees 6,60,000 and the entire compensation shall be paid accordingly. Amounts, if any, paid shall also be given due reduction, subject to the board resolution.
Much obliged.
34 and 35 adjourned. Seal number 36.
ನೀವೇ ಇದ್ರಿ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇವರೇ ನೀವೇ ಇದ್ದೀರಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನೀವೇ ಇದ್ದೀರಾ
Connected matter, ಇದರಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲ ನೀವಿದ್ದೀರಾ
1717 ರಿಪಿಟಿಷನ್ ನಂಬರ್.
ಇಲ್ಲ ನೀವಿದ್ದೀರಾ ಅದರಲ್ಲಿ ಬೇರೆಯವರ
ಇವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವೇ ಇದ್ದೀವಿ, ನಾವೇ ಇದ್ದೀವಿ.
ನೀವೇ ಇದ್ದೀರಾ ಅದನ್ನು ತರ್ಸ್ಕೊಂಡು ಇದೇ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಮೇಡಮ್ ಇದಾರೆ ಅದರಲ್ಲಿ?
ಮೇಡಮ್ ಇಲ್ಲ.
I have not.
ಮೇಡಮ್ ಸುಮನಾ ಬಾಳಿಗ.
ನಾಳೆ ಕಳಿಸಿ, ನಾಳೆ ಹಾಕ್ಸಿ.
ಇಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
I appear for petitioner, my lord, serial number 36. I pray for 3 weeks' time, my lords, we have filed RTI application seeking details of power supply list. Any date of 3 weeks.
19th.
Much of.
Great.
Seal number 37. Saman.
Should appear for the response. Worship, it may be taken up next week, my worship. Seniors held up in another court. Madhyana partnered matter there. Much obliged.
Seal number 38. Srimati Vinchala MR.
Challenge, impugned notice is annexure A, my lords, where there was a.
Who's opposing you?
Shanti Bhushan.
ಬೇಡವಾ ಅವರು?
ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಬಂದಿದೆ, ಅದು ಸರ್ಕ್ಯುಲರ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ ಟು NOC ತಗೋಬೇಕಾಗಿತ್ತು ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ. there is a height of the building 21 meters ಮೇಲೆ. So now there is a notification states my lord the NOC is not required. Based on that my petition needs to be allowed.
ಎಲ್ಲಿದೆ ನೋಟಿಫಿಕೇಶನ್? ಎಲ್ಲಿದೆ ನೋಟಿಫಿಕೇಶನ್?
ನೋಟಿಫಿಕೇಶನ್ ಬೆಳಗ್ಗೆ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಬಂದೆ, ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಅಂತ.
ಏನ್ ಮಾಡ್ಲಿ?
Next week on time.
ಲಿಸ್ಟ್.
Let's interim order needs to be extended.
Seal number 39. Shashkiri Rao.
My lords, the impugned judgment is at annexure A, my lords.
It's E.
A. My lords, here the bottom line of the whole petition is they have claimed the arrears of the R bill, saying that from 2013 to 2019, the representative of the department has not read the meter properly. And they state that the meter has transferred from 50 kV to 100 kV and you have been using electricity of the 100 kV. But due to the arithmetical error, we were not able to bill properly and they have issued the notice saying that you have to pay 15 lakhs and odd of arrears, my lords. What they are stating is that's the arithmetical error, my lords, but according to what the reasons they have issued in the notice, it is purely a technical error. Every month, the representative of that department used to come, check the meter, and they have billed the electricity bill. And we have no arrears left so far till the year 2019, my lords. We have cleared the bill then and there. And also in my building, my lord, I had the tenant who was government office. I had rented my space to LIC and PF offices, my lords. At that time, they are claiming that is from the year 2013 to 19. The tenants were LIC and they were paying the rent directly to the department. And now they come up in the year 2019.
Payment of rent directly to the department.
No, payment of the bill, electricity bill, my lords. Then they come up in the year 2019 stating that from the year 2013, they have misbilled the electricity bill and you have this much amount to pay. I am neither the direct consumer of the electricity, my lords, and I being a prudent person, I had no knowledge how the 50 kV got turned into 100 kV and they didn't come into periodical checkup stating that this is the situation and we have to bill in extra. And there, my lords.
What is the demand now? What is the demand?
For the quashing, 15,67,000.
Tenants are not there?
No, my lords. My lords, may kindly produce the conditions of supply of electricity distribution licensing in state of Karnataka. My lords may kindly peruse 29.08 adjustment of erroneous bills. It's in last page, my lords. 63. Last fourth line. May I read it out, my lords?
For a period of 2 years.
Yes, my lords. And they are dating back to almost 7 years, my lords.
But are you agreeable to pay up to 2 years?
My lords, I'm neither the direct consumer and I was not aware, my lords. It is total negligence on the
You are the
department.
registered consumer, you have an agreement with them saying that in the event of.
But my lords, there is also a point which states that I have been issued only up to 70 kV of electricity. Neither of my application that to extend it to 100 kV, how the meter could change, my lords.
What is the reason given by the ombudsman?
Ombudsman says that it is a arithmetical error, and the arithmetical error, according to Limitation Act, the arithmetical error can be resolved and the amount has to be paid. If I had consumed the extra electricity, my lords, the meter would have run.
Have you implemented this PF office and LIC here?
No, my lords. They have vacated my premises in the year 2018.
They were the only 2 tenants you had?
Yes, my lords.
Nobody else was
Nobody else.
there? Let them come. Let us see if I can implement PF office LIC and ask them to pay the charges.
My lords, however, the extent they can only recover up to the year 2000, 2 years. No, my lords, they have.
But pay 2 years.
claiming. Let them.
Let them come.
The mother of the council is representing on behalf of the respondent number 213 for petitioner inform.
Mostly ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಯಾವ್ದೋ ಪಾರ್ಟ್ ಇದೆ ಮೋಸ್ಟ್ಲಿ.
Mother expert ಆಗಿದಂತೆ council advocate
Serial number 44.
Number
47 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಡ್ವೊಕೇಟ್ 14 ಅಲ್ಲಿ ಇದ್ದಾರೆ.
40 ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
47 and 48.
47 ಸೇಮ್ ಅಡ್ವೊಕೇಟ್.
ಮೈಲಾಡ್ 40 ನಾನು ಅಪೇರ್ ಆಗ್ತೀನಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಸೇಮ್ ಅಡ್ವೊಕೇಟ್.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ.
Serial number 40 and 47.
40 ಅಲ್ಲಿ serial number 40.
On behalf of the respondent.
So
40 and 47.
APMC matter. Swaroop.
Just half
Mother
of
is
the
false member. That's why seeking for 2 weeks.
Serial number 29, my lord.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲ, ನಿಮ್ಗೆ ಏನ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ ಪಿಟಿಷನ್?
ಇಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಬದಲು ಒಂದು ಮೆರಿಟ್ ಮೇಲೆ ಮಾಡ್ಬೋದು.
ಡಿಸ್ಮಿಸ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ಬಿಡ್ಲಾ?
ಅಲ್ಲ, ನಾನು ರೆಡಿ ಇದ್ದೀನಿ. ಲಾಸ್ಟ್ 3 ಟೈಮ್ ಅವರು ಟೈಮ್ ತಗೊಂಡು.
ನಾನು ಎಂಟ್ರಿ ಮಾಡಿರ್ಲಿಲ್ಲ. ಅದು ಇಷ್ಟು ವರ್ಷದ ಅವ್ರ ಪವರ್ ಲೈನ್ ಲೇಮ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ಇನ್ನೂ ಅದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ಆನ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಐ ಹ್ಯಾವ್ ಅ ಟಫ್ ಕೇಸ್.
ಏನ್ ಮಾಡ್ಲಿ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡೋ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ಬೋದು.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡ್ಲಾ?
ಮಾಡ್ಬೋದು.
Serial number 45.
Give reasons after.
Serial number 51, my lords, for the petitioner, counsel on record is not in the city at the moment.
Serial number 48.
Serial number 45, my lord.
Petitioners, my lords, seeking 1 week time.
48.
48. Yes.
Serial number 40, my lord. Next matter.
Serial number 41 for the petitioner. 41. Praise time, my lord.
138.
Previous matter, my lord. Serial number 40, my lord.
41. Praise time, my lord.
Serial number?
Serial number 40, my lord.
ಅಡ್ಜರ್ನ್ ಆಯ್ತಲ್ಲ, ಸ್ವರೂಪ್ ಅವ್ರ
ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸುಮ್ಮನೆ.
ಮಾಡ್ತಾರೆ.
But serial number 45, my lord.
This list will not continue in the office. I don't think it will continue. Then
But
42 may be directed to taken up next week.
already adjourned.
Data
I don't want to give an assurance in case that matter collapses. Therefore,
Interim order extension.
61.
The
61 minutes.
My lord, serial number 45 adjourn ಆಗಿದೆ interim order.
61 also, my lords.
And for the petitioner, I am ready.
Senior mother.
I mentioned this.
61 if it could be adjourned to next week, no, so interim order to be extended. On third, if it could be had, well, similar matters on third. IO to be extended. Grateful.
ಏನಕ್ಕೆ ಬಂದಿದೆ?
Sir, ಅದು 41. Sir, ಅದು 45 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು. ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದ್ಸತಿ ಹಿಂಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿತ್ತು ಬೇರೆ ಅಲ್ಲಿ ಬೆಂಚಲ್ಲಿ ಇದ್ದಾಗ ಅದು 45. ಅದು ಬೆಳಗ್ಗೆ ಅರ್ಜನ್ ಆಗಿದೆ ಯಾರೋ ತಗೊಂಡಿರ್ತೀನಿ
ಅಜ್ಜನ್ ಆಗಿದೆ. ಅಜ್ಜನ್ ಬರ್ಕೊಂಡಿದೀನಿ ನೋಡಿ. APMC ಸ್ವರೂಪ ಅವ್ರ ತಾಯಿ ತೀರ್ಕೊಂಡು.
47.
45 ಅವರಿಲ್ಲ, ನಂದಕಿಶೋರ್ ಇರೋದು.
47 ಸ್ವರೂಪ್.
ಬಟ್ ಬೆಳಗ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ರು ಯಾರು?
ಇಲ್ಲ.
45 ತಗೊಂಡಿಲ್ಲ.
ನಾನು 47 ಇದೆ. 60
ಯಾರು someone
2 weeks ಅಂದ್ರಲ್ಲ.
ಅದು ಹೌದು.
ಇರೋಗಿದಾರ.
47.
ಸರಿ ಅದು ಮತ್ತದು
2 weeks.
ಅಲ್ಲ ಇದು 45 ಮತ್ತದೊಂದು
ಸರ್ ನೋಡಿ 45 ಅಜ್ಜನ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ
45 ಆಗಿಲ್ವಾ?
ಅಲ್ಲ ನಾನು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಕ್ಕೆ ಬಂದಿದ್ದು ನಾವೆಲ್ಲ ಹೊರಟಿದ್ದು ಹಂಗಾಗಿ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇತ್ತು
ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ತಗೊಳಲ್ಲ, ಕೊಲ್ಯಾಪ್ಸ್ ಆದ್ರೆ ತಗೊಂತೀನಿ.
ಅವ್ರು ಹೆಂಗೂ ಇಲ್ಲ ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಕ್ ಆಗುತ್ತೆ
ನಂಬರ್ 70.
ಕೊಡ್ತಾ ಇರ್ತಾವಳು.
ಅಲ್ಲ ಮತ್ತೆ ಇಂಟರ್ ಮಾಡಿರಿದಲ್ಲ ಮೇಡಮ್ ಅದಕ್ಕೆ ಸರ್ ಅದೊಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ. ನಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತು 45 ಅಲ್ಲಿ.
ಸರ್ ಕೊಡ್ತೀನಿ, ಅದೆಲ್ಲ ರೀಚ್ ಆಗಿಲ್ದಿರೋದೆಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀನಿ.
ನಂಬರ್ 70.
ಸರ್ ತಗೊಂಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ರೀಚ್ ಇದಾಗಿಲ್ಲ ಅಂದ್ರೆ ತಗೊಂಡ್
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ?
ಹಾ?
ಮಧ್ಯಾಹ್ನ
ಇದೆ ಮೇಡಮ್, ಅದು ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟರ್ ಇದೆ. ಅದು ನಡೆದ್ರೆ ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ, ನಡೀಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ತಗೊಂತೀನಿ ಅಂತ ಹೇಳಿ ಸರ್.
ಸರ್ 52 ಅಜ್ಜನ್ ಆಗಿದೆ ಸರ್. 52
ಇದೆ.
52 ನೋಡಿ ಸರ್.
56 ಇದೆ.
ಕೆಲಸ ಮಾಡಿ
ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ, ಒಂದಷ್ಟು ಬಂದಿದೆ ಕಳಿಸಿದ್ದೆ. ಮೊನ್ನೆ ಬಂದಿದೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅದು. ಏನ್ ಮಾಡಕ್ಕೆ
ಸರ್ 52 ಇದೆ.
ಬಟ್ ಎಲ್ಲ ಹಿಂಗೆ ಬಂದ್ಬಿಟ್ಟು.
ಸರ್ 52 ಇದೆಯಾ ನೋಡಿ.
52 ಇದೆ ಸರ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದೆ.
ಅದು ಬಿ ಗ್ರೂಪ್ ಕೊಡ್ಬೇಕಾಗಿದೆ. ಸಾಹೇಬ್ರು ಅದೇ ಹೇಳಿ
ರೂಲ್ ಇಶ್ಯೂ ಆಗಿದೆ.
ಅಲ್ಲ ಅದು ಇಶ್ಯೂ ಆಗಿರ್ಲಿಲ್ಲ.
issued on 5/1/2017 ಅಂತ ಆಗಿದೆ. 5th. ಇದೆ. ಶನಿವಾರದ ಇಷ್ಟು ದಿನ ಇರಲ್ಲ, ಎಲ್ಲ ಹೊರಟೋಗಿರುತ್ತೆ. ಯಾವ್ದು ಹೇಳಿ? 16088. ಇಷ್ಟು ದಿನ ಇರಲ್ವಲ್ಲ, ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ಹುಟ್ಟಿದ್ರೆ ಚೆಕ್ ಮಾಡೋದು, ತಗೊಂಡೋಗಿರ್ಬೇಕಲ್ಲ ಬುಕ್. ಆಮೇಲೆ ಬನ್ನಿ, ಹುಟ್ಟಿದ್ರೆ ನೋಡ್ಬೋದು, ಹೋಗಿದ್ಯಾ ಬುಕ್ ತಗೊಂಡು ಫೈಲ್ಸ್ ಹೋಗಿ.
Sir, serial number 32, disposal. 32. Thank you.
ಅವ್ರು
1 week failing which to stand dismissed.
For pronouncement. Seal number 80, Shri Arvind M. Neglu.
Consequently, the impugn orders are washed. The present criminal petition is allowed accordingly. The entire judgment is in the chamber if you want.
Seal number 81.
For petitioner, my lord.
I find no grounds to entertain the present petition, the same is therefore dismissed. All the contents of both the parties are kept open. We adjudicate in the course of trial.
Seal number 82.
In the light of the above, I find no merit in the contents in advance with the petition. This petition is therefore dismissed.
Number 83, Shri Vasant Kumar SP.
This writ petition is allowed and the BDA is directed to allot site number 2085 referred to above to the petitioner and accordingly execute the necessary documents within a period of 2 months. The BDA shall henceforth prepare a list annually as contemplated in Rule 5.2 of the rules in respect of stray sites only after it has disposed of all the applications for alternative sites by allotting the stray sites that have become available in that layout to those allottees who have not secured possession due to any reason, subject to limitations in paragraph 35. And the BDA shall only thereafter allot stray sites after the application for alternative sites are satisfied as indicated above. You will have to, I think, amend the cost stately. Petitioner is no more alva.
Forward bench matter. Seal number 1, Shri Sachin Angadi.
Please, my lord, I appear on behalf of the respondent state, my lord. On the
Yes.
last occasion, I made a submission to the lordship that the present petitioner number 1 has filed an application for discharge. But after verifying, my lord, it is accused number 2 who has filed an application for discharge. The present petitioner has not filed an application for discharge. But however, my lord, the ground which has been raised by the petitioner is that, my lord, without magistrating having not taken cognizance insofar as the said offence, the proceedings initiated are contrary to this. But however, my lord, as on the date of submitting the private complaint, cognizance was taken on the complaint itself by the magistrate at page number 12 and directed to register it as a CC.
Page number?
12, my lord, 12. There is no separate orders have been passed in the order sheet, but on the left side of the shelf, it has been directed to register and convert it as a CC. Based on this, my lord, the cognizance was taken and it was entertained. And
Yenanta Bararu, the complaint is
complaint is presented before the sworn statement deposed with registry CC 4 call on 99. Register in as CC. Next date is call on 99.
What is the order that I passed in the connected matters?
My lord, connected matter, only one matter is there.
Alla, yadu one ಮಾಡಿದ್ನಲ್ಲ ಬೇರೆ accused ಗೆ.
Illa, the lordship, they have not produced. On the last occasion, they have given one citation with regarding to that the complaint which has been filed by the forest officer is not a competent authority.
Like also,
But
but
the-
criminal petition 100319 by 2024.
My lord,
Those
it is,
in the
I am
which
not,
accused.
I am not aware with regard to that 1031. And another contention that was raised by the petitioner is that the complaint, the officer who has filed the complaint is not an authorized officer. But my lord, it is the range forester who has filed the complaint, who is above the rank of the forester. Section 55 of the Karnataka Wildlife Act, it clearly says that, my lord.
But this order cannot apply to you because you are A1.
Yes, my lord, yes, he is A1 and the articles have been traced in his presence.
Then
For me and other, the rain forest
yes.
In this case, the board is going to watch this complaints. In this case, the rain forest officer is by the complaint level. In the same way, in our case, rain forest officer is private complaint is 29 level. The para number 6 the HCGP itself said in this case in the corporate judgment level.
My
No,
lord,
is
in
he
that,
not above the rank of a forester?
yes, my lord, he is the above of rank of us.
ACF and above the rank of the ACF, having the power to raise the complaint level.
Now, please read para 6.
Of the forest officer of the above the rank of the forest level. RF is not the rank of the police officer. Above ACF on the above the rank of the
Forester ಯಾವ ಕೇಳ್ರಿ ನಿಮ್ ಪ್ರಕಾರ?
forester ACF assistant.
ಯಾರು? What is the cadre of a forester?
My lord, he is a B cadre.
He is the
Range forest officer has filed, range forester has filed the complaint.
Lala, the notification that is
My lord, in the para 6, all the forest officers of and above the rank of the forester.
is
And
a range
all the,
forest-
yes,
no,
my
is
lord.
is a range forest officer above the rank of a forester or not?
Yes, my lord, yes, my lord. Range forester is above the rank of forester.
Then
And may I take it to lordship at para 7 of that judgment, para 7 of the judgment. Even considering the said notification issued by the government, it only empowers the police officers who are above the rank of PSI can lodge the complaint, and sub-inspector of police are not authorized either under the act or under the no other notification is brought to the knowledge of this court to show that the empowerment of police sub-inspector to lodge a complaint under wildlife. Here the police inspector has not lodged the complaint. It is the range forester who has lodged the complaint.
Albadi, if you tell me as a matter of fact, as whether a forester is above the rank of a range forest officer or not.
And may I take lordship at para 5 also, it is clear. Section 55, it reads, para 5. The court can take cognizance of the office under section 55 of the act, reads as for cognizance. No court shall take cognizance of any officer offense against this except on the complaint of any person other than. So, my lord,
This Swami case was a case in which the PSA had filed a complaint.
Yes.
How can you say, how can you hold this as the basis for this judge for your case?
In this case, appointment under the act and include special and additional police officer appointed under section 19 and 20 of the act, rather than section 19 and 20 of the act, also make clear that range forest officer cannot be treated as a police officer.
Nobody is saying he's a police officer. There's
Other grounds also there.
what other grounds?
Considering the audio, at page number 16, the driver is not taken the cognizance.
He is referring to page number 12.
12, my lord. It has been clearly mentioned. There is a writing given by the learned magistrate with regarding to registration and put before the next date.
Yes.
If any taking the cognizance of lordship, the passing order on the complaint, which is very much important to us. But here order is not a
Now, what is the order that is passed at page number 12 on the complaint itself? No, he has passed an order. It's about a 5-page.
complaint under section 200 of CRPC.
Thing it says, as the complainant is a public servant, hence one statement is dispensed with. Register.
CC, registered as CC.
Yes, dispense with one statement because he is a public servant. And his director, what else do you want? This section 200 complaint in respect of an offence under special enactment. Okay, you
And
need
the
regular. Which is the order specifically stating cognizance taken?
My lord, cognizance is, that itself, my lord, except this, my lord, there is nothing. Registered CC, re-list on 99. Except this, my lord, nothing has been narrated by the learned magistrate.
ಅದೇನ್ ಬರ್ತದೆ register as SCC ಆಮೇಲೆ ಏನ್ ಬರ್ತಿರೋದು?
Refer to and call on 99. Refer
to ಯಾರಿಗೆ?
Allah, but in the order sheet there is nothing mentioned with regard to that, my lord.
Private.
Next date at page number 17 of the order sheet, my lord, 9/9/2020. NBW to the accused. Thereafter, my lord, they have obtained bail. And now the matter is posted for hearing before charges, my lord, before the trial court. In the meanwhile, the present petitioner, accused number 1, obtained an interim order before this court. Though the, my lord, as per the Panchanama which has been drawn in his presence, all the articles are seized in his presence only. He admits that he was selling the dry wildlife products. At page number 34 is the Panchanama drawn. Typed copy is at page 34. In the middle portion, my lord.
The judicial magistrate who was empowered to summon and accused under section 204 of the Code of Criminal Procedure should always keep in mind that summoning the accused serious matter and criminal law cannot be set into motion as matter of course. The summoning order must reflect that magistrate has applied judicial mind to the facts of the case and the law applicable therein. The order summoning the accused did not be speaking order. But it should not be suffered from any impurity or illegality, where reason are not assigned. However, short it may be for coming to the conclusion that it is fit the case for issuing the summons. Such summoning the order will become bad law. The magistrate, by issuing the summons, are not required to meticulously examine the evaluate the matter on the record. However, he is only required to record in the however short of which it may be, which indicate the application of mind. When the magistrate that is all the expected from him at the stage. The expression opinion and sufficient ground under the 204 user indicate before issuing the summons, magistrate should show that on what matters at least he has repeat case the issue summons without applying the judicial mind.
Lord, definition 12A, forest officer.
Which act are you reading?
Karnataka Wildlife Protection Act, 1970.
Wild Animals and Birds Preservation Act, huh?
Yes, my lord.
Karnataka anta idea. Are you looking at the Wildlife Protection Act?
Yes, my lord. Yes, my lord. Wildlife Protection Act 1972, my lord. Under that, my lord, section 12A, forest officer.
Please come to section 55 of this Wildlife Protection Act.
Yes, my lord, the same thing has been narrated in the judgment which the lordship has just now gone through, my lord. Cognizance of offence. No court shall take cognizance of any offence against this act except on the complaint of any person other than.
Director of Wildlife.
Director of Wildlife, Member Secretary of Central Zoo, Member Secretary Tiger Zone, Chief Wildlife Warden, the officer in charge of the zoo, any person who has given notice of not less than 60 days in the manner prescribed the alleged offence and of this intention to make a complaint to the central government or the state government or the officer authorized as aforesaid.
So Chief Life Warden, Wildlife Warden, or any other officer
Yes, my lord.
authorized in this behalf by the state government.
Yes, my lord. Forest officer, as per 12A, my lord, it is appointed by the state government.
But if
And
there's
the
no
complaint is,
no, but if there's no specific order for taking cognizance,
Allah, there is no such separate order is not passed by the learned magistrate, my lord. Only on the basis on the complaint they have narrated with regarding to that.
without there being that order saying cognizance taken, can the order for registration of a CC, should he not state that he has taken cognizance?
Yes, my lord, that has to be learned magistrate would have to make mention with regard to cognizance having been taken, but that is not forthcoming in the private. It is only registered as CC ante ಬರೆದಿದ್ದಾರೆ.
ಅದು ವಿಷಯಟ್ ಮಾಡುತ್ತಲ್ವಾ proceedings ನ.
ಹೌದು. Yes, my lord, yes. But since, my lord, since the present petitioner is the accused number 1, since the articles were seized in his presence, my lord, on this technical ground, my lord, if the entire proceedings are vitiated, then the accused number 2 also take the benefit of the accused number 1.
The accused number 2 got the benefit because it was based on the statement of the
The
court.
statement of, yes, my lord. But the
A1
presence,
if your cognizance is not taken, how can you maintain the proceedings at all?
my lord, cognizance, it is the magistrate who has committed an error, my lord, but that I cannot say.
That is why they want to take advantage, isn't it?
Allah, but however, there is a mentioning with regarding to register a CC, but a separate order has to be passed and cognizance would have to be taken. But on that technical ground, if the entire process would be vitiated, though the articles are seized in his presence only.
Vitiate ಆಗತ್ತೆ.
Yes, my lord. Yes. Ultimately, it has to be vitiated, my lord. But on this technical ground, if the entire thing goes, my lord,
ಏನ್ ಮಾಡೋದು? The petitioner is the first accused. So he is challenging the entire proceedings initiated against him for offences under section 939, 40, 44, 236, 40 of the Wildlife Protection Act. On the ground that the magistrate, without even taking cognizance of the offence, has proceeded with the matter. He places reliance on the order sheet to indicate that there is no specific order by which the magistrate took cognizance of the complaint. Shri Kalsurmat, HCB submits that the magistrate, on receipt of the complaint, has made an endorsement on the complaint itself for registering the complaint as a criminal case. And he has also noticed that since the complaint was present by a public servant, the requirement of obtaining a sworn statement was dispensed with. And this would therefore indicate that he has indeed taken cognizance. It is settled law that unless the magistrate applies his mind to the allegations contained in the complaint and thereafter forms an opinion that this was that it was a case of which cognizance was to be taken, further proceedings cannot obviously go on. In the instant case, apart from recording the fact that the complainant was a public servant and hence one statement was dispensed with, the magistrate has simply said a criminal case should be registered. Since there is no order directing cognizance to be taken, no order indicating that cognizance was taken of the offences alleged in the complaint, in my view, the entire proceedings would stand vitiated. Consequently, they are quashed.
Seal number 2, Government Advocate.
Please, Lord, learned AAG appears before the honorable court, ma'am.
Then error ಆಗಿದೆ ಅಂತ ತಿರ್ಗಾ interest ಮೇಲೆ interest ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು, the same it.
What exactly is that?
Just a short point. Only question is whether interest or interest is permissible. That's the only thing. So should we finish the calculation?
I did not go into the calculation. I asked the registry to go on with the calculation and
One is the difference is 10 crores in this case. There are nearly 20,000 cases. If the same calculation is adopted for all the cases, the financial implication is more than 1,500 crores. 1,500 crores. So what has happened, just to point out, Rashmi, can you take this judgment for a moment?
which case do you have on it?
I've got, 1,89,000.
Yes.
Page 13.
Which?
13, running page 30, internal page 13. Serial number 4 is the principal amount. Serial number 4, that is 5,66,000.
Para 16 ತಾನೆ?
Page 30, the calculation, internal page 13, 13, separate page 13, running page 30, the tabulation, the registry.
I think there's something wrong with the page numbers.
So in chart,
The ಎರಡು chart ಇದೆ. Para 14.
16, para 16. Para 16 registry and
Let's calculate the amount as follows.
please, can I request to see table number 4. 5 crores 66,59,000 is the principal amount. Serial number 5 and 6 is 9% interest for per
Where
annum.
are you getting that 5,06,000?
On the right hand side,
I have 4,99,000. First, column number 1 is the market value fixed by the apex court at the rate of 26,13,600 per acre.
Correct.
And total extent of land is 3 acres, 34 guntas.
Comes down to 5 crores 88 lakh next page.
Not in unknown.
89.
The Xerox, mostly I think it's interchanged.
Just give it to you.
What is the urgency now?
Your Worship, can it take 5,88,000 is serial number 3. 5,88,000 is the principal amount in that. That's column number 4. Then 9% interest plus 15%. After 1 year, it is 15%. First 1 year, it is.
It is 5 crores 88 lakhs, isn't it?
5 crores 88 lakhs is the principal amount.
This amount paid by the LAO is 5 crores 66 lakhs.
The 9% interest comes up to 50 lakhs. Then it comes up to 7 crores 16 lakhs.
Yes. Total is
15%.
the total is 13 crores 34 lakhs.
See, that's perfect. Still then, then the interest which is put there ought to have been on 5 crores 88 lakhs. Interest is put on total amount of 13 crores. That is that your option will get in serial number 8. It should have been only on 5 crores. It should not have been on less.
No, 13 crores was as on 19/12/2013, correct?
But the interest as per law is only on 5 crores 88. That is why.
No, the total amount payable
Is the amount
as on 29/12. You are basically saying that the interest should be calculated only on the
principal of the 5 crores and
88 lakhs.
88 lakhs. What is calculated interest on 10 crores and all. And after that, the consequences, increasing on nearly 10 crores. And one is 10 crores, the implication now nearly 1,33 lakh acres.
No, I washed my hands off by asking the registry to do this. They have come out this calculation. Can they calculate interest on the entire amount or interest only on the amount? You will be entitled for 15% interest from the date for expiry of 1 year till the date of payment. ಅಲ್ಲ ಸಪೋಸ್ ಇವಾಗ 13 ಕೋಟಿ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕಿತ್ತು, 10 ಕೋಟಿ ಕೊಟ್ಬಿಟ್ರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ. ನೀವ್ ಹೇಳಿದ್ 3 ಕೋಟಿ ಮೇಲೆ ತಿರ್ಗಾ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗುತ್ತೆ ಅಂತ. The decree is simple. It is 26 lakhs 13,600 per acre along with other benefits. So on 26 lakhs, you will be entitled for interest at 9% for the first year, 15%. This is the decree, not on the base. Correct. Suppose that 15% interest is paid, let us say 3 years afterwards. Then for the remaining amount, it's again on the basis of the decretal amount, isn't it? Not on the outstanding due. You are saying that this 3 crores was paid.
It has been clarified. No, there are 20,000 cases, 20,000 cases.
This 5 crore 66 lakhs was the amount due. Sorry, 5 crore 88 lakhs was due. The interest component till the first payment was made was 7 crore 16 lakhs 70,613.
Correct.
So this 3 crores that you pay,
For the interest. Can deduct only for the interest.
if it goes towards the interest, still on the interest component, there are 4 crores to be paid.
Correct. That is 4 crores 66. Therefore, on 4 crores, assuming I did not pay anything, as per the resolution decree and as per section 28, it is 9% and 15% till I pay. So just because I paid this money, again, this cannot be deducted and penal penalty or interest on interest.
We'll consider this. What is the amount according to you? What is the difference between in each case or?
It's all four cases. And what we are concerned is now the 20,000 cases relying upon.
You have deposited the undisputed amount?
Yes, yes, they have withdrawn it also. That's all. You told me, yes. Till yesterday it has been written. All the amount of. Yesterday we met some more amount.
No, according to you.
All the undisputed amount has been paid. I'll put it this way, madam. What I'll give you, every amount except interest on interest, which I'm talking about, that is not paid. Interest on interest not paid. That is the 4 crores what your lordship asked me, sir. On interest on that amount has not been deposited, except that we have come, according to the compared with the judgment and decree. Only this calculation is where the mistake is cropped up. I think the rule of appropriation is that amount will not an interest on interest. It will be principal.
Let us examine this because I basically relied upon the registry to come to this conclusion. I never applied my mind, whatever they said. Because there was a dispute, I asked the registry to look into the matter and then say whether your calculation is correct or their calculation is correct.
The only issue was with regard to method of calculation. That was what the learned is
very clear, madam. It says that 9% and 15%. They don't say that interest on 15% or on interest on interest. Section 28.
Rule of appropriation, what stated in the group 15 law, it is totally, that becomes a principle, you add to the principle. Oh, entire.
Objections, if any, to the review petitions we filed. Till the next date of hearing, there shall be a stay of the order passed by this court insofar as it relates to. Can you file a memo saying that this?
We'll file a memo, Manoj. Please, we'll file a memo. I don't think my learned friend dispute. Anyway, we'll file a memo.
Next date of.
Okay.
Yesterday we filed affidavit in contempt petition, saying that all the payment.
We'll file a memo, Manoj.
Amount dispute by the state as being
Okay.
the component of interest on interest, which shall be specified in a memo to be filed by the state, shall remain state.
Now, may I make one suggestion? I appear for TDK. Krishna Bhatia telling me, Lord, we are the beneficiary. Including application has been filed.
You want to come and review? The review petition, you want to come on record?
Leave Lord, because ultimately we are the beneficiary.
Let the application be pending.
My Lord, application.
I will not say anything, let it be there. Let
Yes,
it.
yes.
Whenever you want.
Yes, sir. Why I made that submission of this, we all filed that petition, not because we were not parties in any of the proceedings, only in contempt we were impeded. Till then we were not made parties. That is the only reason why. But if your lordship said, ultimately your lordship.
Then you get that petition allowed, then the entire thing comes to an end.
This one, here now, since the review is here before your lordship. After this, Lord, then we'll. That is between them only.
All right. When do you want? Relist.
Seal number 6.
Six, my lords, I appear for the respondent, my lords.
What, Prashant, you're boycotting my court?
No, I'm sorry, my lords. I was on the last occasion, my lords, I had a 230 matter passed over. I'm extremely sorry, my lords, that was never the intention. My lords, in this case, my lords, we had issued another, my lords, apologies, my lords, that on the last occasion, my lords had directed me to produce the divisional controller, my lords, respond number 1. But because of some technical glitch, my lord, he couldn't come online today because the system requires that he has to send his details 1 day prior to the Bengaluru server so that he'll be allowed. Lords, in this case, my lords, may I, my lords, request, my lords, on the next occasion, my lords, I'll keep him present. But this time, my lords, I'll dispense. Lords, we have issued, my lords, an endorsement to the petitioner saying that a writ appeal is filed.
What happened? Have you considered the representation?
My lords, we have issued an endorsement to the petitioner. My lords, my lords have passed an order, my lords, basing upon an earlier order passed in the writ petition number 79363 of 2013. That order, my lords, that writ petition 79363 of 2013, my lords, writ appeal is filed.
What happened to the writ appeal?
My lords, writ appeal, my lords, is still pending consideration. I have not filed it. Other panel advocate, my lords, has filed it. And in fact, corporation has also, my lords, intimated the other panel advocate to speed up the process of writ appeal.
This submission is being made for the past 4 months.
Lords, if
Lord, writ appeal is listed before the court on 12/3. Thereafterwards, it was not listed. Still, it's in under non-compliance.
lords, may I request, lords,
The legal errors are before the court, lords.
If my lords, grant few weeks time, my lords, I'll not.
Granted you a few months time and you've not done anything.
I'm not. Since my lords, since writ appeal was pending, my lords, they couldn't take a financial decision. They are awaiting, my lords, the order of the writ
I'll
appeal.
simply adjourn the matter by 1 week to keep the first respondent present. By that time, see that the appeal is posted.
Please, my lords. 2 weeks, my lords, so that.
Due to some difficulty, his request for some more time to keep him personally present. Released after date 2 weeks. Well, on 12th he should appear.
Please, my lords. I'll see to it, my lords, at least the writ appeal get disposed of and some relief will be given to the petition.
For further consideration, seal number 7.
My lord, in this
Appearing
case, on the
petition.
last occasion, the lordship has directed me to contact the administrator who has been appointed to the respondent number 2 management. My lord, today morning, I have consulted and by 2-3 days, he is ready to come to Dharwad and give instructions with regard to whatever the fact is there. By next Friday, my lord, the lordship shall consider my grievance.
Also much submits that he has contacted the third respondent, alva?
Howdo? Yes,
Third respondent.
And has
impleading applicant, third respondent.
and he has informed him that he would be giving him instruction shortly. He requests for a week's time, released on 5th. Please see that it is solved.
Yes, my lord, yes, my lord, yes, my lord.
5th. Seal number 8.
Date, my lord.
5th July.
5th.
Please.
Much obliged.
Seal number 8, Shri Sangam S. Kulkarni.
Lords, I beg to appear for the respondent, my lords. Lords, I have served a copy, my lords, of the information that my lords have directed me to, my lords, but for some reason I was not able to come to Bangalore. I've served a copy on my learned friend, my lords. I'll file a copy of the affidavit in the registry on Monday. May pray for 12th minutes.
The Shri Viresh Budiyal seeks for a week's time to file the affidavit as ordered on 21/3/2024. Released on.
12th may pray for my lords.
Huh?
12th, my lords. I'll appear in person, my lord. 12th, my lords, may pray for.
12th.
Obliged, my lord.
Obliged.
This one passed over matter. Seal number 12. Seal number 12.
ಆ ಸ್ಕೆಚ್ ಪ್ರಕಾರ ಆ ಸ್ಕೂಲ್ ಬಿಟ್ಟು ಮಿಕ್ಕಿದೆಲ್ಲ ಬಿಡಿ ನೀವು
open theatre, detached compound, detached playground.
an order of re-grant made by Kempamma in respect of land brings number 26 measuring 7 guntas, so number 60 measuring 3 acres 20 guntas, which were 14 lands, was settled by way of a compromise on 17/7/2013 before the Tahsildar. The Tahsildar recorded the compromise petition and passed an order in terms of the compromise petition, re-granting the lands in terms of the compromise. Nearly 4 years after the compromise was recorded, the petitioner, which is stated to be the School Development Management Company, SDMC, preferred an appeal to the district judge contending that a school was situated in the regranted lands and therefore the order of the Tahsildar was incorrect. The district judge, however, noticed that the Tahsildar had in this order of regrant, had made it clear that 11 guntas of land had already been granted to the government primary school of Kabnali village. And therefore, it was obvious that the impugned order of regrant would exclude that portion of 11 guntas. The district judge therefore came to the conclusion that the SDMC would have no grievance since the property of 11 guntas, property measure 11 guntas granted to the school was not disturbed. After hearing the matter for some time in this court, in order to ensure that the land of the school was not disturbed, directed the Tahsildar to prepare a sketch to inspect the land bearing number 60 in which the government school was situated and submit a sketch indicating the extent of the built up area and the open area, if any, attached to the school. The Tahsildar has thereafter filed a report in which he has stated that the school exists in an area of 11 guntas and is also enclosed a sketch in which the area of the school is been marked in blue color. In the light of the above, the order of the district judge does not require any interference. It is however made clear that the sketch produced by the Tahsildar shall form a part of the record and the portion earmarked in blue color shall continue to be the property of the school, and the school shall have no right to claim any other property other than the one marked in blue. ಅದಕ್ಕೆ ಸಪರೇಟ್ ಆಗಿ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು ಯಾರ್ದು ಆಸ್ತಿ ತಗೊಳಕ್ಕಾಗಲ್ಲ ನೀವು ಅಕ್ವೈರ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟು ಅಕ್ವೈರ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ ಫ್ರೀಯಾಗಿ ಹೆಂಗ್ ಕೊಡ್ತಾರೋ ಅವ್ರು ನೀವು ಕೊಡ್ತೀರಾ ಫ್ರೀಯಾಗಿ
Seal number 26.
Act code. Act look.
Yes.
With regard to the validity of Rule 14 A block, one of the point which your lordships had pointed out on the last occasion is whether a Lokayukta, when it submits a report under 12(3), if the very same authority goes, would it be a case of a biased approach, whether they are entitled to do it? Whether Lokayukta itself can say under the rule that it should be entrusted to them, whether what would be the consequence, my lord, is one of the point which your lordship read. Lord, kindly take the Lokayukta Act. Section 7 deals with the complaint. This is in the nature of an investigation. Section 7 deals with matters which may be investigated by the Lokayukta. Now, in respect of this plot, this is in the nature of a inquiry or investigation to find out prima facie whether any case is made out for proceeding further in the matter.
Yes.
Now, the consequence of a complaint under section 7, after the opportunity is given to them, the next situation is dealt with under section 12 of the Lokayukta Act. Now, 12.1 deals with in relation to a grievance. 12.1. There is a difference between grievance and allegation. Now, grievance deals with injustice or undue hardship.
Yes.
Allegation deals with the public servant abusing the position, guilty of corruption, has failed to act, so and so. Now, under 12.1, my lord, we are not concerned. 12.3 is the relevant portion. If after investigation of any action involving an allegation has been made, Lokayukta or Upalokayukta is satisfied that such allegation is substantiated either wholly or partly. This is important. He shall by report in writing within 6 months from the date of commencement of the investigation, communicate his finding recommendation along with relevant document. Now, the words which are relevant is, one is substantiated. It does not show established. Substantiated only means, Lord, that there is sufficient prima facie material for proceeding further in the matter. And that also, it need not be a complete substantiation. Even a part substantiation is good enough. So the entire scheme is only an opportunity creates another stage before which an inquiry is held. Normally, in the case of domestic inquiries, articles of charge is done, and thereafter a show cause notice is given. Articles of charge also can be formulated after examining what are the materials before the authorities. They will apply their mind and thereafter conduct an inquiry. In this case, in the case of a public servant, there is an additional safeguard provided that even to initiate proceedings in respect of conducting of disciplinary proceeding, now to find out, to see, to avoid all unsubstantiated claims should not be made, a safeguard, additional safeguard is provided to find out whether there is a prima facie case which justifies calling for an investigation. Now, there is two stages. One is at the initial stage of investigation. The second stage is the case of an adjudication. Now, the question is, a person who investigates cannot adjudicate, my lord, is not an accepted principle of law. There are innumerable situations where an investigation done to find out prima facie what is the material before the authorities, and thereafter proceed further and examine it. Suppose, my lord, even in judicial proceeding, now suppose the court expresses its mind in a particular way. Later on, it does not mean, even if it decides in a particular case, that does not mean in the second case the court is biased and therefore they cannot hear it, my lord, is not an accepted proposition. The reason being is that persons who are occupying a particularly judicial officers who are occupying that field, they are in a position to appreciate different facts and are able to take an impartial viewpoint, impartial decision in the matter, notwithstanding their earlier decision in the matter. That being so, my submission, first submission is, the entire report given under 12.3 is not an adjudication of the issues involved. It is only a case where either wholly or partly substantiated. That means it is only a prima facie view that is to be taken. Now, the next question is, now what is the procedure under 14A? Now, kindly see the rule 14A. Now, similar to KPTCL rules, but it is similar to central government rules. So, therefore, I will refer to 14A only. Same allowed. I think this rule is extracted in the paper book.
What was the first rule that was?
Pardon?
This was substituted.
Rule 14A was substituted when Lokayukta Act came into force, plot. That is somewhere in 86. After the Lokayukta Act came into effect.
The earlier rule prior to.
No, earlier 14A was not there. Regular inquiry, my lord, under 11.
Rule 14 is substituted by GSR number dated 7586.
Yeah, that is because Lokayukta Act came into force.
Now, where is that original rule? Because this is a substituted rule that I have.
Substituted alla, newly inserted rule.
ನಂದ್ರಲ್ಲಿ
Rule 14A is substituted with effect from earlier few. The earlier,
the difference between the earlier
yeah, it uses the word substituted, so there must be earlier rule. Earlier rule ಏನಿತ್ತು ಗೊತ್ತೇ? ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಅಂತ ವರ್ಡ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. Rule 14A is substituted 7586 ಅಂತ. I was under the impression because earlier rule cannot be there because Lokayukta Act itself came into effect in 86.
there's some substitution, maybe was it, did it say anything about the earlier Vigilance Commission? or
ಅವಾಗ
something?
earlier I think Central Vigilance Commission ಇರಬೇಕು. ಅದನ್ನು ಐ ವಿಲ್ ಚೆಕ್ ಅಂಡ್ ಪಾಯಿಂಟ್ ಔಟ್. ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಇಲ್ಲ, CVC ಇಲ್ಲ. I think it is substituted for Central Vigilance. That I'll, in all cases, they have substituted where the Lokayukta word is there, there is a substitution. There must be probably Central Vigilance.
ಅಂತ ಅಂದಂಗಿದೆ. Rule 14A itself is substitute ಅಂತ ಹೇಳ್ತಾರೆ, not just the wherever.
No, that substituted it only refers to the first para. Rule 14A clause 1. Then
ಈ ಪುಸ್ತಕದಲ್ಲಿ ಪೂರ್ತಿ ಅಂತ ಕೊಡ್ತಾರೆ.
Rule 14A substituted ಇದ್ರಲ್ಲ ಅದರ
ನಂತರ ಅದ್ರಲ್ಲಿ ಪೂರ್ತಿ ಅಂತ ಬರ್ತದೆ.
ಇಲ್ಲಿಂದ ಇಲ್ಲಿ ತನಕ ಇದೆ ಇದು ಲೈಕ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದರಿಂದ ಇಲ್ಲಿ ತನಕ ಅಥವಾ ಇದು 6 ಪೂರ್ತಿ ಇದೆ ಎಂಟೈರ್ ರೂಲ್. That I'll check up, Lord. I am also not aware as to what was the position. Now, Lord, the Rule 14A only proposes that the inquiry has to be conducted by the Lokayukta, to persons interested by the Lokayukta. Kindly see there. The provisions of sub-rule 2 shall, notwithstanding anything contained in Rule 9 to 11A and 13, be applicable for purposes of proceeding against government servants whose alleged misconduct has been investigated by the Lokayukta. ಏನು?
ಬುಕ್ ಇರಲಿಲ್ಲ.
The provisions of sub-rule 2, Rule 14A, sub-rule 2 shall, notwithstanding anything contained in Rule 9 to 11A and 13, be applicable for purposes of proceeding against government servants whose alleged misconduct has been investigated by the Lokayukta and Upalokayukta, either under its provisions of the Karnataka Lokayukta Act 1984 or on reference from government, or where the offence alleged against them is punishable under the Prevention of Corruption Act 1947 or the Prevention of Corruption Act 1988 has been investigated by Karnataka Lokayukta Police before 21st day of December 92. But the word used is only investigation. Then where the investigation into any allegation against a member of State Civil Services Group A or Group B, member of State Civil Services Group A or Group B, and member of the State Civil Services Group C or Group D, or a member of the State Civil Services Group C or Group D, the Lokayukta or Upalokayukta or before 21/12/92, the Inspector General of Police of the Karnataka or Lokayukta Police is of the opinion that disciplinary proceedings shall be taken. He shall forward the record of the investigation along with his recommendation to the government, and the government, after examining such a record, may either direct an inquiry into the case by the Lokayukta or Upalokayukta, or direct the appropriate disciplinary authority to take action in accordance with Rule 12.
Is this report of the Upalokayukta that is contained in 12.3 different from this opinion of the Inspector General?
No, this is a different. This is different.
There is
The
nothing
Inspector General also can forward a report.
Now, where is it stated? 14A sub-rule 1 says,
The Lokayukta or Upalokayukta, the Inspector General of Police of the Karnataka is of the opinion that disciplinary proceedings shall be taken. He shall forward the record of the investigation along with his recommendation to government. Government, after examining such a record, may either direct an inquiry or direct appropriate disciplinary. This provision for this Inspector General of Police is not there in the Lokayukta Act. Although I think that earlier also the Central Vigilance Commission was there. That is a crucial point your lordship asked, because earlier also whether the similar provision was there in relation to Vigilance Commission has to be seen. That I'll check up. Then, my lord, that clause C, the Lokayukta, the Upalokayukta, or the officer authorized under clause B to conduct an inquiry shall conduct it in accordance with the provisions of Rule 11. In so far as they are not inconsistent with the
Word
provisions.
used in 12.3 is simply shall by report in writing communicate his findings regarding either substantiated or in part or in full, and recommendations along with the relevant documents. 12.3, that is all. He will
12.3.
record, he will communicate his findings and his recommendations.
Yeah.
Here the word used is somewhat different. It says shall be is of the opinion that disciplinary proceedings shall be taken, we shall forward. So this is a different procedure to be followed
Yeah, but
as compared to 12.3.
No, but 12.3.
12.3 does not contemplate of him forming an opinion regarding holding up a disciplinary inquiry. He can only make a recommendation and stop at that. Now this is completely different.
No, but this only says that he is of the opinion that disciplinary proceeding shall be taken.
This
But
is not the
12.3
requirement of 12.3.
12.3 report also, suppose the authorities of the opinion that disciplinary proceedings will be taken, that also recommendation will be part of that report. Your lordships are right in saying 12.3 does not say that.
But 12.3 says he shall record his findings.
Yes.
So findings is as to whether it is substantiated in whole or in part.
Let 12.3 ಇಲ್ಲ ಅಂತ ಅವರು.
ಈ inquiry ಮಾಡಬೇಕು ಅಂದ್ರೆ ಈ part, punishment ಈ part.
ಅದೇ. No, 12.3, my lord, if the 12.3 report also contains a recommendation that disciplinary proceedings shall be taken, then 14A gets attracted.
Not 12.3, let us assume, let us forget 14A for a minute. 12.3 only contemplates, you record a finding as the Upalokayukta, make a recommendation.
Correct.
Matter stops
And
there.
in a case, my lord,
If you
minor.
want to fall back upon Rule 14A.
Yeah.
Then apart from this report, should there be another opinion recommending
No,
disciplinary
but that
proceedings?
report itself can contain an opinion so long as there is a recommendation either in the report or otherwise. If the recommendation is that disciplinary proceedings shall be taken, then only 14A gets attracted.
Why do
Suppose
they
the
use
12.3 report.
Different phraseology in ಒಂದರಲ್ಲಿ recommendations, finding ಅಂತಾರೆ, ಇನ್ನೊಂದರಲ್ಲಿ opinion ಅಂತಾರೆ. What exactly is the, when this Rule 14A was framed, they were aware of the requirement of Section 12.3.
Now, if the 12.3 says that if after an investigation involving an allegation, it says such allegation is substantiated either wholly or solely, along with relevant documents recommendation. If that recommendation includes, now it only, this is a widely worded. Suppose if the recommendation includes an examination that a disciplinary proceedings to be conducted, then my lord 14A will get attracted.
When this 84 Act was enacted, Lokayukta Act, there was no contemplation that you would refer it to the disciplinary proceeding for a disciplinary proceedings. It was generally left to the discretion. You could make any recommendation, record a finding, make a recommendation. But when 14A was inserted or substituted, there is this requirement.
There is that requirement, my lord, your lordships are right. He should form an opinion. He is of the opinion that disciplinary proceedings shall be taken. He shall form.
This Lokayukta will be going beyond the powers conferred under him under 12.3 and forms a separate opinion which is not
Necessary, my lord.
contemplated.
Either so long as the materials are there. Now, my lord, under 12.3 is a very widely worded recommendation, could be anything. Suppose on the basis of the specified facts, if the authority says on these materials, we are of the opinion that disciplinary proceedings are required to be taken, if such a report is given, then Rule 14A also is satisfied. Then the government will have to apply its mind. Then they will have to decide whether minor penalty has to be imposed. They themselves can impose. If it is a case of major penalty, they will have to refer it to them, or they may take a decision otherwise also. They may say that we will not. It is not a case for conducting of an inquiry at all. Also, if that is their opinion, that is also open to them. But in a case, the entire scheme is only this, that if prima facie investigation and opinion material is gathered, let them conduct an inquiry. Ultimately, my lord, what are they doing? He is only acting as an inquiry officer. Now, government can either kindly see, my lord, C and D, very important. The Lokayukta or Upalokayukta or the officer authorized under clause B to conduct an inquiry shall conduct it in accordance with the provisions of Rule 14. In so far they are not inconsistent with the provisions of this rule. For that purpose shall have the powers of the disciplinary authority referred in the said rule. After inquiry is completed, the record of the case along with findings of the inquiry officer and recommendation of the Lokayukta or Upalokayukta as the case may be, shall be sent to the government. On receipt of the record under clause D, government shall take action in accordance with the provision of Rule 11A. In all such cases, government shall be the disciplinary authority competent to impose any of the penalties specified in Rule 8. Now, Rule 11 will not proceeds with the manner in which inquiry is to be held.
Please come back to this. This clause D.
Clause B, Milord,
Where is completed.
where it is proposed. Clause D, na?
After the inquiry is completed. The record of the case along with the findings.
The clause D, after the inquiry is completed, record of the case along with the findings of the inquiring officer and the recommendation of the Upalokayukta as the case may be shall be
Is this
sent.
the recommendation that is contained in 12.3 then?
No. That is not a recommendation under 12.3. 12.3 would arise before conducting of an inquiry. Now, 12.3, my lord, says, for example, my lord, if you lordship will go back to this section Lokayukta Act. Under Lokayukta Act, section 9 deals with the complaint. Section 7 is the filing of the complaint.
14 yearly, it talks about in subclause 3 about an opinion being formed.
That is another opinion. That is on the basis of.
There's an opinion for a disciplinary inquiry. There's a report under 12.3 making a recommendation.
Correct.
Now, then what is this D?
This opinion is after conducting the inquiry, the inquiring authority, which could be either the retired district judges or one of the inquiring officer, resident registrars, along with that, suppose, my lord, a lawyer officer, lower than the Upalokayukta or Lokayukta conducts an inquiry, that inquiry officer will give his findings. On that basis, Lokayukta or Upalokayukta will also give his recommendation. That will be sent to the government.
Already a recommendation under 12.3. Second
No, my
recommendation.
lord, 12.3 is nothing to do with this conductive. That is why I said draw a distinction between an investigation and an adjudication. This adjudication is done on the basis of the material gathered, evidence recorded. So far as, my lord, there is no evidence recorded in the initial stage. That is only a complaint filed, objections are taken. Court find the authority find that there is a prima facie case which justifies proceeding further.
Comments are called for from the delinquent.
Correct.
From the department.
That is an additional safeguard, but that is
records are secured.
That also
Finding is
a
recorded.
prima facie opinion. That is all.
Finding is recorded that the allegations are
Are substantiated wholly or partly.
and a recommendation is made. It
Correct.
could be anything. Recommendation is made.
Recommendation, let us say, my lord, recommendation is for conducting of an inquiry, disciplinary inquiry. Now, after the conducting of the inquiry, on the basis of the material, he cannot just give it on the basis of the 12.3 report. On the basis of the inquiry, my lord, normally what happens in any disciplinary proceeding, government issues the articles of charge. On that basis, an inquiry officer is appointed. Inquiry officer gives his report. That report is forwarded to the delinquent. His explanations are thereafter the government passes an order. In the present case, only the additional factor is the inquiry officer will give his findings as it is done in any other case. One additional requirement is Lokayukta and Upalokayukta will give a recommendation. That is the only additional requirement as compared to a normal inquiry. Otherwise, what they do is just.
Inquiry officer is subordinate to the Upalokayukta.
But, yes, sir.
So.
The retired district.
Judicial officer, retired or serving?
Retired or serving district judges who are called as judicial registrar. Additional registrar and deputy registrar. They will conduct the inquiry. They will give his finding. That findings will go to Lokayukta or Upalokayukta, who will give a recommendation. That recommendation also is not binding on the state government. State government can independently apply its mind and decide.
But 14A survives, 14A was created only because of this 12.3.
Not necessary. Not necessary. No, that is because your lordships are right to an extent. Because the Lokayukta conducts investigation, this has become necessary.
No, because I think the government simply wanted since they have made recommendation, this task of conducting inquiry is also be entrusted to them.
No, that is also, there is another reason because that the allegation of corruption are the only allegations, my lord, which the Lokayukta will examine. Now, in a case, my lord, a Lokayukta is supposed to be headed by a highly persons occupying highest office, persons of established integrity who have discharged their work, judicial work also. So, in a case, unlike the government itself doing it, the government, while enacting, thought that there will be an independent machinery who will examine this issue and give its report. That is because this creates an efficient and efficacious mechanism for examining allegations of corruption and other maladministration in the matter. So, in an individual case, my lord, may be a different matter. I am not saying that in all cases there will be everything will be done hunky-dory is not my case.
That's the only aspect which is troubling me from that time.
But to say that in all cases a person, suppose, my lord, the civil court grants an injunction order, prima facie.
That is before trial.
No, here also before trial.
Yes,
No, this is, my lord, an additional safeguard given to them.
Yes, complaint is furnished to him.
Correct.
His comments are obtained, not only from him, from the department, records are obtained. And
then they should go for straightaway punishment.
High ranking.
I understand, my lord. I understand, but still, the statute, persons who have framed the statute deem it fit. That notwithstanding that.
That's why I said when they framed the statute, this was not in their contemplation. That the Lokayukta should also be given the power to conduct an inquiry.
It has been done simultaneously. It has been done simultaneously. Act came into.
They was not able to secure that particular.
1986. Well, there is an interesting US Supreme Court judgment. Let me just have a look at this judgment.
Came about in 83.
Copies idea. This very same issue, similar, almost according to me on similar lines, was examined by the US Supreme Court. Though there are similar judgments from our High Court also. Look at page 46, internal page 46. That part 3 of the judgment, the district court framed the constitutional issue which it addressed as being whether for the board temporarily to suspend Dr. Larkin's license at its own contested hearing on charges evolving from its own investigation. Page 46.
The district court framed.
Roman 3 ideyala. The district court framed the constitutional issue which it addressed as being whether for the board temporarily to suspend Dr. Larkin's license at its own contested hearing on charges evolving from its own investigation would constitute a denial to him of his rights to procedural due process. This was the question formulated. The discussion
was to temporarily suspend them, more in the nature of
but the principle that is under examination in this judgment is whether a person who conducts investigation, thereafter they themselves can hear on the charges. That was the issue. Then, my lord, next page, my lord, page 47, second para. The contention, second para, the contention that the combination of investigative and adjudicative function necessarily creates an unconstitutional risk of bias in administrative adjudication has a much more difficult burden of persuasion to carry. It must overcome a presumption of honesty and integrity in those serving as adjudicators. And it must convince that under a realistic appraisal of psychological tendencies and human weakness, conferring investigative and adjudicative powers on the same individual poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of the due process is to be adequately implemented. Very similar claims have been squarely rejected in prior decision of this court in FTC versus Cement Institute. Federal Trade Commission had instituted proceedings concerning respondents' multiple basing point delivered pricing system. It was demanded that the commission members disqualify themselves because long before the commission had filed complaint, it had investigated the parties and reported to Congress and to the president and its members had testified before congressional committees concerning the legality of such pricing system. At least some of the members had disclosed their opinion that the system was illegal. The issue of bias was brought here and confronted on the assumption that such an opinion has been found by the entire membership of the commission as a result of its prior official investigation. Court rejected the claim, saying that the fact that the commission had entertained such views as the result of its prior ex parte investigation did not. The only distinction which can be brought is the earlier is ex parte, but here notice is given. That does not change the scenario, is my submission. Did not necessarily mean that the minds of its members were irrevocably closed on the subject of the respondent basing point practices. Here, in contrast to the commission investigation, members of the cement industry were legally authorized to participants in the hearing. They produced evidence, volumes of it. They were free to point out to the commission by testimony, by cross-examination of witnesses, by arguments, conditions of the trade practices and attack, which they thought kept these practices within the range of legally permissible business activities. In specific response to a due process argument, the court asserted no decision of this court would require us to hold that it would be violation of procedural due process for a judge to sit in a case after he had expressed an opinion as to whether certain types of conduct were prohibited by law. In fact, judges frequently try the same case more than once, decide identical issues each time, although these issues involve questions both of fact and law. Certainly, the Federal Trade Commission cannot possibly under stronger constitutional compulsion in this respect than a court. This court also ruled that a hearing examiner who has recommended findings of fact after rejecting certain evidence as not being probative, was not disqualified to preside at further hearings that were required when reviewing courts held that the evidence had been erroneously excluded. In NLRB also, the Court of Appeals had decided that examiner should not again sit because it would be unfair to require the parties to try issues of fact to those who may have prejudged them. But this court unanimously reversed, saying, certainly it is not the rule of judicial administration that statutory requirement apart, a judge is disqualified from sitting in a retrial because he has reversed an earlier ruling. We find no warrant for imposing upon administrative exigencies a stiffer rule, whereby examiners would be disentitled to sit because they ruled strongly against a party in the first hearing. Thereafter, Lord, the next page. There is further discussion, a detailed discussion. Lordship may go to page 56. 56, about 7 lines from the bottom. It is also very typical for the members of administrative agencies to receive the results of investigation to approve the filing of charges or formal complaint, instituting enforcement proceeding, and then to participate in the ensuing hearing. This mode of procedure does not violate administrative procedure. It does not violate due process of law. We should also remember that it is not contrary to due process to allow judges and administrators who have had their initial decision reversed on appeal to confront and decide the same question a second time around. Here, the board stayed within the accepted bounds of due process. Having investigated, it issued findings and conclusion asserting the commission of certain act, ultimately concluding that there was probable cause to believe that appellee had violated the statute. The risk of bias or prejudgment in this sequence of function has not been considered to be intolerably high or to raise a sufficiently great possibility that the adjudicators would be so psychologically wedded to their complaint that they would consciously or unconsciously avoid the appearance of having erred or changed position. Indeed, just as there is no logical inconsistency between finding of probable cause and an acquittal in a criminal proceeding, there is no incompatibility between the agency filing a complaint based on probable cause and a subsequent decision when all the evidence is in that there has been no violation of the statute. Here, if the board now proceeded after the adversary hearing to determine that appellee's license to practice should not be temporarily suspended, it would not implicitly be admitting error in its prior finding of probable cause. Its position most probably would merely reflect the benefit of a more complete view of the evidence afforded by an adversary hearing. The initial charge or determination of probable cause and the ultimate adjudication have different bases and purposes. The fact that the same agency makes them in tandem, they relate to the same issues, does not result in a procedural due process violation. Clearly, if the initial view of the facts based on evidence derived from non-adversarial process as a practical or legal matter foreclose fair and effective consideration at a subsequent adversary hearing, leading to ultimate decision, a substantial due process question would be raised. But in our view, this is not the case. That the combination of investigative and adjudicative function does not, without more, constitute a due process violation, does not, of course, preclude a court from determining from the special facts and circumstances present in the case before it that the risk of unfairness is intolerably high. Finding of that kind would made by judges with special insights into local realities are entitled to respect. But injunctions resting on such factors should be accompanied by at least minimum findings required under 52 years also. Now, I would say, Lord, that merely because these are all who are the persons who are deciding, these are all persons, Lord, who have been working in either working or retired from the judiciary. They are expected to exercise their judicious mind merely because they make a recommendation. Does it mean that they should adhere to that earlier recommendation only? They are entitled to examine the material, and that again is subject to judicial review. And administrative control. ಅರ್ಬಟ್ಟೆ ಹೇಳೋದು ಅವರು ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್ ಅಲ್ಲಿರೋರ್ಗು ಹೈಕೋರ್ಟ್ ಕಂಟ್ರೋಲ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಇರ್ಲಿ. ಅದೇ
ನನ್ನ ರಿಟೈರ್ಡ್ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್, ರಿಟೈರ್ಡ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ರೆಕಮೆಂಡೇಶನ್ district judge, pragmatically speaking, to give a finding, especially when recommendation is
he
made.
should give, Lord. He should give. That is why.
Sorry, he should ತುಂಬಾ ideally ಏನೇನೋ ಮಾಡ್ಬೇಕು, but
ಅಲ್ಲ, but in a given case, my Lord, court can always examine. But does it mean the rule is bad on an assumption that they will do like this? The question is
that element of unconscious bias.
Whether it can be called as an unconscious bias if a person who hears the matter at a particular stage forms an opinion.
In the eyes of the delinquent, what would be his feeling? Retired high court judge has given a recommendation that inquiry should be conducted. His subordinate conducts an inquiry.
And he can say, my Lord, in every case.
He can say, but for him, what is the concept of justice that he would be thinking?
Lord, he is expected to act. He is not bound by the earlier opinion. If they are become so, I mean, they lose their independent mind. What can be done?
Like an executioner saying something, and the AE is saying, no, that is wrong.
Lord, can there be an assumption that everybody will do like that? Therefore,
the perception, not an assumption. It's a perception of the delinquent. He is the ultimate victim if something.
Yes. Lord, how does he have that perception? Suppose if authority decides the matter, conducts investigation, if there is any specific allegation of bias, and also the person who conducts investigation and the person who decides are not the same persons. He is not the same person.
Chain of command ಅಲ್ಲಿ ಅವರು
ಅಲ್ಲ, ಚೈನ್ ಆಫ್ ಕಮಾಂಡ್ ಅಲ್ಲಿ ಇವರೇನು ಯಾರು ಹಿಂದೆ ಯಾವಾಗ ಕೊಟ್ಟಿರ್ತಾರ, ಯಾವ ಆ ಲೋಕಾಯುಕ್ತ ಇರ್ತಾರ ಇಲ್ವೋ ಅದು ಗೊತ್ತಾಗ.
Will be conducted by the Upalokayukta, Lokayukta based on the police complaint of the very same mistake.
ಇದರಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ.
And based on that 7 investigation, 12 and based on 14.
ಅಲ್ಲ, ಇವ್ರದ್ರಲ್ಲಿ what is the allegation here in this case? If you go to the pleading, there is nothing.
I'm not in the facts of this case.
No. If we go to the issue of pleading, there is no pleading to say that the rule is bad for any specific reason. There is no apprehension. That apprehension should be there. In fact, there is one case, Lord, where they say similar issue has been negative. Sunil Dutt Yadav, ಅಲ್ಲ?
Was there a challenge to the rule there? Was there a challenge to the rule there?
No, ಇಲ್ಲ, rule challenge ಇಲ್ಲ, but the allegation of bias was made. Para 20 onwards. Rule is also extracted in that. Bias ಬಗ್ಗೆ ಇಲ್ಲ ಅಂತ. Para 30, my Lord, is the answer.
This is on a slightly different context in the sense,
No, but
because
the
the
law
criminal
is,
case was registered.
no, but the issue is, he says that this argument is advanced, para 30. The apprehension that case having been registered by Lokayukta police and charge sheet having been filed, there would be bias in the departmental inquiry conducted is slightly by the same authority is not legally entertainable. That
Para
is the-
31, they say that because it was taken away in interest to the Anti-Corruption Bureau, that is also not there, Adikoskara.
This is with reference to the criminal case and departmental inquiry.
And in that case, because of the entrustment to ACB, that question was not really.
Criminal case.
Criminal case.
Allegation.
This is a right case. This is a right.
Lord, with regard to some of the case laws of India where the similar issues have been said that there is no question of bias in such matters, I am producing some judgments. Andele judgment. The first case is, the first case is of Kondal Rao in relation to this motor vehicles transport at Lord, at page 9, page numbers are at the bottom. Page 9. From the top, 10 lines from the top, Gullapalli Nageshwar Rao versus State of Andhra Pradesh. After that, there, as in this case, it was contended that the Chief Minister who was in charge of the portfolio of transport could not be a judge in his own cause, as he was biased against the private operators. This court pointed out.
Para 9.
The page 9, Mala. Page numbers are at the bottom. On the top, 10 lines from the top, Gullapalli Nageshwar Rao. There, as in this case, it was contended that the Chief Minister who was in charge of the portfolio of transport could not be a judge in his own cause, as he was biased against the private operators. This court pointed out the distinction between official bias of an authority, which is inherent in a statutory duty imposed on it, and personal bias of the said authority in favor of or against one of the parties. In dealing with official bias, this court, after considering relevant English decision, observed these decisions on the ground of bias is tolerated with decisions, but the invasion is confined strictly to the limits of the statutory exception. It is not out of place here to notice that in England, the Parliament is supreme and therefore a statutory law, however repugnant to the principles of natural justice, is valid. Whereas in India, the law made by Parliament or a state legislature should stand the test of fundamental rights declared in Part 3 of the Constitution. Then this court proceeded to state that the provisions of the Act did not sanction any dereliction of the principles of natural justice. For the Act visualized in case of a conflict between the undertaking and the operators of the private business, that the state government should sit in judgment and resolve the conflict. Much to the same effect has been stated by Justice Shah in the Narayanappa's case. The learned judge stated, it is also true that the government on whom duty to decide dispute rests is substantially a party to the dispute, but if the government or the authority to whom the power is delegated acts judicially in approving or modifying the scheme, the approval or modification is not open to the challenge on presumption of bias. This is important. The minister or the officer of the government who is invested with the power to hear objection to the scheme is acting in his official capacity. Unless there is reliable evidence to show that he is biased, his decision will not be liable to be called in question merely because he is a limb of the government. Then in the next page, in the above cases, the transport department of the government was the transport undertaking, but here the State Transport Road Corporation, which is a body corporate having perpetual succession and common sale is the transport authority. Though under the provisions of the Act, state government has some control, it cannot be said either legally or factually that the said corporation is a department of the state government. The state government, therefore, in deciding dispute between the said undertaking and the operators of private buses, is only discharging its statutory functions. This objection, therefore, has no merits, nor can we say that it has been established that the ministry in charge of the portfolio of transport has been actuated by personal bias. The fact that he presided over subcommittee constituted to implement the scheme of nationalization of bus services in West Godavari district does not in itself establish any such bias. Indeed, in the counter affidavit filed on behalf of the first respondent, the contents and authenticity of the reports of the proceedings of the subcommittee published in Telugu Daily Andhra Patrika were not admitted. Even if the subcommittee came to such a decision, it is not possible to hold that it was a final and irrevocable decision in derogation of the provisions of the Act. It was only a policy decision, and in the circumstance could only mean that the subcommittee advised the state government to implement the policy of nationalization of bus services in that particular district. The said decision could not either expressly or by necessary implication involve a predetermination of the issue. It can only mean that the policy would be implemented subject to the provisions of the Act. It is not suggested that the ministry in charge of the concerned portfolio has any personal bias against the operators of private buses or any of them. We therefore hold that it has not been established that the ministry in charge of the portfolio of transport had personal bias against the operators of private buses, therefore disqualified. So this judgment, my lord, I am relying upon to show that in an individual case, unless personal bias is demonstrated, merely because they are occupying an official position cannot be the basis for attributing bias, my lord, in such a situation. The next judgment starts from page 17, is in relation to chapter 10 of the Constitution of India in relation to disqualification. There I will only point out. The allegation was the speaker who decides is a biased person, so therefore he shall not decide, my lord, was the question raised before the Supreme Court. The question formulated. Questions formulated in the second paragraph. The question formulated. Lord, at page 38. At page 38, para 17. Yes. About 10 lines from the last 10 lines of para 17. Yes. It is also urged that the investiture in the speaker or the chairman of the power to adjudicate disputed defections would violate important incident of another basic feature of the Constitution, which is parliamentary democracy. It is contended that an independent, fair and impartial machinery for resolution of electoral dispute is an essential and important incident of democracy, that the vesting of the power of adjudication in the speaker or the chairman, who in the Indian parliamentary system are nominees of political parties, are not obliged to resign their party affiliation after election, is violative of this requirement. Then, my lord, at para 24, at page 40, at page 41, point formulated, point number G, points are formulated. Their clause G, my lord, deals with the same issue. I will not read it because the same issue is reiterated. Points formulated at clause G. Concept of free and fair election as a necessary concomitant attribute of democracy, which is a basic feature, includes an independent, impartial machinery for adjudication of electoral dispute. The speaker and chairman do not satisfy this incident of an independent adjudicatory machinery. The investiture and determinative of the adjudicative function in speaker or the chairman, as the case may be, would by itself vitiate the provision on the ground of reasonable likelihood of bias and lack of impartiality, therefore denies the imperative of an independent adjudicative machinery. The speaker and chairman are elected and hold office on the support of the majority party, are not required to resign their membership of the political party after the election to the office of the speaker. This was the question that was formulated. This followed at page 78. Para 113.
Yes.
Page para 113, my lord, same thing is, same question is once again, argument is extracted. Answer is at page 108. Page 18, para 181. Page 108, para 181. The speaker being an authority within the house and his tenure being dependent on the will of the majority, therein likelihood of suspicion of bias could not be ruled out. The question as to disqualification of a member has adjudicated disposition. Therefore, decision to be rendered in consonance with the scheme for adjudication of dispute. Rule of law has in it firmly entrenched natural justice, of which rule against bias is a necessary concomitant. Basic postulates of rule against bias are nemo judex in causa sua. A judge is disqualified from determining any case in which he may fairly be suspected to be biased. And it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. This appears to be the underlying principle adopted by the framers of the Constitution in not designating Speaker as the authority to decide election dispute. Question as to disqualification of members under 103, 192, 329, and opting for an independent authority outside the House. The framers of the Constitution had in this manner kept the office of the Speaker away from this controversy. There is nothing unusual in this scheme. If we bear in mind that the final authority for removal of a judge of the Supreme Court or High Court is outside the judiciary in the Parliament under 124(4), on the same principle, authority to decide the question of disqualification of a member of the legislature is outside the House. Next, this is with regard to this. In the 10th schedule, para 182, the Speaker is made not only the sole but final arbiter of such dispute, with no provision for any appeal or revision against the Speaker's decision to any independent outside the authority. This departure in the 10th schedule is a reverse trend and violates the basic feature of the Constitution, since Speaker cannot be treated as an authority contemplated for being entrusted with this function by the basic postulates of the Constitution, notwithstanding the great dignity to that office to attribute. No, this is minority opinion. So the majority opinion is upheld. This point was not accepted, but para. Let us pay para 113. Yeah, 113, page 78.
Yes.
Correct answer ಮಾಡಿದ್ದಾರೆ ಯಾವ ತರ 113 is an argument of
regarding the finding.
Para 113, it is also urged that the Speaker under the Indian parliamentary tradition is not required to resign his membership of the political party on whose strength he gets elected, that inevitably the decision of the Speaker is not free from the tucks and pulls of political polarization. It is urged that the Speaker who has not resigned his membership of the political party cannot be impartial. At all events, his functioning will not be free from reasonable likelihood. This was the argument. Then, beloved, at 115, the question is whether the investiture of the determinative jurisdiction in the Speaker would by itself stand vitiated as denying the idea of an independent adjudicator authority. We are afraid the criticism that the provision incurs the vice of unconstitutionality ignores the high status and importance of the office of the Speaker in a parliamentary democracy. Office of the Speaker is held in the highest respect and esteem in parliamentary tradition. The evolution of the institution of parliamentary democracy has at its pivot the institution of the Speaker. Speaker holds high important ceremonial office. All questions of the well-being of the House are matters of Speaker concern. The Speaker is said to be the very embodiment of propriety and impartiality. He performs wide-ranging functions, including the performance of important functions of judicial character. Then, beloved, 1116, they refer to Mavlankars and Eskin May. Then, beloved, para 118. It would indeed be unfair to the high traditions of that great office to say that investiture in it of this jurisdiction would be vitiated for violation of a basic feature of democracy. It is inappropriate to express distrust in the high office of the Speaker. merely because some of the speakers are alleged or even found to have discharged their function, not in keeping with the great traditions of that high office. The ropes of the speaker do change and elevate the man inside. Accordingly, the contention that vesting of adjudicatory function in speaker chairman would by itself vitiate the provision on the ground of likelihood of political bias is unsound and is rejected. Speaker chairman hold a pivotal position in the scheme of parliamentary democracy. Under guardians of the rights and privileges of the House, they are expected to and do take far-reaching decisions in the functioning of parliamentary democracy. Restituted of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptionable. But in the present case also, persons who occupy the high office of Lokayukta, if they say, no, you will have to do only what I tell you to do, all subordinate officers should fall in line. Well, they are expected to say, give an open mind to these persons that after examining facts, you are entitled to take a different opinion. In a mere, on an assumption, no law can be struck down on an assumption that the law will be misused by some of them. Ultimately, there are persons who have occupied the high office of Lokayukta, and how ultimately, my lord, any institution will work depend on the individuals. Any institution for that matter, will ultimately, the credibility of the institution depends upon the persons who had that institution. Well, then there are one or two judgments which I have produced. Then page 111 is the judgment of a Bombay High Court.
Yes.
At 114, about 10 lines from the bottom, 114. So far as the argument relating to bias of the Honorable Minister to hear the objection is concerned, it is contended by Shri Paranjape that under 43 of the Act, it is the state government alone which can issue direction. MRTC is an independent statutory corporation, so also local authority undertaking. The Honorable Minister has no personal interest in the matter. The Honorable Minister who heard the objection was in charge of the transport department as a whole and not of MSRTC alone. Therefore, it cannot be said that he was in any way disqualified from hearing the objection. In support of this contention, Paranjape placed reliance on the decision of Kondal Rao, which I have already extracted. It is also similar to this. That Gullapalli Nageshwara. Then, my lord, at page 128 is a Calcutta High Court judgment.
Yes.
At page 129, para 4. The main ground of attack on behalf of the petitioner against the impugned orders for eviction and arrears is that the proceedings were initiated, heard and determined by the estate officer, who is undisputedly an officer of under the Life Insurance Corporation, and the very dispute being related to recovery of possession and other reliefs in respect of premises which belong to the corporation itself. The entire proceeding stood vitiated because of the principle of bias, which the estate officer as an officer of the corporation cannot but have for in favor of its employer, the corporation. This contention appears to have been clearly negated by the Delhi High Court by Justice Dua in M.L. Joshi versus Director of Estates in AR 67 Delhi, in the decision of Punjab and Haryana High Court in MS Obira, where the Delhi decision was followed. A similar contention was also raised before 7-judge bench of the Supreme Court in Maganlal Chaganla. The contention of not having been accepted by Supreme Court. This argument should not detain me in any further, but in view of the importance of the question and its frequent emergence even today in respect of allied and cognate legislation, whereunder an officer of the government or a statutory corporation is entrusted with the function of deciding disputes between the government or the corporation on the one hand and others on the other, I would like to add a few words of my own. To vitiate a judgment or other determination, the bias of a judge or any other authority required to act judicially or quasi-judicially must be of personal or pecuniary in nature. An officer of a government or any other statutory authority does not have, or at least cannot be presumed to have, any personal or pecuniary interest in the matters of the government or corporation, and the only interest that he can have or can be presumed to have is an official interest of impersonal nature. Such impersonal official interest cannot be regarded to be of the nature of bias to vitiate his action. I must not be taken to have ruled that an action or decision taken or arrived at by an officer of the government or statutory corporation in a dispute between the government and the corporation and a third party can never be vitiated by bias. If the officer concerned has manifested a hostile attitude or animosity towards the other party, that would demonstrate bias of a personal nature, which would be bad enough to vitiate the proceeding. But otherwise, there cannot be a straitjacket formula of universal application to the effect that any adjudication by an officer of the government or other statutory authority in any list to which such authority the party must stand vitiated because of bias. The Lord Chancellor is the Chief Judicial Officer in United Kingdom. He is the President of House of Lords sitting as the final court of appeal, but is also a cabinet minister. But his interest in governmental matters being official only, his decision in a case to which government is a party, even in favor of the government, cannot be regarded to have been vitiated by bias. May we remind ourselves that in the American Supreme Court decision in international celebrity, Marbury versus Madison, Chief Justice Marshall, who delivered the opinion of the court, was also acting Secretary of State at the relevant time and signed the commission appointing Marbury. It is now settled law, as would appear from decisions of the Supreme Court in A.K. Kripa, that these rules of natural justice can operate only in areas not covered by any law validly made. In other words, they do not supplant the law, but supplement it. It is true that if statutory provision can be read consistently with the principles of natural justice, importation of those principles do not affect basic structure of the statutory provision. The statutory provision, whenever possible, must be so read, but otherwise the rules of natural justice shall stand outweighed by the legislative provisions. Yeah, last. The next Kerala judgment is also similar to the effect. That page 133 is the Kerala judgment, full bench judgment. Para 5 of the judgment at page 134. Statute 10.5 provides for inquiry, 10.7 for finding by the inquiry authority in regard to charges. Under statute 10.9, the disciplinary authority, if it is not the inquiry authority, is to consider the record of inquiry and record its findings. In the light of these provisions, there is no substance in the contention that the management can only initiate the inquiry but cannot process or proceed with the same. The argument of counsel for appellant was that in a case where the management itself is the accuser or prosecutor, it cannot conduct the inquiry either directly or indirectly, that the rule of natural justice enjoining a person not to be a judge in his own cause should be applied to disqualify the management in such a case from conducting or directing inquiry. It was argued that statute 10.1c should be read down as to conform to the fundamental principle of natural justice, that the said principle should be read into the statute. Counsel cited the well-known passages from Prom United Breweries, so and so. At page so and so, it is stated, my lords, if there is one principle which forms an integral part of English law, it is that every member of a body engaged in judicial proceeding must be able to act judicially. It has been held over and over again that if a member of such body is subject to a bias, whether financial or otherwise, in favor or against either party to the dispute, or is in such a position that a bias must be assumed, we ought not to take part in the decision, even to sit upon the tribunal. This rule has been asserted not only in the case of courts of justice and other judicial tribunals, but in the case of authorities, which though in no sense be called courts, have to act as judges of the rights of others. From the above rule, it necessarily follows that a member of such body, as I have described, cannot be both a party and a judge in the same dispute, and that if he has made himself a party, he cannot act as a judge. If he does so, the decision of the whole body will be vitiated. Then, my lord, after referring to Gullapalli Nageshwara, there is a conclusion, no? Then para 11, my lord, at page 135. Yes. At para 130, page 136, my lord, on the top. Page 136, on the top. What interest in a judicial or quasi-judicial does the law regard as sufficient to incapacitate a person from adjudicating on it, or assisting in adjudicating on the ground of bias or appearance of bias? It is of course clear that any direct pecuniary or proprietary interest in the subject matter of proceeding, however, shall operate as an automatic disqualification. Such a case, the law assumes bias. What interest short of that will suffice. In the present case, it is claimed that a reasonable suspicion of bias is enough. It is true that there are dicta and passages to be found in judgment which lend some color to this claim, but the authorities as a whole are almost overwhelming in support of the requirement. To use well-known words of Justice Blackburn, as a real likelihood of bias must be proved to exist before proceedings will be initiated on the ground that a person who has taken part or assisted in adjudicating them was in law incapacitated by interest from doing so. The argument was subsequently, that argument was negative. At para 14. The counsel for the appellant argued that while principle of natural justice may be overridden by a statutory provision, same result cannot be achieved by subordinate legislation such as the rules as in the present case by university statute. We do not think the argument is tenable. In Sukhdev Singh versus so-and-so, the Supreme Court observed, in England, subordinate legislation, if validly made the full force and effect of a statute, it differs from a statute that it is validity whether as respects of form or substance is normally open to challenge in courts. Subordinate legislation, if validly made the full force and effect of a statute, that is so whether or not statute under which it provides expressly, that is to have the effect as if enacted therein. Then in the next para they say, we see no force in the argument. But ultimately, if this rule 14A is taken away, the power of the Lokayukta will be virtually toothless and then ಬಾಗಿಲಾಕೊಂಡು ಹೋಗ್ಬೇಕಷ್ಟೇ. ಇನ್ನೇನು ಅವ್ರಿಗೇನು?
They'll be confined to the original intent.
But
they'll be confined to act in accordance with the original intent.
No, what is the recommended point in giving a 12-3 report and thereafter not following it up? The ultimate object is that there should be an independent machinery to deal with corruption.
But the act does not contemplate all that.
The
Give
act
three
does
options.
not contemplate, my lord, but that has to be read along with the service rule. Now, the act says recommendation to be made. Now, after recommendation, now, my lord, the power is given under this to strengthen this entire mechanism only. Now, the consequence is the government itself will conduct an inquiry. There are innumerable cases where, my lord, a recommendation, for example, well, recently there was a case where a sanction was given to prosecute. Then a representation is given by the delinquent official. Then after the committee also says, no, this has to be sanction has to be given. Then it goes to the cabinet, they reject it. If the persons again.
There's a provision under the act saying that if during investigation, the Lokayukta comes to the conclusion a criminal offence has been done, then the decision of this to initiate prosecution, there's a deemed sanction. There's no question of seeking.
Under 15, the problem is a Lokayukta cannot go and stand as if as a complaint. That is why it is never used. The provision is such that
there is a provision, whether they want to use it or not, that is up to them.
That provision, Lord, cannot be made use of because he will file a complaint. He himself will have to prosecute. That system, Lord, has become unworkable. But the point here is.
Can't be a ground. It depends on the person who occupies the office.
Correct. On that ground only, my lord, here also rule cannot be struck down. Rule cannot be struck down on an assumption that in a particular case there is a likelihood of in a particular case, if there is likelihood of bias, if the authority comes to the conclusion without there being any material and record, that can be struck down. But to make an assumption,
if the legislature wanted to do that, it would have done so clearly under the Lokayukta Act. Why do you have to follow on a subordinate
legislation? It does not matter, my lord. Now it is done. The question is whether the rule is bad.
Subordinate legislation, not by the legislature.
Very well.
If
now
they
in
had
the
done
state,
that under the Lokayukta Act, saying that they themselves will conduct an inquiry, the matter would end there.
But if the state government does not want inquiry, they can earlier when the ACB was also abolished, in that judgment also, the basis of abolition is that there should be an independent machinery to examine this. To make an assumption, the entire argument of the petitioner saying that the rule should be struck down is, no, you have made an investigation, so you have no opportunity, you will not change your mind. So once you have made a recommendation, you will never change your mind. That assumption is not correct. These are the persons who are discharging are well-trained judicial officers. It is not given some officer who does not know how to decide cases. These are persons, who are well-versed in deciding cases. To make an assumption, No, if Lokayukta, we have given an opinion, therefore we are bound to give a similar opinion, my lord. Such an assumption is not correct because they are expected to, inquiring authority will have to look into the materials produced before him and then make a recommendation. If we make such a recommendation, that with judicial review, it will be struck down. But to say that a rule, under what circumstances, my lord, a rule can be struck down, if it is contrary to the parent statute, or if it is manifestly arbitrary. Is it a case where the court can assume that this is a rule which is manifestly arbitrary, or it is violative of any fundamental rights or any constitutional? None of those circumstances exist. Therefore, there is no justification to say. Otherwise, it will become a toothless tiger. Lokayukta will make a recommendation, and on that recommendation, the government will generally sit on it. Either they may do it or they may not do anything. The very object of strengthening a machinery against fighting corruption will get defeated.
They should amend the Lokayukta Act and provide for some.
No, we don't amend, my lord, state government.
Legislature should do it, not.
No, the question is whether on the basis of the what happens in Vidhan Sabha, ನಮಗೇನು ಗೊತ್ತಾಗಲ್ಲ. ನಾವು ಇರೋದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು. ಈಗ
314A, mechanism as understood by government, because they are interesting to us. That is how even the government have framed and understood.
So therefore, the question is whether the rule as it stands should be struck down. Now, suppose the rule is struck down. What happens? Now there is a rule is a complete scheme. That is, a Lokayukta acts as an inquiry officer, gives its recommendation. Suppose if it is a minor penalty, they need not give under 14A at all. They themselves will issue a show cause notice, thereafter decide. Now, in this flood, he acts, this is nothing but appointing an inquiry officer. How is it different from appointing an inquiry officer, except that they function under Lokayukta? The only basis on which this can be criticized is that they function under Lokayukta, they will be carried away by a 12-3 report. If they do it, my lord, in a given case, that is an absolutely wrong way in which the power is to be exercised. They will have to examine the findings material before them in the inquiry, which is being conducted with the inquiry officer. And that should be based on that report only. So where is the question of going back to 12-3 report when the entire matter has to be reinvestigated? That also can be. And another thing is, the person who gives a 12-3 report, conducts investigation, will not be the person who conducts adjudication. That also could be made clear to see that some kind of a transparent machinery is worked out.
ಯಾರಿಗೆ ಎನ್ಕ್ವೈರಿ ಹೋಗುತ್ತೆ ಅಂತ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಅಲರ್ಟ್ ಆಗುತ್ತೆ.
ಅದೇ ಈಗಲೇ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಈಗಲೇ ಹಾಗೆ ಇದೆ. ಅವ್ರು ಮಾಡಿದವರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದವರು ಕೊಡೋದಿಲ್ಲ ಅಂತ.
ಕೊಡೋದಿಲ್ಲ, ಅದು ಕಂಪ್ಯೂಟರ್ ಆಟೋಮ್ಯಾಟಿಕ್ ಅಲಾಟ್ಮೆಂಟ್.
ಆ ACB ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೂ ಈ ಪ್ರಾವಿಷನ್ಸ್ ನ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರು. At para 230, the last 3 pages. Para 230. The provisions of KL Act, which is enacted for the eradication of the evil of corruption and maladministration, must be construed liberally so as to advance the remedy, in our opinion. There is absolutely no merit in the impugned executive order passed by the state government in exercise of the powers under the provisions of Article 162 of the Constitution of India. And the impugned order cannot be sustained. It is also not in dispute that before enacting the KL Act, public opinion has been agitated for a long time over the prevalence of corruption in the administration, and it is likely that cases coming before the independent authorities like Lokayukta or Upalokayukta might involve allegation of actual evidence of corrupt motive and favoritism. We think that the institution of Lokayukta should deal with such cases as well. It is also relevant to refer to the main features of Lokpal and Lokayukta Act. We have no doubt that the working of the institution of Lokayukta in Karnataka will be watched with keen expectation and interest by the other states in India. We hope that this aspect would also be fully borne in mind by the government in considering the urgency and importance of independence of Lokayukta. A Lokayukta to function as a sentinel to ensure a corruption-free administration. As already stated, Supra, the objects of KL Act and PC Act is to achieve a common object and the goal of corruption-free society. Common man has immense faith in the institution of Karnataka Lokayukta and also its police will. That too after handling investigation relating to mining scam. Earlier, the common man would have filed the complaint against anybody to set the law in motion under PCI. There was no bureaucratic impediment or decision required to initiate proceeding against a complaint. However, ACB was set up abruptly with an intention to take control of pending investigation against high functionaries of the state bureaucrats, etc. In order to protect and scuttle the investigation against political class and bureaucrats, government order so and so came to be issued constituting ACB. But then they refer to the Rangaswamaya's case and other. They also refer to various Supreme Court judgments in relation to taking action against corrupt officers. Although there are two writ petitions filed by the Lokayukta, this locus of Lokayukta, my lord, there are separate petitions that can be separately heard with regard to law.
think prior to this particular rule, the Vigilance Commission was himself the disciplinary authority. That's state government. So the actual disciplinary authority stands ousted the moment it's on a reference or on a complaint to the Vigilance Commission. The actual employer is taken out of the scenario. The Vigilance Commission, the government comes into picture. For the purpose of conducting a rule and for exercising the power under Rule 11. Clause D no. He will exercise the power of the disciplinary authority. She'll have the powers of no, she'll be a disciplinary authority in Basically, 14A2 makes the disciplinary authority with the state government in cases of investigation conducted by the local.
It's a long-standing rule. That also not for the who is there on a long-standing.
That is what is troubling.
Every day is included. You do not know, not we are, you always think that the court will always. That is the matter. This is the idea. But isn't that what they do is taken in the person who is individual is not accepted in the judicial system.
Yes. Page 58. Yes.
There not be any possibility of judges being delayed or being not unclear. These are the matters which are very difficult to be defined and demarcated with the decision. Some element of uncertainty is present. They can be remote or branch. The factor of the is that matters with somewhat greater extent. Consistent of the institution that there should be clinical data, essentially practice before the system. Inserted instances of vegetarian which would have preferred the respondents to insert such a provision in an act. The baby is rejected with it. It may not even be proper to include such amendments with reference. Once if you know that these amendments are relevant to such an important area, after ordinary motive, it is different to different cases where element of error is shown and where it would not be not very precise way of testing. Even in a group, the person possessing the special knowledge may be a particular group, influence the group, and which bias may operate in a subtle manner. The general principles of bias are equally applicable to a two-state Reasonable apprehension is equitable possible apprehension, therefore, especially whether the defendant reasonably apprehends as is attributable to a member of the criminal. According to the apprehension of apprehension of bias is attributed to the course of taking the view that is very remote relationship with them. Apparently, the 16 is because the position of damage of the selection to the course of therapy is the damage was not sustainable. It is equal to rule of the probability of the reasonable apprehension of beginning for absolute agreement or justice in the reasonable restriction between the that is not enforced. The first category is final. The force of unfair against of real include as reasonable conclusion. These doctors will discuss the so the court that real include as reasonable conclusion. The really difference that determination of the basis of the whole reasonable lab would in the circumstance. People that means in likelihood of bias are wrong. The court has to examine the matter from the viewpoint of the people. The word bias in particular is that's included between the attitude and the broader overview of the word bias, which is general conversation means and implies price or review. Because it is often not a very better proposition that has to be referred as for the separate and operation of the impact. The bias is actually managed to act from the reason so the cause of in case of bias of review, it means maybe an actual act conveying activity from the intent of that could be apparent or reasonably that could form part of the journey of the person. It's paragraph 12, 15 and 17.
Yes.
The disciplinary proceedings to prosecute the very most vigilance department. The inquiry was the officer or the chief of the vigilance department. He evidently based on the vigilance department with the view to straight to the directing officer who not have been appointed as an executive officer. From the evidence of another assistant engineer who has taken part in the training, it is evident that the only lost after the vigilance was applicable and here marginal evaluations are the information was made with the Commission of India to operate such a well. And on that basis, the neutrality of arbitrators, the arbitrators should be and what are below are 708 euros.
Yes. Yes.
Employee of the department are added at enforcement when the school court in India part of the real exception is situation when the arbitrator after concluding or authority in behalf of the subject contract or the fees it's subordinate as contracted from an officer of an inferior rank in some other department to the officer is issuing the subject matter of the dispute, and this exception must be the dispute court to enforce within so the appointed instrument application. At this stage of it would be incompetence to say that art economy and this is of this case in the past. There are certain meanings that are independent after argument, which is the process, regardless of the artist,
Yes.
Page 134.
Page
134. 58 and 30. Inquiry officer. 57, 28 and 30.
Yes.
This is so as to avoid the employee officer acted as a prosecutor as well as a judge. An Inquiry Act 28 and 30 of those.
Yes. Yes.
Recommendation being made by the officer to impose a particular paragraph. Paragraph 18 and 19.
Sir.
Actually, 4 repetitions, sir. Two repetitions, then we are, then the lordships are dealing.
ಇನ್ನೇನು ಅದೇ ತಾನೆ ಸೇಮ್ ಪ್ರಿನ್ಸಿಪಲ್.
Focus stand issue or they're being argued in other courts in a separate band. Argue ಮಾಡ್ಬೇಕಾದ್ರೆ separate ಆಗಿ.
ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಅದನ್ನ ಯಾಕೆ ಸಪರೇಟ್ ಆಗಿ ಬಿಡ್ಬೇಕು?
ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್
ಅದಕ್ಕೆ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ಗಳು ಕೇಳಬೇಕು.
ಕೊಡಿ, ಇನ್ನೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಮತ್ತೆ ಎಲ್ಲಾ ಕೋರ್ಟಲ್ಲೂ ಎರಡೆರಡು ಕೇಸ್ ಇದೆ. ಒಂದ್ಸರಿ ಕ್ಲಬ್ ಮಾಡಿ ಹಿಯರ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆನೂ ಇದೆ.
ಅದು ಮುಗಿಸ್ತೀನಿ, ನೀವು ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಕೊಳ್ತೀರ?
ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡೇ ಬೇಡ, ಇದ್ರ ಜೊತೆ ಲಿಂಕ್ ಮಾಡೋದು ಬೇಡ, ಅದು ಬೇರೆ ಹಿಯರ್ ಮಾಡಿ. ಈ ಕೇಸ್ ಇಸ್ ಆನ್ ಎ ಡಿಫರೆಂಟ್ ಇಶ್ಯೂ.
ಎರಡು ಕೇಸು.
If I may please your lordships.
ಯಾವತ್ ಮಾಡ್ತೀರಾ? ಯಾವತ್ ಮಾಡ್ತಾ?
After 1 week.
10 days.
After 10th.
Lordships kindly, my lord. 62.
If I may please your lordships in serial number 26.
Please wait.
I have
Please.
not sought for any interim order, my lord. Simple issue of payment, admitted payment by ESCOM. So it has come in the B group, my lord. That's why it's not reaching. I have not asked for any interim order. Maybe posted in preliminary hearing any date convenient, my lord. Sumana Naganand appears. It is only for payment. They have admitted the payment.
You appear in 62?
No, she is not. Sumana Naganand. Any date convenient to your lordships. Earliest date, because either, my lord, it's binary, my lord. Either they admit the payment and agree to pay, or they say, my lord, they don't.
I'll have it next week. Make a
I
mention.
appear for respondents, my lord.
Yes,
Sumana
you
Naganand.
Just that.
My lords, any other day? We have not filed a statement of objections, my lord.
When do you propose to file?
Kindly grant 3 weeks time.
3 weeks. Payment, admitted
Kindly
payment.
grant 3 weeks.
I'll have it next
2
week.
weeks,
Next
my
week.
lord. We'll file it.
File it
My
next
lords,
week.
2 weeks.
No, file it next week. It's a claim for money.
That's all.
Relist.
Wait. In the preliminary hearing list, my lord, they.
ಅಲ್ಲಿರುತ್ತೆ, ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ 4 ಮೇಲೆ ತಗೊಳ್ತೀನಿ ನಾನು.
Serial number 57, my lords. 57.
My lords, serial number
Excise matters, my lords.
I'll finish here and then get.
Kindly have this matter on any other day, my lords, other than Thursday, my lords. There is urgency in the matters, my lords.
Fifth.
Serial number 49, my lord, it was heard, my lord, only to hear the government advocate with regard to the repayment, my lord. 49.
Next Thursday ಹಾಕೊಳ್ತೀನಿ.
Serial number 63 also, my lords.
Date ಕೊಡ್ತಾರೆ.
Please, my lords.
Yes, madam.
Lordship, serial number. If I may,
Lord.
Which is your matter?
serial number 26, my lords, the same Lokayukta matter. I am appearing for R2 in one of the connected petition 19345, my lords.
Yes.
Here, the Lokayukta is the petitioner who has challenged the state government's order, my lords. Any date before 8th, if your lordship pleases, we will argue the matter, my lords.
11th is the date fixed.
My lord.
Can it be any other date after 11th, my lords? It's slightly inconvenient on that day, if I may.
They have to argue, let them argue, then let us see.
Please.
34, my lord. Interim order was not extended. I'm sorry. Just the date was urgent. I sought time in the morning. I'm so sorry. 34 connected. Idrally. Interim orders are operating in.
Interim order is automatic continue.
Lordship, serial number 66. There is an interim order, but that interim order is to grant a standing clearance honor before 29th of May. That was for that month of June. I plead that the direction may be extended for the future months also.
Sabha has made a statement.
Yes, Your Lordship. In that the interim order may not be extended to the next month, as the interim order was granted on the condition that we could, because the regulation did not permit us to do so. However, we have a regulation which clearly says that standing clearance should not be granted if they have not made payment towards the DSM charges, Your Lordship, for which we will have to argue the matter.
This is a matter that
This
requires a
DSM
hearing.
charges?
Deviation settlement charges, Your Lordship, in case they inject less or more as against what schedule they have given, we impose a certain DSM charge on them because it can be a threat to the grid security. So that payment has not been done by them, and the open access regulations clearly state that if you do not make any payment towards a DSM
How
charge,
much are the charges?
Your Lordships, there is a deficit of around 2 crores that they have not paid up until today. It's been long since they have not made payment, Your Lordship.
If I may make a submission, the condition for granting me the interim order was that I deposit 25% of this 1 crore 85 lakhs. I've done that also. It's on that basis that I got the
Your
interim order.
Lordship,
It's already
the
month
order
end.
was granted only because it was taken up and we did not file our objections even, and we could not
No,
showcase
but
the
it is not an
regulation,
un-
Your Lordship.
It is not an unconditional order. It is saying subject to payment of 25%.
Yes, Your Lordship, but currently we have the regulation which says that we cannot grant a standing clearance if they have not payment towards the DSM charges. On the
That is what is challenged here, isn't it?
Yes, Your Lordship.
So now there's an interim order, conditional interim order granted. To some, at least to certain extent, your grievances are
Yes,
safeguarded.
to some extent, Your Lordships, I leave it to Your Lordships, but if the matter may be had next week on whether they should be paying the DSM
There is no
charges or not.
limited interim order, isn't it? Is there a
It
limited?
is, it could be construed as limited, Your Lordships. It says that.
They're going to construe it as a limited interim order.
I'm at your hands, Your Lordships, may direct
No.
us to.
If you make a statement that you will not do anything, I will not pass any order. If you are saying that you are going to interpret this order, then I will pass an order.
Difficulty is this is month end. Monday is 1st of July. If you don't get
Your
the
Lordships,
clearance,
we
it's an
have to
issue.
give the clearance today. So depending on what if Your Lordships will pass an order.
My order will be depend on what you say.
Your Lordships will consider their prayer. We'll grant them the standing clearance. However, the determination of whether they should be paying us the DSM charges may be had next week itself, Your Lordships. That's all.
It is clarified that the petition shall be granted monthly clearance,
Standing clearance for the month.
standing clearance, even for the succeeding months,
Your Lordships
in
will
view of the fact that the petitioner has complied with the interim order by depositing 25% of rupees 1.85 crores.
I've already done
As
that.
ordered on 27/5/2020.
Your Lordships,
It's already been paid.
restrict the standing clearance to next month. Only we'll argue the matter next week, Your Lordships.
Let it be there. There's not going to be much of a relist on.
Hand delivery may be ordered for it.
She's here. Why do you want hand delivery?
Great.
Sir, 57, 58.
I think that's great order. But
He's not given a date, that's the thing.
ಅಲ್ಲ ಎರಡು ಮಾತ್ರ ರಿಸರ್ವ್ಡ್.
Sir, ಅದು
ಮೂರು ಫರ್ದರ್ ಕನ್ಸಿಡರೇಷನ್ 11th ನೀವು ಪಿಟಿಷನರ್ ಇರೋದು ಫರ್ದರ್ ಮೂರಿದೆ ಬಿ ಪಾಟೀಲ್.
And how much you have deposited? 1.25%.
ಥರ್ಸ್ಡೇ ಜಾಸ್ತಿ ಇದೆ, ರೀಚ್ ಆಗಲ್ಲ. ಫ್ರೈಡೇ ಕೊಟ್ಟಿದ್ವಿ ಎಲ್ಲ 5th ಕೊಟ್ಟಿದ್ವಿ. 63 ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇತ್ತಲ್ವಾ, ಇದೆ 11th ಹಾಕಿದ್ವಿ. ಜಾಸ್ತಿ ಇದೆ, ಎಲ್ಲ 30 ಇದೆ. ಬಿ ಗ್ರೂಪ್ 30 ಬಿ ಗ್ರೂಪ್ ಇದೆ, ಅದಕ್ಕೇನೆ ರೀಚ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಡಿವೈಡ್ ಮಾಡಿ.
90,850.
Fifth.
Dates when you want date, I'm not next week.
Date, Next week. Fifth.
Court officer.
But if it is there, it will be extended. If it is not there. ಅಲ್ಲ ಇದು 66 ಇದೆ. ಅವ್ರು 59 ಅಲ್ಲಿ ಇದೆ ಅಂತ. ಅವ್ರು 59 ಅಂತ. 66 now it was different.
Court officer.
I will check if it is there, it will be extended. Otherwise, it will be posted on 11th. If it,
Court officer.
ಹೇಳಿ sir.
Sir, serial number 76. What is the next date of hearing?
5th.
Court officer.
Check ಮಾಡ್ತೀನಿ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Sir, there is some inconvenience. Can we have it after 8th?
Then check ಮಾಡಿ. ಆಯ್ತು. 9, 6, 4, 6, 4.
Sir, serial number 62 ಯಾವ ಡೇಟಿಗೆ ಹೋಯ್ತು ಹೇಳ್ತೀರಾ ಪ್ಲೀಸ್?
60 to 5th ಗೆ ಮೇಡಮ್.
Okay sir, thank you.
Court officer, there is some inconvenience for 5th. Can we have it after 8th? Serial number 76, court officer.
ಕ್ಲಿಯರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೇನೆ. ಆಯ್ತು ಹೇಳ್ತೀನಿ ಬಿಡಿ. ಇದೆ ಪ್ರೀವಿಯಸ್ ಡೇಟ್ಸ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರ್ಲಿ ಹೇಳ್ತೀನಿ. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. It was not extended. Only on 15th April it was extended. After that, will be extended. Hello? Oh, 5th again. 11th. 35th again. 11th again. ಕೇಳಿದ್ರಲ್ವಾ?
Court officer. Court officer.
ಹೇಳಿ.
59, 61, 62 ಏನಾದ್ರು ಡೇಟ್ ಇದೆಯಾ ಸರ್?
59 11th ಗೆ, 61 3rd ಗೆ.
ಓಕೆ.
ಆಮೇಲೆ
62.
62 5th ಗೆ.
ಓಕೆ. ಫೈನ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.